So I'm not getting family pension, my lord.
When you file this writ petition?
15 days ago. Matter appearing in the list.
It is in the list. Yes.
My lord, kindly allow me to mention one matter. Today's list 298 item number. This is very urgent matter, my lord.
Yes. Speak. All speak.
Oh.
One is arguing, mentioning the matter.
I am praying at you.
19th को रखो urgent motion.
Grateful to Lord.
19th urgent motion.
Grateful to Lord.
Yes.
Your Lordship, may I be allowed to mention the matter to be included in your Lordship list under the heading motion? This matter was filed in September and till October it was in the list, but from November it's not in the list. So it's my humble prayer if you can include it in the list under the motion.
Urgent?
Under the motion, heading motion.
New motion में कर दो.
My lord, kindly allow me to speak item number 298 of today's list. This is very urgent matter. Half of my salary of my client has been deducted by his authority.
Yes.
Half of the salary of my client has been deducted every month illegally by his employer.
When it has started that recovery?
Recovery.
Which month the recovery has started?
Huh? June.
Not aware of that. Yes.
June. My lord, June. My lord, kindly hear.
Not aware of the fact here.
Yes.
I have your Lordship's kindly to mention item number 33 for inclusion, my lord. Lordship has already heard this matter on the 1st of December, my lord, and directed to appear at the top of the list in the judge motion on the 3rd. This is the electricity connection matter, my lord. Mr. Jishnu Chaudhary was appearing on the other side. LPSC charges he was arguing, my lord. We even filed a notes of argument before the coordinate bench. Very short issue, my lord. Any day convenient.
थर्ड में था, फिर कहाँ चले गया? लिस्ट में नहीं है. थर्ड में क्यों नहीं आया?
My lord, I cannot revive the industry that I have purchased through the IBC mechanism, my lord. If I cannot comply with the plan, the industry will be liquidated.
16 तारीख को करो. 16 को अर्जेंट मोशन में.
May I request 17th?
17th.
May I have your Lordship's kind leave to mention, Lordship, item 564 of today's list is appearing under the heading hearing. Lordship, just kindly take a look. This is a tender matter. Affidavit directions were given by virtue of an undertaking by the state recorded in paragraph 4 that they will not be taking any coercive steps. There was no decision at that point of time. Now, Lordship, post vacations, they have not filed their affidavits, and now we are under the clients have been told that the process for blacklisting is now being proceeded with them. Lordship, this way they cannot play both sides. Lordship, play hot and cold. Lordship, I was beseeching Lordship can keep this matter any day so that it can be heard out by Lords.
15 को to be mentioned में.
Lord's kind leave.
My lord, may I
I'm appearing online.
From the other side.
Quality service are also.
My lord,
may I?
My lord, I'm appearing
You are
online.
not aware of the fact.
I am
that
aware.
when you
in hurry, I was forgot to say told the month. May 2025.
May 2025, wait on June, December, 7 months, nothing has been happened. What is the urgency?
Appearing in the Justice Amrita Sinha's list. Justice Amrita Sinha fixed this matter, but unfortunately, determination has been changed. And
Yeah, that is unfortunate for you. Determination in change. What can be done?
kindly hear
Go to the Chief Justice. Why it has been? Why the determination has been changed? Unfortunately for you. Tell the Chief Justice why the unfortunately your determination has been given to me. Please make the submission what you have to make. It is unfortunately for you for changing of determination of the court.
Fixed in the Amrita.
Sorry, go to the appropriate court. Yes.
My lord, may
My Lord's kind leave, my Lord. I'm appearing online.
Sorry, I am not impressed upon your submission. Yes.
My lord, may I be permitted to mention? My lord, I'm praying for a leave. The petitioner is a senior citizen who is aged about 75 years old. Her son has frauded the document and sold the ration shop, which she has dependent. She didn't get a single penny of money from that, and she is an old aged woman, my lord, and she is suffering from multiple ailments. She has no source of income. So I'm humbly praying for leave for this urgent hearing, my lord.
What you have prayed for?
For urgent hearing, my lord, for the ration shop, which his son has taken a sold without her consent.
18th को रखो urgent motion. 18th.
And-
You want to file new one?
Yes, my lord.
Leave is granted to affirm the affidavit and be listed on 18th.
Much obliged, my
May I have your lordship?
Mulad, may I have Mulad's kind leave to
inclusion-
file an application?
Inclusion the writ petition before your lordship.
Inclusion, give the list. Whatever the inclusion, give the list to my court
my,
officer.
my lord. My lord,
Ma-
on
my lord,
last
can
week
you-
I
Lord-
have mentioned for one matter for upgradation, and you have told me to serve the notice to the other side. I have served. I've served to the other side, my lord. This is an electricity matter. The petitioner is not getting electricity from past 3 years, my lord. My lord, I've
Give
mentioned
the
this matter.
inclusion list to my court officer. Whatever who want the inclusion in the list, give to the list to my court officer.
Mulad's kind leave, Mulad, to mention one matter online.
Yes. Yes, just a minute. Yes.
My lord, I have come last week for the upgradation, this matter, and you have told me to serve to the other party. I have
Served?
served. Yes, my lord, I've served.
दे दो.
Much obliged, my lord.
Mulad's
15th.
kind leave to Mulad file an
15th,
application.
15th.
Mulad, I'm appearing online. Mulad, I'm appearing online. Mulad, may I have Mulad's kind leave to mention?
What is the urgency? Who has not paid? Why? Ah. Ah. So you have been engaged in the election duty and you have not been paid. That is a, ah. Who is the other side? One. Lil. 18th urgent motion.
Mulad, I'm appearing online. May I have Mulad's leave to file an application, Mulad?
Yes.
Lordship,
Yes.
498 of your lordship's list, lordship, that the meter of the petitioner has been unlawfully broken by the station manager of the WBACDPL because he refused to pay him the bribe to the tune of ₹50,000.
Go to the anti-corruption unit. Why you came here?
Lordship,
If there is a demand of the bribe, go to the anti-corruption. What the High Court will do?
they have disconnected the meter, and as a result, lordship, until and unless the electricity connection is not restored, he is not in a position to perform his agricultural work, lordship. This
Ah.
is the only source of bread and butter, lordship. This is the urgency, lordship. If you're not
When you file the writ application?
at least 15 days before, lordship.
19th karo. 19th urgent motion.
Lordship may be permitted to mention upon notice for non-prosecution.
What?
Non-prosecution.
That may be
Yes, Mr. Sir.
Please, you mentioned so that.
Well, both lordship heard the matter and direct the matter to appear at the top as urgent motion, but it has gone in the order as adjourned motion.
And
It has
which
come as
date?
a-
Which date?
Today it has come,
Today
but
it
as adjourned motion. So
Okay.
if you not call today,
Okay, if today not called, then tomorrow it will.
tomorrow it will be.
Please mention the matter at the time of rising. If it is not called, then you mention.
May be permitted to mention
My lord, may I have
claim for extension of interim order which is due to expire on 19th December, my lord.
19 December. एक काम करो. 18th December को उसको रखो. To be mentioned extension of interim order.
My lord, may I be permitted to mention a matter for petition? The matter is running as item number 360 in your lordship's list. My lord, it's a very short matter. The petitioner participated in a tender. A work order was given. He completed his work. My lord, the claim of the petitioner is admitted. He was given completion certificate. Now, for the last 2 years, the claim of the petitioner has not been disbursed only on the ground of paucity of the fund of the state government. My lord, kindly.
What is the urgency?
My lord,
You
the matter
wait
is
so
pending for the last 2 years, my lord.
22 तारीख को रखो.
Deeply obliged.
Your lordship, may I seek leave to mention a matter? Your lordship.
Regarding item number 266 and 270, even identical matter. This today's this one. I am paying for argument or early hearing, my lord.
Why? What is the urgency?
So because of the matter relating to the cancellation of caste certificate, my
Huh?
cancellation of caste certificate.
Ah,
I have filed this application, the process of the caste certificate.
ah.
It was filed in the year 2024, my lord. But they have stopped after filing this suit.
Ah.
But 19 is fixed for hearing, my lord. Only taken up.
19th is fixed for hearing before where?
SDO, my lord.
So what you prayed before this court?
Upgradation, my.
What you have prayed once a hearing is before the appropriate authority.
That process has been bad in law. Due to my lord, BDO has inquired into the matter. BDO has no power
Ah.
to inquire into the matter.
So who will inquire?
Inquire with the subdivisional officer.
Ah.
Himself or vigilance officer.
ठीक है उसको 18 करो.
Your Lordship,
My
may I
lord,
seek
kind leave to
mention
file
a
an
matter?
application, my lord.
Your Lordship, I am
Lord.
for the petitioner, Your Lordship. Your Lordship, there is a typographical error in the writ petition, Your Lordship. So, Your Lordship, the petitioner is praying to file the fresh petition, Your Lordship, with the liberty of.
Where is your writ petition?
Lordship, it's already
in the list.
Yes, Your Lordship.
Which number?
So, it is not, Your Lordship, it is not today in the list, Your Lordship. We have filed, Your Lordship, the writ petition, but there is a typographical error, Your
What is the
Lordship.
typographical error? So it is not in the list. What you prayed for here?
Inclusion, Your Lordship, inclusion.
Inclusion, give it.
Well, under compelling circumstances, my lord, I am mentioning from your lordship.
Grateful.
Lord, 76. Your lordship had this matter on 17th, Lord. Lord, Mela, urgency is due, Lord. Completion certificate has given. Lord, more than 60 lakhs have been due, my lord. Petitioner wife is suffering from cruel disease, Lord, in a cancer.
Come in the month of January.
Lordship, kindly, Lordship,
My lord, kind leave, my lord, to file an application, my
Where
lord.
is the now? Where is the number?
Adjourn motion 76, my lord.
76 urgent motion 23 को रखो.
My lord, may we
Urgent motion में 23 को urgent motion में रखो.
My lord, may you permit to mention item number 403 of today's. 403 of today's, my lord. It is a homeopathy medical college and hospital. The operation of the homeopathy medical college has been installed by the bank authority for not allowing to operate the bank account of the homeopathy medical college and hospital, my lord. So, my lord, this application is filed, my lord. Kindly.
It is the hospital account.
Yes, yes.
Account of the hospital.
Yes.
So it has been freezed.
Yes, my lord.
Who?
By the bank authority, respondent to bank authorities, my lord.
Why?
My lord, there is the internal allegation and some of the members.
Who has directed the bank to freeze?
My lord, bank on the request of single letter, my lord, operation has been stopped, my lord. The operation of the hospital and college, my lord.
उसको 22 तारीख को रखो.
403, lord.
Well,
My lord, may I pass it?
electricity matter.
22 तारीख.
403. My lord, may I pass it? My lord, last.
Upgradation, my lord, without electricity, my lord, disconnection has been made.
When the disconnection was made?
Last 10 days ago.
10 days ago.
We are trying.
My lord, may I permit? My lord,
We'll let you wait for the 10
my
days.
lord, last question.
I am without electricity and we are suffering, my lord. Let it be any day of this week. Any day.
23.
May I permit, my lord? Last
my lord, may I
occasion,
be
my lord.
permitted to-
Last occasion, my lord, I mentioned the matter and my lord, the direction is make the serve the notice and Friday we serve the notice to the respondent and my lord, today's list item number 384, my lord, for upgradation, my lord.
What is the matter? What is the urgency?
Regarding Mahatma Gandhi National Rural Employment Guarantee, my lord, the labor get the payment and the builder did not get the payment till 2023, my lord.
Till 23.
Yes,
So
ma'am.
now we are 25. You have waited for the 2 years. Let you wait for
Very long time the matter in the under the heading of new motion and item number 384, my lord. That's
What
the reason
can
I
be done?
for upgradation, my lord.
23 को करो उसको. 23.
my lord, may I be permitted to
Excellent, my lord.
seek
Yes.
leave and file? My lord, may I be permitted to seek leave and file an application, my lord?
ये
I'm
वीडियो बंद
appealing
करो.
online.
वीडियो बंद करो.
Lordship, petitioner has participated in the e-auction in the month of January, Lordship. Then he have purchased 2 plots there. But till date, respondent authority has not issued the sale certificate, nor yet refunded the amount. For that reason, petitioner is suffering financial losses in business and they are several times have prayed before the...
Put on 20 seconds.
My lord, may I permit to mention
20 seconds. Urgent motion.
non-prosecution upon
Huh?
non-prosecution upon Kindly, my lord, to be mentioned.
He wants to terminate the LIC bond, my lord. Petitioner is seriously ill, my lord, for kidney disease. My lord, he wants to terminate the LIC.
Who want to terminate the LIC? So why the LIC is not allowing you to take the LIC amount? Why?
He needs more.
23 को रखो.
May I be permitted to mention, my lord?
23 urgent motion.
My lord, may I be permitted to mention, my lord, item number 462 of today's list, my lord, this is, my lord, earlier petitioner enjoyed connection from his landlord disconnected. I applied for connection, my lord, my business is running without electricity, my lord, kindly consider that. And
When it was disconnected.
my lord, disconnected in the month of November. I applied for new connection in the month of November this year. My lord, read petition filed in the
So come after
no, 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 17 November, business has been disrupted. Kindly consider.
done.
No, my lord, kindly.
24th January.
May I be permitted to mention, my lord?
24th December urgent
My
motion.
lord, for inclusion.
When is going to be
Expiring also this
Huh?
Friday, this Friday, your lordship, 13th, on 13th. is it?
13th?
Yes, sir.
13th is the Saturday.
Sorry, 12th, your lordship.
12th.
Yes, sir.
11 तारीख को रखो.
May I be
To be
permitted to
mentioned
mention?
extension of entry mode.
Lordship, may I be permitted to mention one electricity matter? What has happened, Lordship? Petitioner has filed one writ petition against the CSC authority for raising of arbitrary bills, Lordship. What has happened during pendency of the writ petition? They have disconnected my electricity connection, Lordship. Lordship, I have challenged, also I have filed before the GRO. GRO has not taken any steps. Thereafter writ petition, during pendency, they have disconnected my electricity connection.
23.
My lord,
Great,
may
sir.
I be permitted to mention
Lordship,
item
urgent
number
motion.
400
Great.
of today's list, my lord. The urgency is this, my lord. This is challenging the order of cancellation of scheduled tribe certificate, my lord. My lord, the petitioners are facing difficulties because petitioner number 2 is in service. Two other minor, they are studying, my lord. Your lordship may kindly take it up.
So what is the difficulty?
My lord, it has been cancelled, my lord. Scheduled tribe
Cancelled certificate is cancelled. Okay,
Cancelled.
no problem. Then
My lord, petitioner number 2 is in service. There he will face the difficulties, my lord.
have the authority issued the so cause for termination of your service because of the certificate is cancelled.
Not
Then
not
what
as
is
yet,
the
but my lord, lordship
once
may
you receive the
Lordship,
so cause
lordship may kindly take it
Yes.
up, my lord.
May I be permitted to?
My lord, one matter upon notice to the other side. My lord, what has happened? My lord, apply for new connection, paid a hefty sum of money during pendency of the proceedings. My lord, still date no connection. Now the police authorities, on the instigation of the landowners, my lord, now initiating proceedings against me since there is no electricity as of yet, my lord.
what proceeding initiated by the
I am the developer of the building.
Ah.
I am yet to get. I applied. I paid. Everything is done.
Hmm.
It's only for new connection, my lord. They have not yet given me new connection due to a pendency of the suit.
Hmm.
Now the police authorities, on the instigation of the flat owners, are initiating proceedings. Even me as a counsel, my lord, had to receive phone calls from the police.
23 तारीख को रखो.
May I be permitted to mention about that?
Yes.
Lord, I'm praying to file on urgent writ petition, my lord. The urgency is that, my lord, the Kia India Limited had supplied one car. I purchased one car from the Kia India Limited, and which has been delivered with manufacturing defect. My lord, I am seeking direction, my lord, that Automotive Research Association of India, because that has.
Go to the consumers forum. Yes.
Sir,
My lord, my lord, for inclusion, my for inclusion, my.
My lord, the lordship, may I be permitted to mention that matter for upgradation? The matter concerns Merlin Group, a real estate developer, who is selling the residential units, promoting the residential without proper registration certificate. So this is a serious risk that possess, and I want the court's intervention to just
What order you want from the court?
to
What is your prayer before this
so
court
they
in the
are
writ?
selling of the residential units
Yes.
without getting the registration certificate.
Yes, call the list.
My lord, may I permit to mention?
Permitted to mention in a matter, this is for appointment of officer of district child protection unit. And in that matter, earlier first round litigation was moved before this court, that has been disposed of by an order dated 6th August 2025. As the mass of the
What you want, sir? I don't want all
new
these.
motion, let it be listed.
New motion, I already told. Whatever the new motion, give to
My
the
lord,
officers.
my lord, my lord, this is a tender matter, my lord. Work order is in complete, my lord, and due bill not paid, my lord. My lord,
Come to
my
my
lord,
chamber, I will issue the check to you.
my lord, only inclusion, my lord.
My lord,
That water body filling up Ukilbedi, my lord had fixed it on 17th. Now, my lord, in your lordship's order of 11th November, your lordship had directed all the other respondents to positively file their affidavit by end of November. No affidavits have come. Reply is complete. My lord, kindly see they are totally withdrawing the water and making it dry. My lord, I am saying only preponement. Instead of 17th, any day this week.
17 is fixed, no?
Yes, my lord. But my lord, kindly see they are totally changing the nature and character. I know, and we have.
वो matter कल to be mention में रखो, issue
Yes,
the
yes.
notice.
May I be permitted
Well,
to mention, my lord?
कल to be mention में
To be
रखो, issue the notice to the other side. Let they come, then we'll
Yes.
see.
My lord,
My lord.
the last week, my lord, at the time of mentioning, your lordship was pleased to fix the matter on 18th of this month, my lord. But my lord, the date mentioned in the presentation form has expired, my lord, and for this reason, my lord, the government leader has refused to accept the service, my lord. And my lord, if your lordship kindly passes an order, my lord, to this effect, my lord, then
Serve the notice to the department. Why you giving to the government PIT if they are not?
the department is also saying so, my lord.
Okay, so we'll see
My lord.
that. You file an affidavit. You file an affidavit to that effect.
My lord.
Yeah, वो online में कौन सा खोलो?
My lord. My lord, this is grant of license, my lord, regarding selling of mother dairy products. He is not handing over the shop, my lord.
Who? Go to the civil court. What the writ court will do? Not
My-
handing over the shop. What the writ court will do? Go to the civil suit. Obtain an injunction order. What the civil writ court will do, madam? Yes.
My lord, I am playing apology. My lord,
Madam, sir, you are not aware of the facts.
Yes, I am aware.
What you are aware?
In a hurry, I was forgot to say till the month. Then May 2025. My lord, kindly give it on to be mentioned.
22 तारीख को रखो उसको urgent motion.
Your Lordship, may I be permitted to mention item number 366 of today's list for updates on the matter relating to electricity, Your Lordship. It is disconnected sometimes in July 2025, and the matter was taken up by His Lordship, the Honorable Justice Kaushik Chandra, sometimes in October, and matter was listed on 10th of November, Your Lordship. Thereafter, the determination has changed. Your Lordship, kindly.
Where is the 23 तारीख को रखो?
Grateful.
Yes.
Your Lordship, may I be permitted to mention one matter? Your Lordship, the item number 268 of this today's cause list, Your Lordship, the matter relates to premature release, Your Lordship. The accused is in jail for more than 30 years, Your Lordship. Your Lordship, kindly fix the matter for hearing, Your Lordship.
Matters are fixed. I think so. I don't know where. There are 4 matters fixed. वो jail matters कब रखा है? तुमको तो कुछ पता नहीं होगा. Jail matters रखा है ना? Premature release का. Which date? You're not aware. ठीक उसको 22 को रखो.
Grateful, Your Lordship. Item number 268.
Yes, call the list.
Please see.
For what?
My lord, this matter is of 2024, my lord.
Huh?
This matter, this petition is of 2000.
Use the microphone.
This writ petition, this writ petition is of 2024, my lord, related to Senior Citizen Act, my lord. The old lady, my lord, was outstated by her son from her husband's house, my lord.
And 23 तारीख को रखो.
Much obliged, my lord.
Yes, call the.
Item number 1, I am. Lordship, item number 1, I am for the petitioner. Lordship, I want to non-prosecution. Lordship, this is the instruction of.
The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. An advocate appearing for the petition has handed over a communication dated December 2025, wherein the petitioner has informed the advocate that the petitioner do not intend to continue with the instant writ application and requested the advocate to withdraw the writ application. In view of the communication dated 3rd December 2025, the petitioner and learned counsel appearing for the petitioner place for withdrawal of the writ petition. In view of the submission made by the counsel for the petitioner and the communication dated 3rd December 2025, WPA number 25373 of 2024 is dismissed as withdrawn. Interim order if any stand vacated. Communication dated 3rd December 2025 be kept with the record.
Good.
Next.
Your Lordship, I'm appearing on behalf of the petitioner. The file was previously not traceable. We mentioned the matter, and now today the matter has appeared. So, Your Honor, Your Lordship, first of all, I'm filing the affidavit of service. It has been already delivered to the CSC authority and to
I
the
appearing for CSC Limited, my lord.
Your Lordship, the petitioner is actually a land tenant in regards to the property situated at P233 Upan Banerjee Road at PS Purnashree. Your Lordship, he has been paying the rents without any demur. There is a suit pending before the learned 5th Civil Judge Junior Division Alipur, wherein he is paying the rents as per the court's direction, and the matter has not been disposed of as of now. Your Lordship,
For the tenant.
Yes, Your Lordship. Your Lordship, the issue is that the electricity has been disconnected in the year 2015. Till today, the electricity is not there, which is the basic amenity. He has been staying there with his family, with his minor children, without the electricity, Your Lordship. Therefore, you're praying Your Lordship to kindly issue a direction upon the CSC so that they restore the electricity in the tenanted portion. Because he does not have sufficient means. He sells vegetable to earn his livelihood. It will not be possible for him to make a new meter board in some other area. Meter box board. Your Lordship also praying to kindly issue a direction upon the Purnashree concerned police station to kindly assist during such restoration. However, Lordship, if you may also ask them to not ask any or maybe minimal charges, probably 1,000 or 2,000, because he is a vegetable seller, Your Lordship. He will not be able to pay any money more than that, Your Lordship.
My lord.
Yes.
My lord, my instruction, my lord, it is a Basti area, my lord. My instruction says that it's approximately 8 katha piece of land, my lord. There are 2 hutments with total 7 rooms, and presently there are 3 tenants. One of them is a writ petitioner in item number 2, and the other is item number 3, my lord. So, my lord, there are presently 3 tenants. The 2 has applied, and other has not yet applied, and it's a Basti area. So, my lord, as per the provisions of the regulations, my lord, the regulation, my lord, is. Well, may I give the name of the regulation? This is West Bengal Electricity Regulatory Commission, Recovery of Expenditure for Providing New Connection Regulations 2013, Regulation 18, my lord. It says, my lord, in Basti,
Which regulation you are referring?
My lord, this is Recovery of Expenditure, my lord. Recovery of Expenditure for Providing New Connection Regulations 2013. My lord, I'm tender my apology. I could not be present physically. But if your lordship grants me time, my lord, I can appear before the lordship any day and provide a copy of the regulations, my lord.
It is there. Which regulation you have? Which?
Also, my lord, it's regulation 18, my lord. 2013 regulations, recovery of expenditure for providing new connections.
Regulation 18.
Regulation 18, my lord.
Yes, installation of block meter.
Block meters. Yes, my lord. In
Yes.
busties, markets, etc., where it may not be possible to segregate one consumer from an adjacent consumer because of existence of a very large number of consumers in a relatively small premises, and where because of multiplicity of the wirings of such a large number of consumers, there may be fire and safety hazards, the licensee may effect supply of electricity to all the consumers or intending consumers through a suitably located common meter of adequate capacity to be known as a block meter. So, my lord, my instruction, it's a Basti area, and at present there is no service in the premises. So, we can install one block meter from which, my lord, the other tenants also, if they apply in future, they will be able to get supply. That is my instruction. Earlier, my lord, my instruction.
So the item number 3 also you are appearing?
Yes, your lordship.
So there are 2 persons are there. So you apply, install the block meter.
My lord, we are ready to install a block meter from which both the petitioners will get supply.
Your lordship, the only condition is that they sell vegetable to earn their livelihood. If this includes a huge cost, they will not be able to incur the same. That is the only issue.
You have to bear the expenditure. Who will bear the
that
expenditure
we
for
cannot-
your electricity? And state will not.
Definitely, your lordship. But just asking your lordship to make it minimal so that they can afford
What
it.
minimal? What is the charges you have to pay? They are not asking for any high rent, whatever it is.
Whatever is the
you have to pay.
Your lordship,
whatever is in the
previously the
regulations,
tenanted
will
portion
be
only
charging.
they were meter box there. Now they are saying that they need a different meter board to be established in some nearby area. Previously, it was in the tenanted portion of these 3 different
Okay,
tenants.
then let you file this inspection. You inspect the premises and file the report.
Well,
madam.
we have conducted inspection 25th of November. This is my latest inspection report.
Where is the inspection report? Have you
My lord,
submitted?
it is with no, my lord. It is with me. If your lordship keeps it tomorrow or day after tomorrow, I'll supply it to your lordship, my lord.
Day after tomorrow, let us file the report.
Much
My-
obliged, lordship.
My lord,
As
grateful.
prayer made by the counsel for the respondent, case is set down. Let the matter appear on 11th December under the same heading for filing
Grateful, my lord.
authority.
Grateful, my
Yes. Same.
Do your thing same.
Next for
But I am for the petitioner in this matter that
My lord,
jaggery and molasses issue.
my lord, petitioner prayed for before the file application before the landed court below, my lord, landed ACJ Malda with the same ACJ Arambagh.
But what I tell you, Lordship, is this.
My lord,
What
kindly
it-
look at that,
what-
my lord.
what-
And the prayer
Prayer means, well, here is a prayer for quashing. Certiorari issue prayer has been made. Mandamus also has been prayed, declaring that the entire proceeding is absolutely without jurisdiction. Malad, so far as the goods are concerned, Malad, according to our jaggery and the track is concerned, Malad, the Supreme Court in the case of Sundar Bhai Ambara's case, Malad, has said I can approach the magistrate for the purpose of release of the goods. That judgment.
To the order, my lord,
Why you are interrupting? Let me complete.
In here praying for my lord, hence the accusation for the final bail, my lord.
Bail has been granted.
My lord, judicial custody petitioner Emily Arijit De and Monojit De, who is the owner of the Day Enterprise, my lord, is filed a petition praying for the return of the seized vehicle and the
Yes, that we can do.
So what you want, sir? What you want?
My lord, they are praying same.
Yes, they are praying. I am not entertaining. That's why on the last occasion, the court case, last occasion you are there, not there. That's why every time change, the state is changing the advocate.
No, my lord, my learned senior, I am assisting him, my lord.
You are not aware what has happened on the last date.
My lord,
yes.
Mala, so far as the merit of the writ petition is concerned, question of molasses, the report has been given by the state government. According to us, Mala, it suffers from various infirmities because the direction or the guideline given by the state itself has not been complied with.
Correct.
That is a matter to be finally heard by your lordship. I am not on that. So far as the petition is concerned, Malad, we are also wanting it to be tested before the Bose Institute, the scientific authority, because there are two conflicting reports. One is IFB. YFB is an established organization where they are taking reports in other matters also, in my matter also. On the same day, another matter where the report was come in there against them, Malad, that has already been released.
Okay.
So far as I am,
what you want now?
I am praying this, Malad, so far as the release part is concerned, that is there, Malad, we are going there in value of judgment. Let the matter appear after vacation.
For what?
For the purpose of deciding whether it should be quashed or not.
This court will not go into the criminal court. You go to the other court. How this court will decide with regard to the quashing? This is not a criminal bench.
No. On the issue, whether the declaration.
Maybe the criminal case has been initiated.
I am not on criminal case. Initiation of the proceeding without without jurisdiction.
Given rise to the initiation.
That molasses control order does not apply here. Lordship, can you look at the order itself?
Petitioner has filed the present application.
This control order has no application because it is not a molasses.
Saying for release of the vehicle being number WB 41K 3352 loaded with the alleged jaggery dated on 15th of September 2025. Police stop. Counsel for the petition submit that there are two contrary reports of the
scientific lab.
Two contrary report of the scientific lab, in which in one report it is mentioned that the alleged materials are not molasses, and another report reveals that the alleged materials loaded in the truck are the molasses. Full stop. Learned counsel for the state submit that the who has initiated the criminal case?
My lord,
already a criminal case has been initiated before the London ACJM Arambagh, being CR number 179 of 2025.
The officer in charge
wherein the petitioner,
by the excise circuit.
petitioner has filed an application for release of the vehicle, and the London magistrate has called for the report from the concerned authority with regard to the release of the vehicle. Considering the above, this court finds that the concerned authorities have already initiated a criminal case and the petitioner has approached the London magistrate for release of the vehicle. Thus, Thus, the writ application filed by the petitioner is not maintainable. Accordingly, same is dismissed.
And my lord, in the last occasion, my lord, my learned senior name is my lord Tanmay Chakraborty instead of the Tanmay
Call the other matter.
But one more prayer I am making to your lordship. Lordship has already held this. So far as the identity of the goods are concerned, that is according to the molasses control order. If it is not a molasses, the initiation itself is void ab initio.
You challenge that before the
But all points be kept open, lordship.
But this court has dismissed the writ application only on the issue that the petitioner has made an application for release of the vehicle before the magistrate, and this court has not gone into the merit of the matter. The petitioner has a liberty to take all the points before the London magistrate, before the appropriate court when the occasion arises.
Great.
Item number 6.
Item number 6, Your Lordship, I am for the petitioner.
Yes.
Yes. Yesterday, Your Lordship, I placed the matter that basically, Your Lordship, is for providing services. And Your Lordship, the NIT, Your Lordship, was floated by the Southeastern Railways, and thereafter, Your Lordship, we participated in that NIT, and we had been, Your Lordship, declared as a successful bidder.
Yes, Mukesh, any matter?
My lord, I am, my lord, item 8, my lord, it is, I'll come back, my lord. The court
Yeah,
of
if you-
law.
20 minutes more.
I'll come back.
So I have been declared, Your Lordship, as a successful bidder. And thereafter, Your Lordship, the LOA has been issued. I have just indicated, Your Lordship, that is a specific, Your Lordship, tenure of that particular LOA.
Yes.
And I have also indicated, Your Lordship, and in the technical bid, Your Lordship, I had to mention, Your Lordship, the key personals and other personals. I have given, Your Lordship, those particular details of the key personals and other personals. The Southeastern Railways, Your Lordship, was satisfied that these are the qualified persons. They allowed me. And Your Lordship, I crossed the technical bid, I crossed the financial bid, and finally the LOA has been issued in my favor. As per the LOA, within the particular period of time, Your Lordship, I have already submitted the performance bank guarantee. So it was, Your Lordship, as per the, Your Lordship, the tender clauses and Your Lordship, the RFPs clauses. Now, when Your Lordship, had been declared as a successful bidder, there is a substitution clause. Yesterday, I have shown before the Honorable Court that I am entitled for the substitution for, Your Lordship, the 50%. And if it is not beyond 50%, then in that case, Your Lordship, I had to, my remuneration or my fees or my charges will be deducted. I have also shown, Your Lordship, the various pages where time to time, Your Lordship, I was applying for the approval of those particular substitutions, and where they were sitting tight, and finally they had given me a reply that if you want the substitution, first you have to take approval under clause 3.8. So that till that particular thing was very clear. Subsequently, also I was giving the approvals. They were not giving me the approvals. And Your Lordship, I have also shown that the key personnel, Your Lordship, was appointed sometime, Your Lordship, on 28th February 2025. Your Lordship, kindly sees, Your Lordship, page 444. Yes. Lordship, that is very important because last occasion, Your Lordship, that was the main document, 28th February 2025, where Mr. Neeraj Choksi was deployed as a key personnel, as a team leader. Now, after the appointment, Your Lordship, again, Your Lordship, on 2 occasions, I applied for, Your Lordship, the substitution.
What
But
has happened to this?
Now,
28 February 2025.
28th February, they were not giving me the approvals. I have indicated, Your Lordship, the key personnel has been appointed. It has been deployed.
This Neeraj, this
Choksi.
Choksi.
Yes, he has gone to Ranchi, and Lordship, he has taken the charge, and he was there. Thereafter, Your Lordship, I had to, Your Lordship, engage the other personals because he alone as a team leader cannot work. So on 2 occasions, I again applied for, that is 1st March 2025 and 4th April 2025. Annexure P14, if Your Lordship kindly take page number 1. Just after 444. Lordship, kindly take page 446.
Yes. Appointment of principal.
On 1st March 2025, Your Lordship, I have again given, Your Lordship, the names of the original candidates and the proposed candidates.
Yes.
Now, apart from that, Your Lordship, again, page 449 is also important. 1st March, then 4th April, Your Lordship, I have also given Your Lordship regarding the substitution. I have given the name of the original one as well as the proposed one. That was 4th April 2025.
So how many persons you wanted to substitute?
Lordship, time to time, Your Lordship, apart from the team leader, I had to, Your Lordship, give all the persons because LOA was issued long back. The LOA, Your Lordship, was issued in my favor
That is July
on 26 July 2024.
Correct.
The agreement signed, Lordship, they subsequently agreement signed on 26 December 2024. During that particular period of time, because I had to apply, Your Lordship, even the substitution of Mr. Neeraj Choksi. But they were saying first you appoint the key personnel, team leader, then we will consider. That is, Your Lordship, they referred, Your Lordship, clause number 3.8. So I finally appointed, Your Lordship, Mr. Neeraj Choksi, Your Lordship, as a team leader. Thereafter, again, I applied for the substitution. The most important thing, if Lordship kindly take once, page 79, Your Lordship, of the RFP, which says, Your Lordship, deals with, Your Lordship, the termination. Page 79. Volume 1.
Yes. Yes.
Page 79, Your Lordship, clause number 6 deals with termination. Now, 6.1. Without prejudice to the succeeding provision of this clause, the agreement shall stand terminated after the project supervision service agency had rendered all the service to the satisfaction of the authority and the same are accepted by the authority.
Yes.
If it is completed. Now, 6.2. The authority may, by giving notice in writing, immediately terminate this agreement if the project supervision services or any project supervision agency's personnel. 6.2.1. Breach of the terms of the agreement which, in case of breach capable of being remedied, is not remedied by the project supervision services agencies within 10 days of the receipt of the notice from the authority specifying the breach and requiring its remedy. So therefore, the precondition is the 10 days notice. Now, Your Lordship, kindly, Lordship, I have given Your Lordship the entire facts that, Your Lordship, the substitution was for pending for approval.
Yes.
Now, suddenly, Your Lordship, they have given me that notice of remedial. Lordship, kindly take that notice that is at page 450. Volume number 3. Page 450.
Yes.
Now, this letter was issued, Your Lordship, on 11th April 2025. Yes. Now, Your Lordship, kindly sees this continuation to the above contract agreement in reference number such and such, LOA number such and such, dated 26th of July 2024, has been issued to you. Reference to the subject work till a completion period of 24 months. Thereafter, signing of the agreement was also concluded on 26th of December 2024. Consequently, multiple communications with a reference number 224 has been sent to you, instructing deployment of key personnel as proposed by you as per your bid. But till that, you have failed to deploy even a single key personnel or any other manpower, as is evident from the letter dated 3rd of April 2025, and already more than 8 months period has elapsed. This renders of breach of the terms as set out in clause 3.11.1, 3.112, 4.3 of the schedule of the agreement, 3.8.1 of the RFP, including the entire conditions and objective of annexures terms of reference. Hence, you are hereby served 10 days notice period in accordance with clause 6, with special emphasis to clause number 6.2.1, 6.2.5 and 6.2.6 of the contract agreement under schedule 1 form of the agreement for taking remedial measures, failing which the issue will be dealt according to clause 2.14 and specific implications of clause number 2, 2.1, 1.14.3, 1.14.4, 15.4, including forfeiting of the bank guarantee or performance guarantee of the RFP and the termination of the contract without any claim whatsoever. So my contention, your Lordship, is once you are sitting tight over the approval How can I remedy it?
So what has happened after this?
Thereafter, I gave your lordship the representations that this is the situation. If lordship kindly take your lordship my representation, that is your lordship 23rd April 2025 at page 452.
So then termination.
Yes, your lordship. Just yes. Thereafter, your lordship, they have terminated my.
Where is the termination?
Yes, your lordship. I am showing your lordship the termination notice. That is at page 454.
Yes.
And if your lordship kindly sees page 452, I have your lordship referred all my earlier requests for approvals, and I was requesting kindly your lordship substitute these particular people, and I've given the CVs so that they can evaluate and at least give me a final order that these particular persons are qualified or disqualified. Now, suddenly 454 on 3rd of June 2025, they were given me a termination notice saying that I have committed breach. Lordship kindly sees page 455. Initially, your lordship, they have given your lordship that regarding the delays. Now, 455, if your lordship kindly sees, paragraph 4.
Yes.
And whereas subsequently, multiple communications as mentioned in reference 3 to 11 had been issued from Deputy CEA Ranchi and Office of the CE directing them to deploy requisite key personnel, including team leader. Considering in this regard is drawn to the agency's letter dated 28th February 2025 and 23rd April 2025 above, whereby in response to the undersigned instruction for deployment of key personnel on immediate basis, Ellen Malviya Infrastructure has confirmed reporting the team leader on 28th of February 2025, 7 months after the date of the LOA, but subsequently was unavailable from 29th February 2025 as confirmed by such and such dated 22nd of April, pursuant to the remaining key personnel to join their assignments, including the team leader, as submitted RFP. Consequent to all above, it is evident that the agency has failed to fulfill the requirement of the contract stipulated, which is also evident from their own statement issued through letter dated such and such dated 23rd April 2025, even after lapse of 9 months, that is more than 180 days, which constitutes to breach of the terms of the contract as per clause 6.2.1, guilty of delay in commencement of the work or delay in performance of its contractual obligation with a clause number 6.2.6. The authority hereby was forced to issue 10 days notice on 11th April 2025 in accordance with clause 6 with special emphasis on clause number 6.2.1 and 6.2.6 of the contract agreement under schedule 1 form of the agreement for taking remedial measures, failing which the issue will have to be dealt according to clause 2.114 and specific implication of clause 2.14.1 4 and 2.15.4 withdrawal of LOA, including forfeiting of the bid security or performing security of the RFP and termination of the contract agreement without claim whatsoever according to the bid security and performance security submitted by you shall be forfeited on encashed. And thereafter, your lordship, they have terminated. Yes. And after that, your lordship, immediately on the next date, that is at page 457, on 4th of June 2025, third they terminated, fourth, your lordship, they encashed the bank guarantee. Yes. Now today, your lordship, why I am before your lordship for?
What the writ could do now?
Yes, I knew your lordship, this particular question will come to me that 4th June it has been done. Why today we have filed the writ petition? Kindly come, your lordship, page 161. No, your lordship, it's not page 97. No, your lordship, kindly take page 130. 130, your lordship, volume 1.
Yes.
Lordship, this is a part of the technical bid, and this is a form which I have to sign. Now, Lordship, kindly take the last one, clause number 1.6. For the bidder in case of consortium, state the following information. One is not applicable to me, kindly take 2. Has the bidder or any member in case of consortium has been penalized by any organization for poor quality of work or breach of contract in the last 5 years? Now, Your Lordship, kindly see the answer. Page 131. Note. If answer to any of the questions to 2 to 5 is yes, the bidder is not eligible forthwith, not eligible for this PSSA. So therefore, today, Your Lordship, they had alleged breach of, Your Lordship, the terms and conditions and terminated me. So in any future PSSA, I am not entitled to eligible even to participate.
If an answer of any of the question at 2
to 5 is yes.
Yes, the bidder is not eligible. PSSA means?
PSSA, Your Lordship, is Project Supervision Services Agency. That's my business. Project Supervision Services Agency.
Okay.
So therefore, in future contracts in connection with the railways, I am not eligible.
Whether you challenge this clause?
No, this clause, Your Lordship, is there. So in every, Your Lordship, contract of the central government or the state government, either, Your Lordship, is the ineligibility clause is there, and as Your Lordship yesterday asked me whether there is a specific clause for blacklisting. The blacklisting, Your Lordship, is also, Your Lordship, there in that particular clause number 4, page 131. So blacklisting means I cannot participate in this particular tender or for any other, Your Lordship, central government. Your Lordship, kindly see page 131, clause number 4. Has the bidder or any member of the consortium been blacklisted by any government department, public sector undertaking in the last 5 years, and such blacklisting exists on bid due date? Now, Your Lordship, if Your Lordship today prima facie I have shown Your Lordship that the termination, Your Lordship, is prima facie bad in law. The reason is very simple. When you have given me the letter of 10 days to remedy, Your Lordship, the defects, the first precondition is you have to first either approve the substitution or reject the substitution. But you are sitting tight, you are not either accepting it or rejecting it, and you are telling me to remedy, Your Lordship, the breach. That's the, Your Lordship, the violation of the principles of natural justice. That's my humble submission before the court. The 2 prayers today I am seeking for, if Your Lordship kindly consider. First, Your Lordship, kindly stay the termination notice to the extent. I'm not asking for specific, just the orders in nature of specific performance today. I am saying the termination notice will not debar me for participating any future tender as PSSA issued by the railways or any other authority.
How it can be in the part? Because no, I don't think, because when you file the writ application.
The writ application, Your Lordship, has been filed, Your Lordship, in this month only.
Number only.
Yes, Your Lordship. But today, if Your Lordship, if this particular termination, I'm not saying, Your Lordship, the termination should be stayed to the full in entirety.
No, leave aside all stay.
Yes.
If today also, if
Yes.
they are not appearing and the court will find that the termination is wrong, what remedy you are having now?
No, if the Honorable Court, Your Lordship, set aside the termination, either, Your Lordship, I will get the work back, and if, Your Lordship, they have already given to a third party, my remedy, Your Lordship, lies in damages. I am not on that. Yes, Your Lordship, I am aware of that. But Your Lordship, in respect of the termination, that Your Lordship, further debarment or further participation in other bids, Your Lordship, I cannot go before an arbitration or a suit court where I can get these remedies. Your Lordship, unless and until, Your Lordship, the Honorable Writ Court, if prima facie I can show that this particular termination or 10 days notices, Your Lordship, are ex facie bad in law, then in that case I am entitled, Your Lordship, under the Writ Court, Your Lordship, at least to get that particular protection so that I can participate, because this, Your Lordship, is infringement of, Your Lordship, my right to carry on the business, Article 19(1)(g). I cannot participate any further.
Then again the question arose, once the termination and the invocation, the bank guarantee is intact, so how the court can interfere in the clause 1.6?
Exactly, Your Lordship. That's the only prayer today I am making. Kindly stay the termination notice to the extent that I can participate in future contracts, nothing else. I'm not saying, Your Lordship, reverse the entirety.
1.6 is the consequential to their termination.
Yes.
Correct.
Yes.
And the termination with regard to, as per their contention, breach of contract.
Yes,
Breach of terms and conditions.
Lordship.
So breach of terms and conditions, this is the appendix 1 is the technical bit. What is the condition that you have to bear that?
Lordship.
Well, unless and until that is not been declared by this court, how you can get the relief of 1.6?
I understand, Your Lordship. But two things are important here. First, Your Lordship, the LOA was issued sometime on 29 July 2024.
Subject to correction.
Yes, Your Lordship.
They are not appearing. They are not appearing.
Yes, Your Lordship.
If any order is passed, it will be affected either you or the other party.
Lordship.
If suggested, I am giving a further direction for filing an affidavit, inform the authority. If they will come, I will fix in the month of January. If they will not come, it will be heard on merit.
Lordship can direct me.
This is the consequence.
I understand, Your Lordship, is an implications, Your Lordship, where Your Lordship, I would be, Your Lordship. Lordship, can I come back on Monday because it's already in Garden Bridge, Your Lordship?
Yes, Mr. Shah, you can guide this court.
Yes, sir. Lordship, as per Your Lordship, the guidance of my senior, Lordship, kindly, Your Lordship, direct Your Lordship the railways not to treat this, Your Lordship, as termination notice at a debarment, Your Lordship, to participate in the future contracts.
Now, that's why I'm telling, because the consequence.
Because breach of contract, Your Lordship, is not a ground, Your Lordship, in connection with the blacklistings. That's why clause number 2 and 4 has been specifically differently given. But today, if Your Lordship, they are not coming, Your Lordship, I have filed, Your Lordship, the affidavit of service. Your Lordship, not only Your Lordship, first service I have served, even Your Lordship, the supplementary affidavit I have served them.
What do you file in supplementary?
For supplementary, Your Lordship, I have filed, Your Lordship, 2 letters, wherein, Your Lordship, it will show that after Lordship, kindly, Your Lordship, take the supplementary affidavit. 3 letters I have disclosed.
Yes.
Lordship, kindly take page number 7. That is, Your Lordship, 5th of January, Your Lordship, 2025. After the execution, the contract was executed on 26 December 2024.
Correct.
And thereafter, on 5th of January 2025, I have given Your Lordship them letter and requested them, Your Lordship, to give me the approvals. Because unless and until the approval is given, Your Lordship, I cannot deploy. And if I can't deploy, I cannot execute the contract.
Have you issued any tender with regard to this work?
Yes, sir.
Have you issued, the authority have issued any further fresh tender notice with regard to this work?
Lordship, we are not aware. We are just apprehending if they issue, Your Lordship, to future Your Lordship, to third parties. Your Lordship, that is in connection with this contract. Today, Your Lordship, I cannot participate in any other contract. Yes.
With regard to this contract,
I have, Your Lordship, pleaded that we had an apprehension that they will issue, but Your Lordship, there is nothing on record, Your Lordship, to show that the subject matter of the tender, Your Lordship, has been issued to a third party. Today, I am only a limited order, Your Lordship, that this should not be treated, so that I cannot participate, Your Lordship, in the future. That will not prejudice, Your Lordship, Southeastern Railways. I am not saying, Your Lordship, set it aside and, Your Lordship, kindly allow me to again start the work, Your Lordship, as per, Your Lordship, the LOA or the contract. I am not praying for that particular, Your Lordship, relief today. I am saying if any future contract, Your Lordship, is issued, so that I can participate. Otherwise, whenever, Your Lordship, I go and file, Your Lordship, the application forms, this particular clause, Your Lordship, will debar me, Your Lordship, for the eligibility as a PSSA, Your Lordship, as per, Your Lordship, the tender documents. That, Your Lordship, can always, Your Lordship, with deepest respect, stay for the time being so that I can participate. Where, Your Lordship, I have shown, Your Lordship, that prima facie this remedial letter and termination notice, Your Lordship, are ex facie, Your Lordship, in violation of the principles of natural justice.
the petitioner has filed the present writ application challenging the interim order of termination dated 3rd June 2025. 3rd June 2025. The respondents have issued a tender notice on 20th March 2020, on 1st of August 2020. What is the date of the tender notice?
Lordship, the tender LOA was floated, Your Lordship, sometime, Your Lordship, on 28.
Page 27?
Page 27, Your Lordship. There's
What is
no
the date?
no date mentioned, but closing date is mentioned on 20th March.
Tender notice in the month of March 2024 for appointment of project supervision services agency within bracket PSSA for providing project supervision services at various construction sites sections in the jurisdiction of CE/CON-1/GRC Construction Organization, Southeastern Railway. Full stop. The petitioner has participated in this said tender. Full stop. The on 26th of December 2024, 10th of December 2024, an agreement was entered between the petitioner and the respondents. As per the agreement, the Project Supervision Services Agency requiring the authorities prior approval, and the PSSA shall obtain the authorities prior approval in writing before taking any action, that is appointment of such members of the key personals and appointment of all other personals as well. As per clause 3.11 of the agreement, the authority accepts all key personals specified in the bid to be available during implementation of the agreement. Full stop. As per clause 3.11.2, in case a PSS substitutes a key personnel of lower marks as compared to the original bid, deduction of difference of payment to second highest bidder, in case of violation of payment, the activity to be done at stage of variation and after completion of 25%, 50%, 75%, and final contractual amount payment in the contract as a whole. Full stop. The petitioner has also submitted the bank guarantee. Full stop. On 17th of August 2024, the petitioner has requested the respondents for substitution of the original candidate as resident engineers civil. Full stop. Subsequently, the petitioner has made several requests to the authorities for substitution, but none of the request was considered by the authority. Full stop. All of a sudden, where is the termination letter?
Your Lordship, the remedial letter, Your Lordship, is page 450 and termination 454. 450 is a remedial letter for 10 days.
On 11th of August, what is the date? 11th
April 2025.
April 2025, the chief engineer has issued a remedial letter directing the petitioner in informing the petitioner for taking remedial measures, failing which the authorities will take appropriate steps in accordance with. On receipt of the remedial letter dated 11th April 2025, the petitioner has submitted a detailed reply to the authority on 23rd of April 2025, mentioning all the correspondence made by the petitioner with the concerned authority for substitution of the resident engineer, sector expert, quality control, supervisor, and AutoCAD draftsman, as well as the computer operator. In spite, full stop, though the petitioner has given detailed reply to the authority, but without considering the reply submitted by the petitioner, by an order dated 3rd of June 2025, the contact of the petitioner was terminated on the ground that the petitioner has violated the terms and conditions of the agreement. The petitioner further submitted, subsequent to the termination of the contact of the petitioner, the bank guarantee was also invoked by the authorities. Now the petitioner, full stop. Learned counsel appearing for the petitioner had drawn the attention of this court to the, where is the technical bid?
Page 130, Your Lordship.
Draw the attention of this court to the technical bid form. Technical bid form under Appendix 1, wherein it is mentioned that if the bidder or any of the members, in case of consortium being penalized by any organization for the poor quality of the work or breach of contract in the last 5 years, the bidder is not eligible for this PSSA. Full stop. Counsel for the petition submitted. The respondents have terminated the contract without considering the request made by the petitioner for substitution, but has made an allegation that the petitioner has violated the terms and conditions of the contract, and as such, as per clause 1.6 of the technical bid form, the petitioner will not be eligible for the PSSA. There is no time mentioned. Not eligible for this.
Yes, Your Lordship. As PSSA, he will not be in.
PSSA. Consider the submission made by the counsel for the petitioner. The petitioner has filed the affidavit of service showing that the notices have been served to the respondent, but in spite of service of notice, none appears on behalf of the respondents. Consider the submission made by the counsel for the petitioner, peruse the materials on record. This court finds that as per the terms of the contract, the petitioner time and again made representation to the authorities for substitution of the officials of the PSSA. In spite of receipt of the request of the petitioner, the authorities are not considered, but finally they have issued the remedial notice. In the reply of the remedial notice, also the petitioner has submitted a detailed reply stating the fact that time and again the petitioner has requested the authorities for substitution of the
of Your Lordship, the key personnel and other personals.
The key personnel and other personals, but the same has not been considered. Considering the above, this court find that though the termination order is passed in the month of June 2025 and subsequently the bank guarantee has also been invoked, and as such at this stage it is not proper for this court to pass any order of injunction with regard to the termination order and the invocation of the bank guarantee. But this court find that till the disposal of the present date application
the petitioner shall not be debarred to be eligible for this PSSA. Accordingly, respondents authorities are directed not to restrain from giving effect on further effect to clause 1.6 II of the technical bid form till 23rd of December 2025 or leave the matter on 25th December 2025. The petition is directed to 23rd of December. Yes.
Lordship, in the meantime, if they want to file the affidavit, I will communicate, Your Lordship.
As none appears on behalf of the respondents, in spite of service of notice, the respondents are at liberty to then in the meantime then also 23rd bola na 8th of January ko. As none appears on behalf of the respondents, in spite of service of notice, the respondents are at liberty to file their affidavit in opposition by 18th of by 22nd of December 2025 after serving the copy to the Land Council for the petitioner. Petitioner is liberty to file reply if any by 6th of January 2026 after serving the copy to the Land Council to the respondents. List the matter on 8th of January.
I'm grateful, Your Lordship. Okay.
Yes. Yes.
My lord, this is coming up, my lord, after affidavits. My lord, though the files are voluminous, my lord, actually, my lord, there's a very short question, my lord, involved here. My lord, the respondent number 7, which is the private respondent, markets and sells, my lord, mustard oil under, my lord, a trademark, Doctor's Choice, and, my lord, with a stethoscope and a heart, my lord, as part of the trademark. Now, my lord, under the Food Safety and Standards Act 2006 and the rules and regulations framed under it, my lord, any brand, my lord, which is misleading or can cause, my lord, confusion as to, my lord, the nature of the product, my lord, is, my lord, prohibited, and, my lord, appropriate steps can be taken. Now, the petitioner before your lordship, my lord, is, my lord, the Indian Research and Ethics Society, consisting primarily of doctors, my lord, as its members. They wrote, my lord, to, my lord, the food security authorities, saying, look, this mark cannot be permitted to be used because the consumers can be led to believe that we, the doctors, have recommended this product and that it has health advantages. Now, my lord, no action was taken. So, my lord, we filed, my lord, a writ petition in this honorable court complaining of inaction on the part of the respondent authorities. My lord, in that proceeding, while it was being heard, my lord, they came up with a report saying we have taken steps, so the cause of action regarding inaction no longer survives. The learned judge, my lord, noted that fact, directed handing over of such report, and, my lord, gave liberty, my lord, to, my lord, the writ petitioner to file, my lord, another writ petition or challenge, my lord, the decision, my lord, which had been taken. My lord, the second writ petition is as a consequence of that. And, my lord, also, my lord, that it had not considered our representation of, my lord, 29th of November 2023, because and 29th of May 2024. My lord, because my lord, the report, my lord, was my lord of October. So it could not have, my lord, considered, my lord, these. So my lord, we, my lord, filed, my lord, the writ petition challenging, my lord, some of the documents disclosed, my lord, in the report. My lord, in short, my lord, what was stated was, look, we have actually given them notice to, what's the term used? To, my lord, my lord, improvement notices have been issued. My lord, they were really font size, etc., that you lessen the font. And my lord, the next thing, my lord, which is glaring is that we cannot do anything more because, my lord, once, my lord, it's in the domain of trademarks, my lord, FSSAI has no, my lord, jurisdiction. This was, my lord. Now, a writ here, my lord, is to the effect that, my lord, the FSS Act, my lord, the Food Standard and Security Act, my lord, is a special act. And, my lord, there is a non-obstante provision, my lord, in the act, which says, notwithstanding anything contained in any other law, my lord, the provisions of this act have to be given effect to, because this is an act in the interest of, my lord, consumers. So, my lord, that is our principal challenge. There are two decisions, my lord, one of the Supreme Court and one of the Delhi High Court, saying, my lord, the Trademarks Act or any other act, my lord, relating to branding will have no role to play when, my lord, the Food Standards and Security Act is involved. And secondly, I would say more so in this case, because, my lord, the statutory authorities have already held, my lord, in their reports, etc., that the advertisement and packaging, my lord, is misleading. So, my lord, I'll just show your lordship, my lord, this is, my lord.
What is the prayer?
My lord, prayer is to strike these down and direct, my lord, the respondent authorities to take steps in accordance with the FSS Act. Because they've already found that, my lord, this is, my lord, misleading, my lord. The reason why they refused to exercise any further jurisdiction, my lord, was because this is a trademark. It's outside our purview now. It's a registered trademark. That's the reason. Now, my lord, I'll start only, my lord, from the order of 9th of, I'm sorry, my lord, 9th of May 2024. That was, my lord, what are you saying? My lord, that's, my lord, page 33. Sorry, my lord, 39, my lord, of this writ petition.
Yes.
My lord, kindly see, my lord, May 9, 2024. Learned Senior Counsel appearing for the petitioner fairly points out that as per the report filed on behalf of respond numbers 4, 5, and 6, that is the Food Safety and Standards Authority of India, a decision has been taken on the complaint made by the petitioner. Upon hearing learned counsel and perusal of the report, it is evident that the respondents' authorities have taken a decision on the complaint of the petitioner. Kindly mark the date, my lord, on October 12, 2023. Annexed at page 13 of the report filed the said respondents. Accordingly, the cause of action regarding inaction on the part of the authorities has been rendered infructuous. Then, my lord, however, needless to say, it will be open to the appearing parties, including the petitioner, to challenge the decision now taken by the respondent authorities in an independent writ petition stroke challenge. Accordingly, WPA 6460 of 2024 is disposed of by keeping on record the report filed by the respondents 4 to 6 and granting liberty to the petitioner and any other aggrieved party to challenge the decision taken by the respondent authorities on October 12, 2023, annexed at page 13 of the said report. Since the said decision was disclosed to the petitioner only by way of report for the first time, kindly note this, the appropriate forum court taking up the challenge shall duly consider such fact while considering the question of delay, if any. Because, my lord, we are being informed, my lord, for the first time. It is made clear that the contentions of the parties regarding such proposed challenge have not been gone into on merits by the court and it will be open to the appropriate forum, court, to decide all issues independently in accordance with law. Now, my lord, my lord, kindly first have a look at the report, and my lord, I will then show, my lord, the prayers, my lord, which have been, my lord, made here. My lord, the report, my lord, is, my lord, where is the report? Give me the link. My lord, volume 5, page 206.
Yes.
My lord, this kindly see the heading, report filed in the form of an affidavit on behalf of so and so. Then, my lord, kindly come to para 6 at page 208. It is submitted that the representations were received from the petitioner alleging misleading brand name and misleading claims on the product label, that pursuant to the said representations, 3 improvement notices under section 32 of the FSS Act 2006 were issued to the food business operator. Food business operator, my lord, is respond number 7, Baj, my lord, by the concerned central licensing authorities on the following dates. Now, my lord, 15th March, 18th April, and 12th October.
Yes.
A copy of the improvement notice dated 15th March, 18th April, and 12th October is enclosed and marked as Annexure A. It is submitted that with respect to the, kindly mark this, misleading brand name, Doctor's Choice, the Director of Enforcement and Regulatory Operations, vide letter dated 12th October, informed about FBO submission that it is not a claim but a trademark, and taking action with respect to trademark is out of the purview of respondent FSSI. A copy of the letter is so and so. It is further submitted that in compliance with the improved notices, the FBO has already rectified the product labels as directed and also submitted copies of rectified labels. Additionally, FBO also provided a disclaimer regarding trademark. Then, my lord, para 9, it is also pertinent to submit that subsequent to the compliance efforts, the respondent FSSAI received a communication from the Central Consumer Protection Authority, email dated 9 January, seeking updated information on the matter. It is submitted that in response to CCPA's inquiry, respondent furnished a copy of the reply dated 23rd January 2024, comprehensively addressing the concerns raised by the petitioner and provided details regarding action taken. Copy of reply dated so and so. It is submitted that in view of the above submission and manner, present writ petition is baseless, misleading, etc., etc. So, my lord, this was, my lord, the report. Yes. Now, my lord, kindly have a look at the 5 documents, my lord, which have been relied on here. My lord, kindly come to page 211 first. This is the first improvement notice of 15th of March 2023.
Yes.
My lord, improvement notice under section 32 of Food Safety and Standards Act. Give me the act. My lord, your lordship has a copy of the act, my lord, or I'll give a copy.
Give the copy.
Yes, sir. Is this? I just want to show 32, my lord. My lord, I think it should be page 23 of your.
Yes, yes.
Yes. Now, my lord, kindly see section 32. The designated, if the designated officer has reasonable ground for believing that any food business operator, and my lord, FBO has been defined in the Act, has failed to comply with any regulations to which this section applies, he may, by a notice served on that food business operator, in this Act referred to as an improvement notice, state the grounds for believing that the food business operator has failed to comply with the regulations, Specify the matters which constitute the food business operator's failure so to comply. Specify the measures which, in the opinion of the authority, food business operator must take in order to secure compliance, and require the food business operator to take those measures or measures which are equivalent to them within a reasonable period, etc. So, my lord, jurisdiction to, my lord, invoke 32 is, my lord, based on, my lord, a satisfaction that they have not complied with the regulations. Now, my lord, kindly see what the notice says. 15 March 2023. It has been observed by this office that Bajbaj Refineries Limited, having its office at so-and-so, is marketing on labels of refined soybean oil, refined sunflower oil, and Kachi Ghani mustard oil, hereinafter referred to the products with brand name Doctor's Choice and pictorial representation of stethoscope on the label of the product, is found to be, kindly mark this, in contravention of so-and-so, the rules and regulations made thereunder. In this connection, you are hereby serve this improvement notice under 32, etc. Now, my lord, grounds of improvement. It is observed from the front of the pack that the brand name Doctor's Choice, along with heart symbol and the stethoscope in the shape of the heart on the label, kindly, my lord, see, are grossly misleading the consumer, as it ordinarily means that this oil is not only heart friendly but also recommended by a doctor. This is in violation of Section 23 and 24 of Food Safety Act, Regulation 43 and 44 of Food Safety and Standards, Labeling and Display Regulations 2024. The provisions are reiterated as under. My lord, they are here. I'll just place it from here. Section 23, my lord, kindly see. My lord, they say there's violation of 23 and, my lord, 24 in Regulation 43 and 4F. No person shall manufacture, distribute, sell, or expose for sale or dispatch or deliver to any agent or broker for the purpose of sale any packaged food products which are not marked and labeled in the manner as may be specified by regulation, provided that the label shall not contain any statement, kindly mark this proviso, any statement, claim, design, or device which is false or misleading in any particular concerning the food products contained in the package, or concerning the quantity or the nutritive value, implying medicinal or therapeutic claims, or in relation to the place of origin of the said food products. Then, Miller 2, every food business operator shall ensure that the labeling and presentation of food, including the shape, appearance of packaging, the packaging material used, the manner in which they are enamed, and the setting in which they are displayed, and the information which is made available about them through whatever medium documents does not mislead consumers. Then Section 24, restrictions of advertisement and prohibition of unfair trade practices. No advertisement shall be made of any food which is misleading or deceiving or contravenes the provisions of this Act, the rules and regulations made thereunder. Now, my lord, kindly see the regulations. Prepackaged food shall not be described or presented on any label or any labeling in a manner that is false, misleading, or deceptive, or is likely to create an erroneous impression regarding its character in any respect. Then 4.4, any information, then kindly note this, or pictorial device, written, printed, or graphic matter may be displayed on the label, provided that it is not in conflict with the requirements of this regulation. Further, it is also observed that the unregistered trademark, which is a device mark, is being used by FPO as against the registered trademark. Then, my lord, mandatory requirement of compliance. In this regard, you are hereby directed to stop using the misleading brand name and pictorial representation on the front of the pack label with immediate effect. 2, taking cognizance of the above deficiencies, non-compliances, you are hereby directed to immediately comply with the said requirements and submit compliance report to this office with supporting evidence of the action within 30 days. In case of non-submission within specified time, shall be compelled to initiate suitable action. Then, my lord, comes the second, my lord, improvement notice, my lord, which is, my lord, 18th of April, which is at page 215, my lord.
5 or 213.
215, my lord. That's, my lord, the third. October is the third, my lord. They've got, my lord, in the report itself, it came, my lord, like this. The reply received in response to the improvement notice dated 15 is not found to be satisfactory. Give the reply. However, another opportunity is being provided and improvement notice is being served freshly under section 32 of the FSS Act. It is observed from the copies of the front of the pack labels enclosed in the reply submitted by Bajbaj dated 12th April and Bajbaj Refineries having its office at so-and-so, 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 is marketing refined soybean and kachi ghani mustard oil, hereinafter called products, with brand name Doctor's Choice and pictorial representation of stethoscope on the label of the product, which is found to be in contravention with food rules. In this connection, you hereby serve the improvement notice under 32 food safety and standard on grounds of improvement, erroneous brand name Doctor's Choice and pictorial representation of so-and-so. It is observed from the front of the pack enclosed in the reply submitted by so-and-so, along with heart and symbol stethoscope in the shape of the heart on the label, are grossly misleading. So, my lord, again, second improvement notice says grossly misleading the consumer as it depicts the product as heart-friendly and recommended by doctors. This is in violation of Regulation 8.3 and 10.2 of Food Safety and Standard Advertising and Claims Regulations 2018, thereby violating 23 and 24 of the Act of 2000. Provisions are reiterated. So, my lord, earlier notice 23, 24, 43, 44. Now, addition here, my lord, is 83 and 84. Yes. Food shall not be described as healthy or be represented in a manner that implies that a food in and of itself will impart health. Then 10.2 is very important, my lord. There shall not appear in the label of any package containing food for sale the words recommended by the medical or nutrition or health professionals, or any words which imply or suggest that the food is recommended, prescribed, or approved by medical practitioners or approved for medical purposes. My lord, then 23, 24 is again set out. Then, my lord, kindly come to para 2.2. It is observed that the labels of the product do not contain the name of the manufacturer and license number of the brand owners not provided on label. This is in violation of Regulation 5.6 and 7B of so-and-so. So, my lord, there was a further violation. And then 2.3, expiry date has also not been mentioned. Then, my lord, kindly come to para 3. In this regard, you are hereby directed to stop using misleading brand name and pictorial representations on the front of the pack label with immediate effect, taking cognizance of the above deficiencies, non-compliances. You are hereby directed to immediately comply with the requirements and submit compliance report. Now, my lord, kindly come to 12th October at page 218.
Yes.
And then, my lord, kindly see para 2, my lord. Following actions were taken. Improvement notice 15th, then, my lord, 18th.
Yes.
We've showed these two. Then, my lord, kindly come to the paragraph after that. My lord, kindly see their stand. Whereas FBO, Bajbaj, had replied that Doctor's Choice is not a claim as per Regulation 10.2, but a trademark, and had accordingly submitted revised label. With respect to misleading claims on FBO official website, fresh improvement notice has been served to Bajbaj on 12th. Furthermore, it is to be mentioned that the status and action on unregistered is out of, kindly note this, purview of SSAI. Pertaining to complaint so-and-so has been served for removing misreadings, my lord, that's dealing with another one. Now, my lord, kindly have a look at the revised label 219. My lord, kindly see this, my lord, very carefully. My lord, we have, my lord, doctor's choice with, my lord, and my lord, apostrophe is after the S. So, my lord, all doctors are recommending this. My lord, with the TM, and my lord, in, my lord, the second O, my lord, it's heart-shaped. Choice, Kachi Ghani, mustard oil. Now, in the next page, my lord, kindly see left-hand top, my lord, that, my lord, doctor's choice, my lord, heart, and, my lord, a stethoscope. Left-hand top, my lord.
Yes.
Stethoscope is also there. And, my lord, so, my lord, the entire mark is retained. And, my lord, then we have a little disclaimer. So, pictorial representation, my lord, mark, my lord, everything retained. Now, kindly have a look at the disclaimer. My lord, same page. My lord, the left-hand package, my lord, towards, my lord, the right-hand side, my lord, towards the bottom. Disclaimer. Doctor's choice is only a brand name or trademark. It does not represent its true nature.
Yes.
Now, my lord, that is, my lord, also in, my lord, page 220 for, yes. Now, my lord, that's for a different product, but it's, my lord, similar. And I want to show your lordship, my lord, one other letter which was issued. My lord, kindly come to the other improvement notice. My lord, page 213.
Yes.
My lord, this is on the website for which, my lord, my lord, grounds of improvement. My lord, this is 13th October. It has been observed that Bajbaj Refineries license is promoting its product on its official website as healthy, cholesterol-free, and usage of undermines products of same category available. Claims should be made in line with Schedule 2A of the above. Other misleading claims found on the website, my lord, whole lot of misleading claims, my lord, are, my lord, indicated.
What is the date?
My lord, this, my lord, is 12th of October 2023. Same date as, my lord, the decision. My lord, decision itself says that they've sent out one improvement notice regarding website. This is, my lord, that which I'm showing. So, my lord, apropos, my lord, other than website, there were two improvement notices. My lord, and, my lord, the, my lord, decision. This is, my lord, how, my lord, that was March and April were the two improvement notices, and, my lord, the decision. My lord, which, my lord, alleged compliance, my lord, I'm showing your lordship, and the decision is we can't do anything more because it's outside the purview. Now, my lord, kindly have a look at, my lord, our representation. No, November, Java. My lord, there is, my lord, a representation of 29th, 29th of November 2023, my lord.
Page.
My lord, page 169, I believe. These should be linked, yeah. Nothing is linked. My lord, volume 4, annexure P7.
Yes.
My lord, 29th November.
Yes.
My lord, where we had pointed out, my lord, the provisions of the act under which, my lord, action can be taken. My lord, we had specifically referred to, my lord, the food safety and standards advertisement and claims regulations. I'm not placing it in detail, but this was, my lord, also, my lord, before them. And, my lord, then my lord, 29th of May, 2024, which is, my lord, at page 232. Volume 5, my lord.
Yes.
And my lord, kindly have a look at my prayer. My lord, the last page, my lord, which is page 236. Kindly come to, my lord, subpara G.
Yes.
My lord, it is also pertinent to remind that the Honorable Supreme Court of India has recently taken a view in respect of misleading advertisements that it is of abundant importance for the manufacturers, advertisers of food products to ensure that consumers are made aware of the kind of product that is being offered for purchase, particularly in food and health sector, as a fundamental right to health under Article 32, etc. Advertisement and claims made by so-and-so as an impact of infringing. In the aforesaid facts, society requests your good officers to initiate appropriate action against so-and-so, would appreciate if response with details is provided to us, etc. Now, my lord, there are other letters. I'm not troubling your lordship with that. I'll come straight to the law, my lord. Yes. Now, my lord, while the writ was pending, this is very important. My lord, they have admitted our case. Kindly have a look. My lord, the affidavit in opposition, my lord, of, my lord, the respond number 5 here. My lord, it's the affidavit of one, my lord, file, my lord, Maji.
File Maji.
Yes, my lord.
5 and 6.
Yes, my lord.
Yes.
Now, my lord, kindly see page, my lord, 19.
Yes.
My lord, this is dated 18 November 2025.
24.
My lord, internal communication, they have disclosed it here. Now, kindly see their stand, my lord. Not internal, to us. My lord, 18 November. This is in reference to the representation dated 29th May regarding claims made by Bajbaj to their product so-and-so. For using in this regard, it is to inform you that the matter has been forwarded to so-and-so for necessary actions. The next page, my lord, 20. In continue regarding use of, now, my lord, kindly see, in continuation with the letter dated 11 November, regarding the use of misleading marks by certain food business operators, it is brought to your attention that the use of misleading trademarks continues, which misleads consumers about the true nature and health benefits. Further, as mentioned in our earlier letter, trademark like pizza cheese is being used, so-and-so, etc. Then, my lord, kindly come to page 21, my lord, which is the letter, my lord, which is being referred to in the letter at page 20. Kindly take the second paragraph. Recently, a trend has emerged. My lord, second paragraph at page 21. Yes. Recently, a trend has emerged where food business operators utilize trademarks that may deceive consumers about the actual nature and health benefits of their products. Some of the significant examples are doctor's choice. This branding suggests an endorsement by a healthcare professional, potentially leading consumers to believe the product is a medically validated option, which is misleading without proper evidence. Then, my lord, kindly come to page 22. Given the seriousness of this issue, the Office of the Controller General is required to ensure that trademarks are thoroughly evaluated before approval, avoiding any potential, if required, opinion of FSSI. Now, my lord, but the fact of the matter remains that decision, even though they say, my lord, it's misleading, they say we can't do anything about it because it's a trademark and that is beyond, my lord, our purview. And that's the stand in the affidavit also, which your lordship will find. My lord, paragraph 4 and 17, my lord.
Of the
This very affidavit, my lord.
Yes.
Where para 4? What are you reading? Where? My lord, kindly see, respondents have no role in the merit of the subject issue.
Correct.
This is, my lord, again, my lord, the stand. Now, my lord, kindly take the act once. My lord, kindly have a look at, my lord, section 89. You have a compilation. What is this? Of what? Why should we show all the judgment?
Yes. Overriding effect.
Yes. Now, my lord, kindly see the provisions of this act shall have effect notwithstanding anything inconsistent therewith contained in any other law
For the time being in.
for the time being in force or in any instrument having effect by virtue of any law other than this act. Now, my lord, this came to be, my lord, interpreted, my lord, by, my lord, the Supreme Court, my lord, in the decision reported in 2024, 3 SCC 502. You have it or no? No, I can't give it. I can't. My lord, it's come in a compilation, my lord. I don't know why people like preparing compilations and don't have. I want to finish it, my lord, kindly. No. No. My lord, we unnecessarily read too much. No, my lord, I don't like reading anymore. My lord, judgments are, my lord, they get. Is it there? Give it to me. I don't think you have the full judgment there. Can't even read. Give it to me. How much money will you save? That I know, but it goes up to where? 212. No, you will not do anything. At a stapler, how? And arrange the Delhi with the stapler. I'll do it. Give them a copy accordingly. Just give. Kindly take the second page of that.
May I have your lordship's leave, Mr. Bachawat?
Yes.
Now, my lord, kindly come to, my lord, paragraph
29.
27 to, my lord, 29. Do they know the case or they don't know the case? My lord, huh? করে দিচ্ছি আমারটাই করে দিচ্ছি তোমাকে just give me one. My lord, kindly come to, my lord, paragraph 27. Will you airdrop one to Ranjan? No, not compilation. আমি দিয়ে দিচ্ছি তোমাকে In this context, we must consider the effect of section 89 FSSA. So, my lord, this provision was, my lord, being considered. The title of the section indeed indicates that the intention is to give an overriding effect to FSSA over all food-related issues. However, in the main section, there is no such restriction confined to food-related laws, and it is provided that provisions of so-and-so shall have effect, notwithstanding anything inconsistent therewith contained in any other law for the time being in force. So the section indicates So the section indicates that an overriding effect is given to the provisions of SSA over any other law. Then, my lord, kindly come to it. And my lord, kindly see, my lord, 29. My lord, 28 and 20. The settled law is that if the main section is unambiguous, the aid of the title of the section or its marginal note cannot be taken to interpret the same. Only if it is ambiguous, the title of the section or the marginal note can be looked into to understand the intention of the legislature. Therefore, the main section clearly gives overriding effect to the provisions of FSSA over any other law insofar as the law applies to the aspects of food in the field covered by so-and-so. In this case, we are concerned only with section so-and-so of IPC. When the offense under 272 and 273 are made out, even the offense under 59 will be attracted. In fact, offense under is more stringent. Then, my lord, the other decisions. Now, my lord, the Delhi High Court decision, my lord, is, my lord, reported in 2025 SCC Online Delhi 7909.
Yes.
Yes. Now, my lord, kindly come to paragraph 7, my lord, which is print page 8, and my lord, running. Oh, sorry.
Paragraph?
My lord, para 7, my lord. My lord, compilation page 188, print page 8, my lord.
Yes.
Now, my lord, kindly note one thing. It's the FSSAI stand in Delhi High Court, which is contrary to the stand here. Kindly just note that, my lord. But, my lord, kindly come to, my lord, straight away, my lord, F. The contention of the petitioner that disclaimers were included. I've shown your lordship, that's the only thing. Disclaimers were included on labels. To avoid confusion cannot be considered. There are a number of complaints that disclaimers are ineffective when the brand name containing virtually dominates the label. Now the labels before your lordship, my lord, your lordship see. The product labeling prominently displays the term ORS and uses color schemes, fonts, and representative identical or similar to medically approved so-and-so. And 3, consumers, particularly laypersons, do not read or comprehend such disclaimers. Now, Millard, kindly come to K. Page 190, Millard, print page 10. The Trademarks Act 1999 sets rules for registering, protecting, and enforcing trademarks. A trademark helps identify one company's goods or services from other. Under the Trademarks Act, the organizations only have the right to stop others from using their marks without permission. Trademarks Act nowhere gives permission to the organization to use the trademarks for creating deception amongst the consumers. The jurisdiction of so-and-so is confined to trademark registration and protection under Trademarks Act. It does not extend to determining compliance with food safety laws. As per 89, provisions of so-and-so have overriding effect. And then, my lord. Then, my lord, kindly come to 191. My lord, L, subpara L. Even a validly registered trademark cannot be used in a manner that misleads consumers or contravenes food safety provisions. Therefore, even if a trademark is validly registered, its use on food products must comply with the provisions of so-and-so. Then, Millard, kindly come to P. It is the duty of FSSAI as a regulator to ensure protection of consumers' interest, including fair practices and protect the consumer from misleading claims, designs, etc. The orders have been issued to ensure compliance of provisions contained in so-and-so. And 4351 labeling and advertising claims. It is wrong understanding of petitioner that FSSAI cannot modify its orders, etc. Then my lord T, and this is very important. Registration or prior use of a composite mark containing with or without does not confer an unfettered right to use the mark in contravention of other statutory prohibitions. Registration of a trademark cannot be used to circumvent health, safety, or consumer protection statutes. Then, my lord, the decision was taken on that basis. That is recorded in para 8. My lord, kindly see, my lord, in the decision, my lord, 8B, my lord, 3 lines from the start of 8B, statutory obligations under FSS Act and regulations cannot be subordinated to private commercial losses, particularly where the regulatory object is to advert consumer deception and safeguard health. And then, my lord, para 9, it is evident that impugned orders, measures taken by so-and-so are impelled by serious public health. These are the same as in pursuance of to effect statutory mandate. Then, my lord, Vincent, my lord, is referred to. And, my lord, kindly come to para 14.
Para?
My lord, para 14, kindly see, my lord,
I think it is
my
not.
lord, last page of the case, my lord.
It's not a complete judgment.
What have you given? Oh, I'm sorry, my lord, it's my fault, I think. My lord, may I staple that, my lord?
Yeah, I will. Yes.
Para 14, in the circumstances, this court is not inclined to interdict in the light of the order, particularly in light of deleterious effect and adverse health, so and so. Now, my lord, here, the important thing is, my lord, FSSAI has said this is misleading. This is going to create confusion. My lord, in spite of that, they say, well, trademark law, I can't come in. And here they stand, my lord, which has been upheld by the court is, my lord, and it's in consonance with section 89. And that is what we pointed out. Yes. Now I just want to show your lordship, my lord, few provisions. Now, my lord, kindly note, first thing, my lord, that, my lord, it has found that there is a violation of 23, 24, then regulation 43, 44, and 5354. And, my lord, regulation 10.2. These violations have been found. And they were, my lord, mentioned, my lord, in the improvement notices. Correct. It did not go any further, in spite of being of the view, as communicated, my lord, to the trademark authorities, that these are absolutely misleading.
They can take the.
And the reason that they have not done so is because it's trademark law, we cannot, which is not, my lord, correct. Now, my lord, I want to show your lordships, my lord, what are the steps, my lord, which they could take. My lord, 23 I've already placed, 24 I've already placed. I want to, my lord, show your lordship, my lord, 26. My lord, it's abdicating, my lord. My lord, 26, my lord, is another relevant section because, my lord, an FBO, my lord, has to also comply with the provisions of the Act. Kindly have a look, my lord, at 26. Yes. Every food business operator shall ensure that articles of food satisfy the requirements of this Act and the regulations made thereunder at all stages of production, processing, import, distribution, and sale within the business under his code. Then, my lord, no food business operator shall himself, on behalf, so sell, distribute a which is unsafe, misbranded, or substandard, or contain 6. Kindly mark the words, my lord, misbranded. Then, my lord, kindly come to, my lord, section 33. My lord, the improvement notices, my lord, were under 32. Yes. But in spite of that, my lord, it is really, I've shown your lordship not doing anything because disclaimers are wholly irrelevant. Now, my lord, 33 kindly see. If any food business operator, my lord, this is if there's a conviction, then my lord, 2, the court may on being signed by an order impose prohibition as so and so, as soon as practicable after making the concerned food sale shall serve a copy, etc. These, my lord, are all these powers, my lord, which are available. Then, my lord, emergency prohibition and orders, my lord, under 34. This is the most important. If the designated officer is satisfied that health risk condition exists with respect, he may serve a notice on apply to the commissioner for imposing prohibition. This is the emergency power. My lord, while we wait for a conviction or anything, my lord, if the authority is satisfied, they can, my lord, do this. They don't have to wait, my lord, for the result of that. Then, my lord, kindly take, my lord, 42 is launching prosecution. My lord, penalty under 49. And my lord, 66 is, my lord, holding directors of respond number 1, respond number 7, my lord, liable to, my lord, the provisions of the Act. And my lord, 4344, etc., my lord, have all been placed. So, my lord, in my respectful submission, if your lordship has a look at the prayers, my lord, in, my lord, the writ petition, my lord, at page, my lord, my lord, page 32, up. Back, back. My lord, page 32. And my lord, I have referred to section 28 measure also. Which is, my lord, food recall.
Yes.
And similarly, my lord, 12th October. My lord, to quash that, my lord. My lord, I hadn't shown your lordship, my lord, 23rd January, my lord, letter. I think I should show that also. 23rd January 2024. Huh? Yes, kindly have a look, my lord, at page 221. My lord, same. My lord, they say because of trademark. That's why I've asked for quashing of this word. Kindly have a look at the third paragraph. Further, it is informed that the concerned so-and-so has issued improvement notices and closed the case since FBO is compliant with by removing all misleading claims from advertisement as well as also submitted copy of rectified labels. FBO has also provided disclaimer so-and-so. Further, brand name Doctor's Choice is a registered trademark. And I've shown your lordship, my lord, no change, only disclaimer. Disclaimers, my lord, are not read by ordinary people. So, my lord, it's of no effect. That's, my lord, what the Delhi High Court has held. Yes. And, my lord, in any event, my lord, even after this, there is communication, which I've shown your lordship, from, my lord, the food authorities to, my lord, the consumer authorities and trademark, saying, my lord, that this, before you register anybody, you need to keep this in mind. Because the articles are still misleading. So, my lord, in my respectful submission, my lord, I'm, my lord, praying for, my lord, the reliefs here.
Thank you. Yes.
The state should argue first, my lord.
Which for the state?
The state, my lord, for state of West Bengal, my lord, I'm appearing, my lord.
No, not state of West Bengal, my lord. The
My lord, Union of India, my lord. Union of India will be answering this one.
Yes.
Is anybody there?
What is there?
My lord, I'll give them notice, my lord. Let them come in.
Mr. Bachao, they are appearing for?
Right here for me, I wanted 7.
7. And Mr. Shah?
But he's leading. I have a leader.
So 7 and
My lord, my lord, 4, 5 and 6 have shown your lordship the affidavit.
Correct.
Let them now come and explain, my lord. If they can't,
I am fixing a date. Let
yes, my lord.
inform the date. If
We'll
they
inform
cannot
them,
come,
my
then-
lord. My lord, otherwise, my lord, kindly say otherwise will proceed expert.
Correct, that's it.
My lord,
Against them.
madam, my presence can kindly be noted, my lord.
Yes. Yes, she is here.
Give some time, Madam, to answer my lawyer senior regarding this matter. Give me some time, Madam. The next
Yes, so go through the judgment of the Delhi High Court. The stand taken by your authority before the Delhi High Court.
give me 1 week time, Madam, I will.
The learned counsel for the petition has concluded his argument. You are appearing for the 4 and 5. 5 and 6. Counsel for the respondent number 5 and 6. Prays for some time to take instruction. Accordingly, case is adjourned. Let the matter appear. कभी
कच्ची कहानी
कोई डेट है देखो 2 बजे कौन सी डेट में How much time, Mr. You take half an hour, 1 hour?
Little bit more. But I don't know why my learned friend is worried. Please see how light the oil is. Very light.
Every time you are bringing some or the other sample before the court. 11 December. कितना बजे? आज कितना तारीख है? 11 नहीं next
I'm
week.
sure it's a count.
11 December you will be able to 15-16 तारीख.
No. This has to be done before. I am opposing this.
Before vacation. 15, 16. 16. हाँ?
11 PM no 11 AM होगा.
फिक्स है ना 2 बजे
11 PM.
बजे खाली है 16 तारीख
প্রচুর তেল খাইয়েছে so loose
2 बजे खाली है ना 16 at 2 PM.
Yes, ma'am.
16 at 2 PM as a specially fixed matter.
But Mr. Shah is apparently not here on 16th.
Yeah, Mr. Shah is not there on 16.
16. 15. 17 में देखो fix है.
My lord, lordship,
ठीक है.
the state may finish, my lord, on the 16th, then we will respond on another reception.
If they will not take much time, then you can continue.
That is what I was thinking.
18 खाली है 17 18 उसको प्रॉब्लम है ना. Okay, let it be 17. Let they come.
Yes.
17 है ना.
Great lordship.
2 PM 2 PM. अभी तो बोला 17. फिर कब है? Okay. Instead of 17, 16. 16.
But 16th, Mr. Shah is not here. That's
No, let they complete. Take कर देना. Yes, next.
I am for the petitioner, Lordship. Lordship, on the last occasion, CSC Limited has submitted their report, Lordship. I took time on the last occasion to file my exception, Lordship. Lordship, CSC authority in their report has stated that I reside along with my father in the said premises, Lordship. It is not true, Lordship. Father resides in a separate room, Lordship. I reside in a separate 100 square feet room with a kitchen inside, Lordship. And I reside there with my family and I have no good relation with my father, Lordship. And Lordship, thereafter, already the CSC authority in the said area, all the establishment are hutments, Lordship. For all the establishments, 25 meters have been already given by the CSC authority. I have applied, Lordship, for my establishment. I am the resident of the said premises for long, Lordship. I applied as per section 43. I am ready to comply with all the formalities. Now they are stating that in their paragraph number 2, Lordship, landlords have strong objection against installation of another meter in favor of the petitioner. Lordship, in their first reply after my application, they have stated nothing. Now they have come with the new allegation, Lordship. Lordship, I have in my report, Lordship, kindly comes to paragraph number 5 of my exception. Lordship, I have cited the special bench judgment of our Honorable Court Lordship in Port Blair Lordship. Obhimanyu versus the Superintendent in Jail Lordship, I am with the judgment. Lordship, if I am in settled possession Lordship, I am entitled to get the connection without...
No, that is, they are not telling that they will not provide the electric connection.
Lordship,
They are telling that this is the Basti premises.
Lordship, for
Basti meter 25.
Yes,
meters
25
are
they
there,
have already
and
provided.
another 1 meter is in your father's name.
Yes.
They are ready to give the meter to
Lordship,
you as a block meter.
Lordship,
The
what
bill
I
can
am
be adjusted as...
What I am saying, my father has no good relation with me, Lordship. What I am praying, Lordship, block meter be installed, Lordship, in my name, Lordship, another one block meter.
How it can be?
Lordship, in several cases, it has happened by order of this court, Lordship.
Yes, next.
Lordship, these are my submissions, Lordship. The conversion of the said meter will not suffice, Lordship, as I have no good relation with my father. Another block meter be installed, I am ready and willing to comply with all the formalities.
We have filed the report, my lord, previously, and we have to convert the existing meter, my lord, block meter.
But it's not.
My lord,
and father will not give any consent.
What would be the effect if the new meter is provided in the premises of the petitioner? What would be the effect if the new meter is provided in the premises of the petitioner? What would be effect if new meter is provided in the premises of the petitioner?
That is tantamount to splitting of load, my lord.
Huh?
Splitting of load, tantamount to splitting of load, my lord.
How? How is splitting of?
And my lord, paragraph 2, my lord, of my report, my lord.
Yes, I have gone through. 25 meters already there. Common meter board.
I am praying meter be installed in the common meter board, Lord.
His father meter, my lord.
Correct. No, you have stated that there are already 25 meters in the existing common meter board. Landlords have a strong objection against installation of another meter in favor of the petition.
Lordship.
So you take the block meter.
Lordship, another block meter be installed in my name. We are ready to comply, Lordship. Lordship, conversion will...
My lord, can I take instruction, my lord? Keep it tomorrow.
When?
Tomorrow.
Tomorrow.
Tomorrow, my lord.
Lordship.
The petitioner has filed exception to the report of the district engineer. Let the same be kept with the record.
I have also handed over a copy.
The petitioner, the respondent requires a day's time to take instruction. According case is adjourned. Let the matter appear tomorrow under the same matter.
Lordship. Good.
Next.
This is my application. But in this case, Miller, the stone crusher unit, Miller, had questioned, Miller, the propriety of an order, Miller. The unit is situated at Arunachal Pradesh. Now, Miller, the question would naturally, Miller, crop up as to whether this honorable court has jurisdiction. And more particularly, in the context where, Miller, the National Green Tribunal has passed an order, which is a subject matter of challenge in this writ petition, because the law says that the appeal lies to the Supreme Court, Section 22. These are the points against me. First, I have to cross this hurdle. Since, Miller, the Honorable Supreme Court, Miller, has, Miller, answered this question subject to, Miller, what my lord will say. Miller, the similar question, Miller, had cropped up. This is the bench of Justice Joseph and Justice Roy, Miller, reported in 2022 SCC on line 639. The conclusion part, my lord, since brevity is the soul of wit, I do not wish to, my lord, burden your lordships with, my lord, legal exaggerations. Page 45, paragraph 45, my lord. When, my lord, the Honorable Supreme Court, my lord, said, in consequence of the conclusion, sir, the National Green Tribunal under section 14 and 22 of the NGT Act does not oust the High Court jurisdiction under Article 226 and 227, as the same is a part of the basic structure of the Constitution. The remedy of the direct appeal to the Supreme Court under such and such of the Act is intravied as the Constitution of India. Section 3 of the NGT Act is not a case of excessive delegation of power to the central government. The seat of the NGT bench can be located as per the exigencies. It is not necessary to locate them in every state. The prayer for relocating in the Bhopal NGT, meaning thereby, my lord, this NGT Eastern region, my lord, covers 7 states. So the territorial jurisdiction under Article 226(2) would not create any impediment. So far as the question is concerned, that, my lord, that I have come before your lordship, my lord, here, my lord, the perversity, my lord, section, the
Who is
page
appealing for the respondents?
affidavit of service, my lord.
Third.
Served, my lord. And everybody has received.
Yes.
So if your lordship allows me to proceed, or if your lordship, my lord, if your lordship allows me to proceed, my lord, the order under appeal, I will take your lordship, my lord, afterwards, subject to what my lord will say. My lord, the kindly comes to, my lord, page 39 of your lordship's brief.
Yes.
My lord, this is a letter dated, my lord, 14/6/2021, which was addressed to the Additional Deputy Commissioner, my lord, Government of Arunachal Pradesh. My lord, it says the Office of the Divisional Forest Officer. It says, my lord, this matter is regarding issue of no objection certificate in favor of Sri Ojung Darin. It says, my lord, this is the matter issue regarding issue of no objection certificate in respect of such and such for the purpose of setting up of stone crusher unit at such and such. This department has no objection in issuing the LPC for the specific plot of land measuring such and such in favor of the applicant, as the land does not fall under RF, VRF, PRF, VMC and promoted area, etc. The NOC is subject to the condition that the area should be used for the purpose as applied for. Next, my lord, kindly comes to me.
That is correct, but how this court? It's okay if you go by the Supreme Court judgment.
Supreme Court says the territorial, since it covers
How this court?
of this court. So, my lord, it is not necessary to my lord, set up a bench in every state, since it covers. So territorial jurisdiction, the order under appeal, the order under judicial review, my lord, is situated in Rajarhat, NGT. I am questioning the propriety of the order.
Correct.
My lord, this order, the order of, my lord, the DFO, the District Forest Officer, my lord, has issued, my lord, a no objection certificate. Correct. The same DFO, the geo line, my lord, that is, my lord, page, the geology of marine, they have also granted permission. The guideline, my lord, that was framed under rules 2012, it clearly states, my lord, that these are the conditions. My lord, the same DFO, my lord, there was a collective decision taken by a committee constituted under a law. My lord, DFO is a part of the decision-making process. The same DFO afterwards says, after, my lord, the grant of permission, when, my lord, the period of my renewal exists, the DFO has, my lord, cancelled, my lord, the permission. Without, since it was a collective decision, so that is why I have come. First of all, my lord, the jurisdiction.
That's correct. Okay, the Green Tribunal is here in Calcutta, but the originating from the Arunachal Pradesh, because the cause of action from the Arunachal Pradesh with
Yes.
regard to the grant of
Yes.
for running
Yes.
is,
Yes.
stone crusher.
Right, my lord.
Crusher. So
Right.
how this?
No.
Maybe it High Court have a jurisdiction, but whether this High Court or the
Yes,
Arunachal.
my lord, the question is, since the this is the order, my lord, the principle of merger of the order, because this order was affirmed, the order of cancellation which is impugned, my lord, before your lordship, by the NGT. Now, my lord, the moment the NGT National Green Tribunal has affirmed the order, my lord, that means, my lord, this has been merged into this because the affirmation has been done. Now, my lord, if that is done, then Article 226 subclause 2, my lord, if your lordship, my lord, I do not want to, my lord, repeat it. Your lordship need not open the book. My lord, whether, my lord, such fact of merger, my lord, by reason of the order finally attain finality, my lord, which is a subject matter of challenge for your lordship, whether your lordship can constitute it, because the Arunachal is within this, because otherwise, my lord, the jurisdiction.
No, because what I agree with you, but what is the troubling here? The Green Tribunal is also having the jurisdiction of the Arunachal Pradesh.
Right, my lord.
Correct. And the order passed by the Arunachal authority or whatever it is before the Green Tribunal. Green Tribunal has passed an order. So, if the Green Tribunal is having the authority, having the jurisdiction of the Arunachal Pradesh, and he passed an order, whether this court
Yes,
can...
my lord, the superintendent's power of the High Court, my lord, under the law, my lord, the question is, my lord, your lordship knows, my lord, that the under Article 235 of the Constitution of India, my lord, the High Court, my lord, exercises superintendent's power. Now, my lord, the territorial jurisdiction, since the Arunachal, my lord, is coming under this tribunal, yes, and all appointments and all jurisdiction vested in it by law, as such, my lord, the judicial review court within the territorial jurisdiction is my cause of action, my lord. It constitutes a bundle of facts, my lord, constitutes a cause of action. My cause of action, the principal cause of action, my lord, emanates from, my lord, the order passed by the National Green Tribunal. Now, my lord, I must be candid to your lordship, my lord. There was a challenge, my lord, thrown, my lord, 2 years ago, that the one of the chief secretary of the state, my lord, he was slapped with a notice, my lord, which is a premonition of a disciplinary proceeding, my lord. That was questioned before the Supreme Court. The bench presided over by Justice Shobhoshachi Bhattacharya, my lord. That was, my lord, whether the tribunal, whether it should be the principal bench in Delhi or, my lord, before this. My lord, that question, my lord, the Supreme Court initially, my lord, had shown its discordant note and, my lord, nullified the decision. Ultimately, my lord, I am told, my lord, there is a reference to the larger bench. The same Supreme Court, my lord, found it that the decision, my lord, held by your lordship's court, my lord, apparently, my lord, it beats their conscience, and that is why reference was made. Number 2. Number 3, my lord, the two aspects are different, because the tribunal constituted under Article 323A and capital B, my lord, H. Chandrakumar, my lord, stares at our mind, at our face. So, my lord, under this code, my lord, there are two fundamental difference. One is the constitutional remedy, another is, my lord, the alternative remedy. It is an alternative remedy. Constitutional remedy, your lordship cannot compromise. But the alternative remedy, the Supreme Court says, my lord, because this 45 paragraph, which I have shown, my lord, it clearly indicates in no uncertain terms, my lord, the High Court has jurisdiction.
That's why, correct.
Yeah, I know. Because your lordship says that whether the Arunachal Pradesh High Court or, my lord, here. Yes, my lord, this is, my lord, that is my respectful submission, that if your lordship takes it, that the judgment of this NGT, it is the principal cause of action. This tribunal is not, my lord, after this order was passed, affirming, my lord, the order passed by the administrative authority. Ultimately, my lord, if it is a question of a territorial jurisdiction, that is what, my lord, disturbing your lordship's mind, if I have correctly understood my lord's mind. If that is so, my lord, your lordship kindly have the charity to consider that my cause of action is nowhere. My cause of action is the only one point. That is, my lord, the NGT, Calcutta, Eastern Bench. If that is so, my lord, and if it assumes, my lord, all jurisdiction, my lord, of all the territories, my lord, ultimately all jurisdiction, territorial jurisdiction, ultimately, in essence, by reason of the constitution of the NGT, it vests in the Rajarhat, Eastern region, Calcutta, then, my lord, whether I am entitled to make such submission, and it's correct in law, that such territorial jurisdiction, my lord, it gives rise to cause of action, my lord, to come before your lordship, and not elsewhere. Because the Arunachal Pradesh High Court or the council appearing might say that, my lord, the Rajarhat principal bench in the Eastern region bench in Kolkata, that is the principal source of cause of action. Because your lordship, under any circumstances, possibly, my lord, cannot segregate that the factum of the order, which is a subject matter of judicial review, it cannot be segregated. Your lordship cannot fix your lordship's eye only, my lord, at the center point that the original order emanates from the original. Arunachal has been merged. If that is so, my lord, Whether, my lord, there is no.
That's why that is
No, my lord, whether I'm making it makes a sense.
That's correct. You are making that is
Yes, my lord, it is a question of law.
You have that judgment of this tribunal judgment. You are having that. The Supreme Court judgment where it has held that the tribunal of
no, my lord, no, my lord, because this judgment, my lord, was in my favor, the principal law, but distinguishable on the facts that it was Central Administrative Tribunal. Here it is not. Here, my lord, this tribunal has a different color and texture.
That's
yes.
what you want to, because see, in this Central Tribunal, he was posted here, he was working here, but he was the cadre of the central government. So there was some.
No, my duty is to tell the truth, my lord, because justice is truth, my lord. And so, my lord, and even if it does not favor me, but this judgment was not countenanced by the Supreme Court. The Honorable Supreme Court later on found it that discordant note, my lord, because ultimately it beats their conscience subject. That is why they referred the matter to the larger bench. It is yet to take decision. But even then, my lord, if it sounds a discordant note and does not lend any meaningful assistance to my case here, even then, my lord, whether I'm entitled that L. Chandrakumar will not come in aid of this.
That's correct.
Yes, but even then, on the point of this, my lord, first of all, my lord, I will show your lordship, my lord, one decision, my lord, regarding, my lord, the territorial jurisdiction, because I said, my lord, that whatever may be the source of, my lord, originates from Arunachal, the moment, my lord, it comes here, and it is the only principal cause of action, because your lordship, under any circumstances, cannot segregate this order.
No, that's why this court cannot segregate the author only in my mind. Let me also
Yes, yes.
go through that. Let me also.
I will collect this judgment, Supreme Court as well as this one, and I will
this, because I am not on the order passed by the authority at the Arunachal Pradesh, because now the question is the NGT is having the same jurisdiction which the Calcutta as well as the Arunachal Pradesh. Arunachal Pradesh is not having the another NGT. Correct. That is also having the jurisdiction of Calcutta only. So this came from the Arunachal Pradesh. So if it is come from Arunachal Pradesh is having the High Court. Arunachal Pradesh is having a. Can this court?
Yes, because the same question would crop up. The same reason, my lord, would be disturb their lordships, his lordship's mind. Maybe that, my lord, that since the principal order it coming from cause of action is here, Calcutta, why the Arunachal will take her? My lord, I will be, my lord, swindling from here and there, like, my lord, simple harmonic motion.
Let me also go through this point. Let me consider this.
Yes. So, my lord, what should
you are having any judgment on
my lord,
this
I know
point?
I am armed with this judgment in order to show that the High Court can exercise jurisdiction despite there being an existence of Section 22. NGT order can be questioned before your lordship. Number one, if I have crossed this hurdle, now, my lord, second point is that since your lordship is not desirous of looking at the only one order in a segregated manner, then, my lord, I have, my lord, one point that, my lord, this order since merged into this ultimate, so it is within Calcutta. So territorial jurisdictional bar, my lord.
That is only your.
That is, yes, my lord. So, my lord, this is a cause of action. So if it is a cause of action and there is no other cause of action, because, my lord, first of all, the principle of merger. When the court affirms, tribunal affirms the order, it means, my lord, because I cannot say that leaving aside, my lord, the tribunal's order, I am only concentrating on this. Because tribunal's order is the only order. Whether tribunal was correct in dealing with the issue or in the manner, my lord, it has done. Number one. Number two, whether there is an element of perversity. If the perversity is there, my lord, then, my lord, it dismantles the edifice of the judicial reasoning. If that is so, my lord, if your lordship wants me to address and if your lordship wants me to arm with, my lord, I can bring that judgment also in order to satisfy your lordship's, my lord, conscience.
That's the point.
Yes, my lord.
When you will come?
16th of this month. I mean, may it retain its position, my lord, so that I can address. I'm extremely grateful.
Learned counsel for the petition has argued the matter at length.
Should I serve another notice to them?
Yes, if serve the notice.
Kindly record
let
that.
the matter appear on police. Affidavit of service filed with the petition captured the report. In spite of service of notice, none appears on behalf of the respondents. So the petitioners counsel for the petition argued the matter and praised for time for argued at length, but due to paucity of time, the hearing could not be completed. According cases adjourned. let the matter appear on 16th
Millard, I am sorry.
December.
If it is taken up 17, Millard, my junior has submitted.
17 December 2025 under the same heading. In the meantime, the petition is directed to inform the next date of hearing to the respondents to file affidavit on the next date fixed. Come on, 17.
Deeply obliged. Extremely grateful.
Hmm. 11 Lordship, I am for the petition.
Yes.
I appear on behalf of the CS.
Lordship, I am filing my exception.
I just received the exception 5 minutes back. I'll do
Yes,
the
Lordship.
What is the report? Let me see your report.
Manor, I have already submitted
Yes.
my report, Manor.
Temporary structure has go down for restoring used plastic material. It is not
Manor,
intertwined.
with the report, Manor, we have also annexed a photograph.
Lordship, in my exception, Lordship.
Yes.
Learned friend wants a separate connection in this bamboo shade plastic covered.
Lordship, I am not demanding the connection in the said bamboo state structure for the said bamboo state structure. Lordship, the meter will be installed in the existing meter board, not in my premises,
Where
Lordship.
is the existing meter board?
It is installed by the CSC authority. They have already provided connection there, Lordship. I have stated in my report.
Manor, we have already stated in our report, Manor.
In the next premises, Lordship, there is a connection in the name of
The inspection representative petitioner present during the inspection found the petitioner was getting supply from the meter number so and so and so. You are getting the meter number.
Lordship, that is in the name of someone else, Lordship. I have to depend on them to get my Lordship. KMC has issued trade license for my business. I am a separate entity, Lordship, under the KMC.
If
I am the
KMC has done something wrong, Manor, then we also have to do wrong. Manor, this is
I
a
am
block
the-
meter.
I am
My
the
learned
occupier
friend
of the
very
said
much knows, Manor. This is in the name of Subhash Chandra Vishwas and others.
That is a different person, Lordship. I have no relation with them. I am a separate entity, Lordship. I am carrying on my separate business, Lordship. I am handing over one judgment of this honorable court, Lordship. Whether Justice Shobhuchaji Bhattacharya held that it is for a temporary teaching unit, Justice Bhattacharya directed to give connection, Lordship. I am
A temporary teaching unit and
teaching
Manor.
units, teaching unit.
How can we give a meter in
Lordship,
this?
kindly seize the
He cannot, my lord,
the
draw up
unreported
the
judgment.
line, my lord.
Unreported judgment, Lordship.
Come get a copy.
Yes, yes, yes. In that case, Lordship, every unit was a temporary teaching unit, Lordship, a plastic shed structure.
Nowhere it is written a plastic shed.
Paragraph 5. Temporary teaching unit.
Yes, no plastic says is not written.
Lordship, temporary structure was there. And this case also, CSC authorities case is my trust.
Yeah, you are not denied these photographs.
Lordship, I am there, Lordship.
What?
I am
And
there.
my lord, he is
KMC
getting
has issued-
supply.
For the all temporary structure, but in my case, they are not willing
No,
to provide.
that is my establishment, Lordship. I am not denying. That is
Okay.
my establishment. Lordship, all the establishment in the said area is like that, same. And they have already provided connection, and we are demanding the connection in the existing meter board, not in my structure, Lordship. And from there, they will only drag the electric wiring, Lordship.
From where he will drag the
That is-
electric
that is-
coiling in a
that
bamboo
is-
shed structure?
That is
They are getting
that is the
supply,
job
my
of the
lord.
electrician, Lordship.
That is not the job of the CSC.
CSC authority only installs the electric meter in the existing
Let
meter
my
board.
learned take the responsibility if some fire hazard happens.
Lordship, already connection is going on there.
Connection is
in-
there
in
through
the
a
name
block
of
meter,
in
my
the
lord.
name of a separate entity.
Through a block meter, my lord. This is not the connection of individual meters we have not given.
Lordship, as I am the occupier, Lordship, KMC has
Occupier, my lord, if he is an occupier in respect of there is no shed, when we have to give him a separate meter.
Lordship,
My lord,
I am
kindly
not
see
demanding the meter in the said
This is,
stock
my
room,
lord, he
Lordship.
knows that it has to go before the GRO.
Lordship, then let the matter be referred to the GRO, Lordship.
See, anyhow, if he is having the structure, he is having the business, he has having the right of electricity.
Lordship.
It is the essential condition. Correct. You show me what are the conditions for providing the electricity.
My lord, in this kind of places, my lord, it is temporary structure or in Basti culture or in crowded places, my lord, we give connection through block meters. My lord, if you, my lord, may kindly take my report in the first paragraph, the meter standing in the name of Subhash Chandra Bishwas and others. My lord, this is a block meter. Through block meter, there are sub meters through which they are getting the supplies.
Okay.
Man, why
So
we are?
give the submeter to him.
Man, it is already there.
No, no, I
He
have
is
no
getting
sub-
some.
The meter.
He is getting
Lordship,
supply
sub-
through this block.
sub- Lordship, what submeter is a meter, Lordship, the petitioner has to install in his shop room. CSC authority will not install. And the unit consumed will be shown in that.
From that meter, main meter, you give the block meter to him.
Man,
Submeter to him.
Man, submeter we don't provide.
Then
Man, it is not in the domain of the CSC to.
providing the from 1 meter to so many.
Man, I'll tell you a lot.
You're segregating the bills.
I'll tell you a lot.
No segregation, one bills only raised, Lordship.
It is better than my lord, he submits for both the parties.
Lordship.
My lord, how we do it, my lord? In crowded places or marketplaces and bastis, my lord, we provide block meters. Block meters are generally given in one person name and others. So 20 meters. In this case, my lord, I was just going through. There are, my lord, 25 meters. 25 meters are there. My lord, we provide a block meter. We give the connection to the block meters. In one person's name, it is there. We issue the bill in respect of that one person. And from that block meters, there are separate submeters. My lord, I'll take the example of a marketplace.
Correct. That's what I'm telling you. There are submeters.
Yes.
Block meter.
Yes.
From the block meter, you are providing the submeters to.
No, we are not providing. The person in whose name we are giving, they will provide the submeters. So he is already having, my lord, he is getting the connection through this meter. Meter number 6227815.
The name of the Subhash Chandra Bose.
Yes.
Bishwas.
Yes. The submeter, my lord, doesn't have any number, my lord. These around
So who
20.
will provide the submeter?
Submeter will be provided by the Subhash Chandra Bishwas and others.
Lordship, may I?
Through that, they will get the supply. Why we don't give, my lord? Will you kindly see the photographs?
Who is paying the electricity?
The Subhash Chandra Bishwas and others.
And to whom you are paying the amount?
I have no connection, Lordship.
No, this is a wrong statement.
I have no connection.
My lord,
I am appointing a special officer whether you are getting the electric
Lordship.
connection or not.
Lordship.
Because he is telling that you are having electric connection. He is telling that you are telling that you are not having the electric
Lordship.
connection. So I am appointing the special office from the court. Let the inspection be done and whether you are in the gets any electric connection in premises.
Lordship.
And without any notice, surprise, he will visit.
Lordship. Lordship.
The petitioner has filed the present date application praying for grant of electric connection. Police. The Deputy Manager CESC Limited has filed the report stating that during the inspection, it was found that the petitioner was getting supply from meter number 6227815, consumer number 023410230089, standing in the name of Subhash Chandra Biswas and others. Police. Learned counsel for the petitioner submits that in the said report it is also mentioned that the petitioner is using the temporary structure as godown for storing used plastic materials within bracket garbage. Thus, the petitioner is not entitled to garbage. Police stop. The petitioner denied the contention raised by the authority that the petitioner is getting supply. Counsel for the petition submitted, it is a specific case of the petition. The petition is not having any electric connection in his premises. Police. As there is a dispute whether there is any electric connection provided to the petitioner in the temporary structure of the petitioner. Accordingly, this court is of the view one officer, a special officer should be appointed to ascertain whether the petitioner is having any electric connection in his premises. Full stop. Who is the junior member of the bar here? How much? Where is the place situated?
Lordship, this is
it is West Choubhaga Tiljola.
The Tiljola area, Lordship of
There
Kolkata.
only. Who is the junior member? How many years you are in practice?
No, he is not enrolled, Lordship.
Not enrolled.
Minor
How many year?
3 years.
3 years. Yes, you can go and so and so. Give the name and phone number. Is appointed as special officer for the purpose of visiting the premises of the petitioner wherein the petitioner intend to get an electricity connection and to ascertain, number one, whether the petitioner is having any electricity is getting any electricity in the said premises. Number two, whether the said premises is a temporary structure using for a godown or storing of plastic materials.
Lordship, it is used for storing of plastic material. It
You
is
are
admitted.
admitted.
But only first point will suffice.
क्या बोला? To ascertain. Now okay, first wala खाली. Can in this full stop. The special officer is requested to inspect the premises without any notice to the petitioner. But who will identify?
Lordship,
We
may
can
I,
identify if the petitioner have trust on us, we can identify.
Lordship, may I give the number of the petitioner to the
No,
What purpose would this?
That we can.
Any officer of the CSC authority may assist, Lordship. But
the special officer requested to inspect the premises without any notice to the petitioner, but will take the help of the CFC officers for identification of the premises.
Only identification, Lordship.
Identification. Okay. Let the special officer be filed report before this court. How much time? Within a week? Within a week? How far it is?
Tiljola, Lordship, in next to Topshia, Tiljola, Lordship. Area.
By 18th of December 2025. List the matter on 18 December 2025 for filing report and further orders.
Great.
The remuneration of the special officer is fixed rupees 5,000. The petitioner shall pay the remuneration to the petitioner, to the special officer.
I'm grateful.
Grateful.
Let her look there.
May it please your lordship. Well, the petitioner before your lordship is the holder of an excise license by which he is running his restaurant cum bar for the last over 2 years. Now, in terms of the provisions of rule under the West Bengal Excise Foreign Liquor Rules, Rule 239 specifically provides that if any holder of an excise license wants to have any professional entertainment, dancing, singing, performances on the premises of his bar, he has to make a written application before the collector of the concerned area. And the collector will sanction such permission. Only after such sanction is obtained, this permission can be operated by him. Now, in terms of Rule 239, an application was made before the collector of excise, Hooghly. Now, the collector called for police reports. Well, there are, I'll place before your lordship, there are 2 reports. One from the District Intelligence Bureau, which says that yes, for the last 2 years, this restaurant has been operating without any adverse reports. There are nothing of complaint. There are no residential houses besides this establishment.
Not the residential houses, how you are running the restaurant?
No. It usually happens is that people come from places.
Okay.
Now, there are no such things. But so far as the report of the Mogra police station, which is the local police station, they have stated that at present there are no houses, but in future that might come up. And so they have rejected it, though they have stated there is no adverse. May I place the reports before your lordship? For once kindly comes to page 27 and page 28, which are the 2 reports filed by the DIB, Malad Hooghly, where page 27 is the forwarding. May I take your lordship to page 28 for once?
may I place from line 4 of page 28 of the report. During local inquiry, it could be found that there is no educational institution.
28.
Yes, Malad, page 28.
Yes.
Line 4, Malad.
Yes.
During local inquiry, it could be found that there is no educational institution or religious institution or any vital establishments near the above mentioned place. Ongoing through the records, it could be found that there is nothing adverse against the applicant in the PS record and the DIB record. This may be added that there is no apprehension of law and order if permission is accorded for professional entertainment or dance and playing of vocal and instrumental music within that premises. Now, your lordship kindly takes up page 25 and page 26,
Where
which
is
are
your adverse report?
yes, page 26, your lordship. Page 26, may I place the second paragraph?
Yes.
Malad consulted PS records and no such complaint case relating to breach of law and order situation in the locality, in the location where the aforesaid establishment stands is found since the year 2023, when I opened. There is no residential houses in and around the business establishment as mentioned above, but there is every possibility of mushrooming of residential houses at the said location in near future. So entirely based on surmise and conjectures, the districts of Nodia and may I once pause over here. The districts of Nodia and North 24 Parganas are the bordering of Mogra PS. Malad, in so far as this North 24 Parganas is concerned, this area is very close to Kollani Expressway. Now, Kollani Expressway are dotted with various similar types of establishments which already have all these permissions and everything.
Okay,
But over here,
then what has happened?
now, Malad, the page 29 is my order under
Rejected
challenge,
order.
Malad. The collector does not say why the report of DIB is to be considered. It simply says that since Mogra PS has objected, so I am rejecting.
You might not have been visited the PS.
My lord, I leave it to your lordship. There are some things better not said, your lordship. Page 29, if you're is that order, kindly comes to page 30.
Yes.
My lord, the last, I have considered the rival contentions and documents placed before me. The police report, only he speaks of the police report. The police report, in fact, stresses a strong suggestion that grant of proposed permission may lead to untoward incidences. The provisions of Rule 239 as amended does not cast any obligation upon the collector to grant the said permission. In fact, a probable untoward issue, the prayer of the license cannot, I could not understand this meaning. The prayer of the license cannot be allowed and then it is rejected.
Yes. Where is the Rule 239?
Yes. Malad, at the bottom, Malad, of the left-hand side. Left-hand side page, bottom, Malad. In the districts, it's the collector. In Kolkata, it is the commissioner of police.
Yes.
My lord, I beg to appear, my lord, on behalf of the state, my lord. I am just strong. I have the strong opposition. Objection also, my lord, because, my lord, the report says that there is no houses or residential houses. In future, there may be, because it is the highway. My lord, in this regard, my lord, on the coordinate bench, in the coordinate bench of the Honorable High Court, Calcutta, on the various judgments, my lord, it has been passed by the Honorable High Court that possibility, because of national highway, it may not be granted, my lord, because of, my lord, in future, there may be the establishment regarding the construction or whatever.
Have
it
you
is.
gone through the Supreme Court order?
My lord?
Have you gone through the Supreme Court order with regard to the national highway? What is the distance is to be maintained at the state highways and the national highways? What is the distance is to be maintained for grant of the bar license? Have you gone through?
My lord,
Making the submission,
my lord,
taking into consideration in future the national highway come, that's why it is not been granted. Have you gone through the judgment? There is a judgment of the Supreme Court wherein it is mentioned there are two types of the highways. One is the state highway, there another is a national highways. In both the highways, the Supreme Court has categorized what is the distance is to be maintained for grant of the bar license. And subsequently it has been modified. I don't know whether I am not matched up with that.
In the original judgment of 2015 was modified in 2018.
That's why it was modified, but I have not gone through. Please go through it. Please go through it. And second thing, what are the guidelines you have framed? This is the rules and what are the guidelines which you have framed with regard to the grant of the bar license and with regard to the dance and entertainment programs. What are the guidelines with you? Because your officer has only stated that you have given a report. In future, there will be a
construction or residential
and,
house.
settlement of the people. That's why it is not. In future, we don't know tomorrow who will be in the seat and who will be there for the state. We have to go by the as on date.
Yes, my lord. In this occasion, my lord, kindly grant leave, my lord, so that I can get the latest view of
Correct. You see that because I appreciate the bar and we have to avoid that. But it cannot be said that it is not the guidelines of the state authority. No bar license is to be granted. Bar license is to be granted in a strict sense. That's why I asked for the guidelines. I think many of the states were having their own guidelines. That has been went to the Supreme Court, and Supreme Court has fixed the guidelines with regard to the distance of the national highway and the state highway. Please go through it and take instruction and come with the guidelines if any guidelines.
Let me come.
Because that also not been considered by your authority. Correct? Learned counsel for the petitioner has concluded his argument. Full stop. Counsel for the respondent prays for time to take instruction. According case is adjourned, let the matter appear on 18th of December under the same heading. Yes, Mr. Bhattacharya.
Your lordships, permission, may I mention
Yes,
It may retain its position.
So my lord rises. An unusual prayer I am making. That is item number 13. My learned senior friend is appearing on behalf of the state. My lord, only an accommodation for this day. Why I say? Because after recess, my lord, the division bench has already fixed a matter and
Not today.
only not today.
13 not today.
with your
My lord, only prayer is let it retain its position
Yes.
as urgent motion.
with your lordship's permission, if I may mention item 15.
Just a minute, yes.
I'm
So name, having number and email. Very good.
my lord, in item 15, if your lordships will permit, and this is connected, my lord, on the same issue which is being raised in items 71 to 80. My lord, it's a challenge to the West Bengal incentive schemes and obligations in the nature of Grants Act, my lord, whereby the liability of the state, my lord, vis-a-vis earlier schemes has been waived off by them. I'm only praying in this matter, my lord, item 15, notice is yet to be issued. Otherwise, we are on the same footing, my lord, challenging the same statute. Your lordships in the other matters have issued notice and also granted a stay against recovery of any benefits which have already been received by the party. There, my lord, reply was to be filed by the state. I am informed that no reply has been filed. Counter is yet to be filed. So, if your lordships permit, similar orders may be passed, issuing notice and protecting
15, I am appearing for the state, my lord. 15, I am appearing for the state.
Yes, my lord. So, my lord, we are challenging the
Only
same.
16, only 16.
15. Only 15, my lord. 1-5.
1-5.
1-5.
1-5.
So you will file affidavit.
My lord, because the virus has been challenged, the learned advocate general has to appear also in this matter.
Have you issued the notice to the advocate general?
Yes, in fact, my lord, because this matter had travelled up to the Supreme Court on the merit,
Correct.
and my lord, the Supreme Court had passed an order, my lord, essentially, my lord, awaiting, my lord, the outcome of the decision by your lordships. So that matter remains pending.
Item number 15 record karo. Counsel for the respondent fares for time to file affidavit in opposition. Let affidavit in opposition filed by 2 weeks.
My lord, 4 weeks, my lord. 4 weeks, my lord.
Within 4 weeks, reply if any there to be filed within 2 weeks.
As your lordships please, but your lordships may also protect me as has been done in item 71 in your voco, my
I
lord.
don't know what is the protection order in the 71.
I'll just read. If my learned friend is carrying it, he'll just
No, I'm not having, because today is the first date of appearance for this matter.
no, but in the other matters, 71
Other matters,
that
I am not
notice has
appearing.
been issued into the state is the same, my lord. Just show me the order.
But since the virus has been challenged, my lord, the learned advocate general has to appear.
25 list the matter on 4 weeks, 2 weeks, 6 weeks. है ना? List the matter on 22nd of January 2026. In the meantime, respondents are restrained from initiating any proceedings to recover any benefit already granted to the petition till the next date of hearing.
My lord, if not already done, I don't know, my lord. I don't
Yes,
have.
it is there. It is there.
I'm so grateful to you.
It is done, not done. That is not done, not done.
Yes, my lord. Yes, I'm grateful.
I'm grateful, my lord. I'm grateful.
My lord, now I have a leader in the matter, Lord, and I do not know whether it will be right on my part, my lord, to continue, because with him coming in, my lord, I'm in a dicey situation. I'm ready otherwise to argue. It's only this because this is something I've been intimated a day back, perhaps, my lord, to have someone over me. So, my lord, may I only request your lordship then to keep it for.
What is the problem? What is the problem?
My lord, since he's leading me, my lord, because this is the main point which will be argued.
Okay.
My lord, we intend to, my lord, conclude the arguments in one go then. That's the only reason, my lord.
One time.
Yes, my lord.
When?
Huh? 15 days. May I pray for a fortnight's time, my lord? I'm told Mr. S.N. Mukherjee will be leading me in the matter.
Fortnight. Then after vacation only.
We'll come back then after vacation. That will be better, my lord, so that we are better ready in the matter. Lord,
Though the matter is specially fixed today at 2 p.m., but due to personal difficulty, Common Learned Counsel for the petitioner, placed for adjournment, according cases adjourned, let the matter appear. Yes, जनवरी 7-8 तारीख को देखो खाली है 2 बजे.
Hmm? Hmm.
खाली. Then 8 January.
8, my lord. Will
8
come.
January at 2 p.m. is specially fixed matter.
My lord. But I really apologize. I came to know it yesterday. Otherwise, I would have mentioned and indicated because it's a fixed matter. I wouldn't have done that, my lord. I'm very deeply obliged, my lord.
Okay. Yes.
Lord, item number 14, my lord, I beg to appear on the petition, my lord.
I appear for the respondent number 5,
Reserve Bank of India.
My lord, this is a my lord, case. Not the petitioner, my lord, having a current account in my lord, in the my lord, IDI bank. My lord, this bank account has been my lord, debit freezed. My lord, for the reason that one complaint has been made before the my lord, state of Odisha by some person. My lord, these before this state cyber cell Odisha, and my lord, the allegation is that my lord, 25,000 has been my lord, the proceed of 25,000 my lord, come to my account, and this is my lord, allegedly my lord,
Yes.
this is my lord, allegedly my lord, a proceed of my lord, cyber crime, and my lord, my account has been defreezed. My lord, your lordship kindly come to my lord, annexure my lord, P2. But I am my lord, doing business, my lord, my
Page. P2 page.
page 20. My lord, your lordship, below portion, my lord, your lordship kindly see disputed amount.
25,000.
So 25,000, and my lord, remarks, your lordship kindly see remarks portion. Hence, lien recommended.
Where is the remarks?
My lord, remark, my lord.
Hence, lien recommended.
Hence, lien recommended. Now, my lord, complaint reported by state Odisha, and my lord, complainant forward from my lord, one Rajesh Raut. Your lordship got it.
Request to hold the fraudulent transaction reported by the cyber crime department for account number as per the standard operating position attending cyber crime. Yes. Who has made a complaint? Who has given the request?
My lord, yes, my lord, I have given. Now, your lordship, kindly come to the page 23.
Yes.
My lord, in page 23 on 13/5/2024, your lordship, kindly see my account has been credited by my lord 1, 2, 3, 4, 5, 6, 6 lakhs of rupees from my lord Jogomaya. My lord Jogomaya, my lord, my mother-in-law.
1, 2, 3, 4, 5, 6, and 50,000 also.
Yes, 50,000 also.
Yes.
From Jogomaya. This is my mother-in-law. Now, my lord, the allegation is that the amount credited from this part, my lord, the 6 lakhs and 50,000, in that amount, the 25,000 was there, the proceed of crime. That is the allegation that has, my lord, credited to my account.
Where is the 25,000?
But there is no 25,000. But the contention is that somebody made complaint before the Odisha that when the Jogomaya, my mother-in-law, transferred the amount. In that amount, the 25,000 was there. That is the crime of proceed, disputed 25,000. That is the case of the prosecution. Right? No.
Yes.
Now, I have made repeated representations. The lordship kindly see page 28 from page 28.
Yes.
Thereafter, in January 2025, that is page 44. There is a request from Ministry of Home Affairs, India Cyber Crime Coordinate Center to the DGP Odisha.
This one copy of the legal notice. Yes, then.
After that request to Milord, nothing has been done. Thereafter, Milord, the legal notices has been sent. Thereafter, Milord, again, page 63. Same request has been made.
ACP 14C to the DGP Odisha. Yes.
Nothing has been done, Milord. Now, Milord, my account having, Milord, 11 lakhs and odd. Milord, this is a current account. Milord, only disputed account is 25,000. Milord, for sake of the argument, Milord, if somebody says, Milord, these 25,000, Milord, entered me in my account, it is a proceed of crime, a disputed amount, Milord. The bank is required to be, Milord, said lien to the account, Milord. As by my understanding, Milord, lien means, Milord, the claim of 25,000 for, Milord, 25,000 for, Milord, more than 1 year, Milord, my account has been debit freeze, Milord. My livelihood, Milord, in stake.
Okay.
Milord,
yes, who is
Milord,
for
Milord, for Milord, I am.
For removal of the fee, customer will contact the notice the details. The lying fees cannot be removed from the bank saying unless and until bank
From the side of the? Yes, we are appearing for.
Directly before the Reserve Bank of India. Call number 5, my lord.
What is
My
the
lord,
content?
only thing that they have made both the Reserve Bank and the Ombudsman a party. However, they have not approached the Ombudsman, as I find from the records, in a manner as has been prescribed under the mechanism being the integrated Ombudsman scheme. Without doing that, my lord, they have simplicity made the Reserve Bank and the Ombudsman a party. And no representation was never ever made to either the Reserve Bank, my lord.
Milord, I have served my affidavit service.
Service.
I have also served, Milord, through mail before mentioning your lordship, Milord. That is also your. Now, Milord, This is the mentioning that we have said this matter will be mentioned before that we have sent by post and by also mails also. Now subject to Lordship correction
Yes.
There is a judgment of Honorable Division Bench of Bombay High Court in recently 28th November 2025. It says it categorically says the bank account cannot be defreezed in a manner. You should kindly see the judgment. It is relying the judgment of the Honorable Kerala High Court that is affirmed by the Honorable Supreme Court. And our High Court Honorable Justice Sabyasachi Bhattacharya also passed judgment. Now you should kindly see the the first portion. The common question requires to answer whether the investigating authority has power to devil freeze the account under section such and such, Bharatiya Nagarik Sina Act such and such. Now, second paragraph, the reasons why the account are devil freeze is that there occurred some cyber fraud and that part of amount of alleged fraud have been credited to the account of the respective petitioners. Now, there are third paragraph, that is the contention of the bank. The investigating agency has issued a communication to the bank to debit freeze the account of respective petitioner. However, in many cases, in such communication is not issued to the bank. At least the communication is not placed before us by the concerned bank. Some cases communication given, some cases not given. Now, you should kindly come to the paragraph number 5. So far as section 106 of the BNS Act is concerned, it is well settled. The High Court of Kerala, in case of such and such, while dealing with the debit freeze account in an identical situation, took notice of the judgment of Honorable Supreme Court such and such, wherein the Supreme Court held that such power are available by the investigation authority under section 2 of the code, which was now placed in provision of BNS. Now it says now BNS Act says 106 and 107 also. 106 tells about seizure and 107 tells about the attachment. Now you will kindly see thereafter paragraph number 8. Thus, the Kerala High Court, taking note of the subsequent judgment of Supreme Court, held that the court did not contain any provision of seizure of attachment of the proceed of crime, except under Chapter 7A, dealing with the reciprocal arrangement with other countries. The court then took note of the lacuna that occurred in section 102 of the code and observed that the same has been cured by keeping section 106 in BNS, which is akin to 106, and by the section 107 of the BNS Act. Now 107 initially not there. 107 came to the front for attachment provision. Before that, 106 tells about the seizure of the crime proceed and also tells about the this seizure has to be reported by the investigating authority to the magistrate. May I place paragraph number 10? Thus, the Kerala High Court in clear terms held that the police officer investigating the crime has to approach judicial magistrate under 107 of BNS to seek attachment of the property. Any property believed to be delivered directly or indirectly from a crime activity or commission of offence. Subsequently, courts will have to be adopted in terms of order passed by the magistrate. The court has further clarified that while section 106 speaks about seizure, 107 deals with attachment, forfeiture and restoration. Seizure under section 1 can be carried out by the police authority and report submitted to the magistrate. On the other hand, attachment under section 1 can offered only upon order of the magistrate. The logic behind that distinction is that the purpose of seizure is more to secure the evidence during the investigation, whereas the attachment is intended to secure proceed of crime by preventing its disposal and ensuring the availability of the legal procedure as such forfeiture disposal of victim. Now, paragraph number 15. The judgment 12, paragraph number 12 says the Kerala High Court judgment SLP has been dismissed. Paragraph 15, in view of 14, in view of the matter, we may note that here that there is a place of system to deal with the financial fraud, which is titled as Citizen Financial Cyber Fraud Reporting and Management System. This system has been published in Indian Cybercrime Coordination Center, which comes under Ministry of Home Affairs, Government of India. Our attention is invited in FAQ, that is the question, particularly in question number 21, The said question and answer would throw further light to know.
The petitioner has filed the present writ application. Bring for a direction upon the IDBI bank for defreeze the current bank account number 0074102609454 recorded in the name of the petitioner. Counsel for the petitioner submitted that petitioner is having the current bank account in the IDI bank. Which branch?
Branch is Konnagar branch, my lord. IDBI Bank, Konnagar branch in the district of Hooghly.
Which respondent?
At 9.
IDI branch and branch Kabula is having the bank account. IDI branch, Creeper Road, Konnagar, West Bengal. Police. On 13th of May 2024, the bank has kept the current account of the petitioner freezed on the request of the Cyber Cell Department of Odisha Police. Counsel for the petitioner submitted on 13th of May 2024. 13th of May 2024, the mother of the petitioner, namely Jogmaya.
Yes, my lord.
Jogmaya has transferred an amount of rupees 6,50,000. 6,50,000. But without any notice and without any intimation to the petitioner, the bank has freezed the account of the petitioner. The petitioner has made request to the police authority, and the request made by the petitioner was forwarded by the director of Ministry of Home Affairs to the DGP Odisha PHQ Bakshi Bazar, Cuttack, for taking appropriate steps in accordance with law. But in spite of the same, no steps has been taken by the DGP Odisha. Accordingly, the petitioner has made further representation to the police authority and to the ministry, to the concerned authority, including the Ministry of Home Affairs, and the representation was again forwarded by the concerned ministry to the DGP Odisha by a communication dated 7th of August 2025 with the request for taking appropriate steps in accordance with law, but till date no action has been taken by the police authority at Odisha for defreezing the account of the petitioner. Police. Counsel for the petitioner submitted that no illegal transaction has been made in the account of the petitioner, and due to the freezing of the account of the petitioner, the petitioner business. You are a businessman.
Yes, this is current account.
Is facing great difficulties to run his business. Learned counsel appearing for the bank submits that as per the request of the Cyber Cell Department of Odisha, the bank has freezed the account of the petitioner. He further submits that the bank has acted in terms of the standard operating procedure within bracket SOP, wherein it provides that the lien wherein it is mentioned that the lien has been marked as requested by the cyber police in cybercrime portal of Ministry of Home Affairs. Police stop. For removal of lien, customer may contact the nodal police officer concerned. Police stop. The details concern full stop. The lien/freeze cannot be removed from bank's end unless and until the bank receive any written information or NOC from the cyber cell authorities. They submit that if the petitioner will produce the NOC from the concerned author from the cyber cell authorities, the bank will allow the petitioner to operate the bank. Learned Counsel appearing for the Reserve Bank of India submit that the petitioner only had sent a letter but failed to file the complaint in a proper form as provided under the scheme. And as such, the Reserve Bank of India is not in a position to take any action as the petitioner has not made a formal complaint under the scheme. Learned Counsel for the petitioner has relied upon the judgment, unrefuted judgment, in the case of Mr. Karthik Yogeshwar Chatur versus Union of India in criminal writ petition number 321 of 2025 by the Honorable Bombay High Court Nagpur, Honorable Division Bench of the Bombay High Court Nagpur branch dated 20 November 2025, wherein the Honorable Division Bench of the Nagpur High Court, Bombay High Court, relying upon the judgment passed by the Honorable Kerala High Court, passed by the Kerala High Court in the case of Headstar Global Private Limited versus State of Kerala and others within bracket criminal miscase MC number 3740 of 2025 dated 2nd June 2025, wherein the Kerala High Court held that a police officer investigating a crime has to approach jurisdictional magistrate under section 107 of the BNSS to seek attachment of any property believed to be derived directly or indirectly from a criminal activity or commission of an offense. Full stop. Subsequent course will have to be adopted in terms of the order passed by the magistrate. The court further clarified that while section 106 speaks of seizure, section 107 deals with attachment, forfeiture and restoration. Full stop. The seizure under 106 can be carried out by the police officer, an ex post facto report submitted to the magistrate. On the other hand, attachment under section 107 can be effected only upon order of the magistrate. The logic behind the distinction being that the purpose of seizure is more to secure evidence during investigation, whereas attachment is intended to secure proceeds of crime by preventing its disposal and thus ensuring its availability for legal procedure such as forfeiture of distribution of the victims. Full stop. The number next. The judgment passed by the Kerala High Court clearly make it clear, judgment High Court make it clear that the debit freezing account is not permissible under section 106 of the BNSS. BNSS. Police. The order passed by the Kerala High Court was also challenged before the Honorable Supreme Court in SLP, being SLP criminal number 13433/2025, where the Honorable Supreme Court denied to interfere with the said judgment. Considering the above, this court finds that in the case in hand, the considering the above, this court finds that in the present case, on the basis of the instruction of the cyber cell department, the bank has kept the account of the petitioner in lien. And in the account, it is recorded that the disputed amount is rupees 25,000. The bank has taken the stand that unless and until no objection has been obtained by the petitioner from the concerned police authority, concerned cyber cell authorities, it is not possible for the bank to defreeze the account. But the legal position is otherwise. The bank has not produced any document before this court that the cyber cell department of Orissa has produced any order of the court passed under section 106. What? Magistrate order is there, 106.
No.
Then, there is no record produced by the bank to show that the cyber cell has produced any order passed by the magistrate allowing the cyber cell department to freeze the account of the petitioner. Considering the above, this court finds that the cyber cell department, without obtaining the order from the London magistrate and without following the procedure as prescribed under section 106 and 107 of the BNSS, has directed the bank to freeze the account of the petitioner, and the bank has freezed the account of the petitioner, which is not in accordance with law. Accordingly, the freezing of the account of the petitioner on 13th of May 2024 is set aside and passed. Full stop. The bank is directed to allow the petitioner to operate the bank account being number so and so. Full stop. It is made clear that this order will not prevent the police authority or the cyber cell authority for taking appropriate steps in accordance with law if necessary for freezing of the account of the petitioner. Who decide disputed? Who decide? Who will decide?
My lord, one indulgence. Perhaps my lord was kind enough to record that only a letter was sent to RBI, my lord. No communication was ever made to RBI.
Okay, sir. The RBI has not received any communication.
My lord.
उसने बोला ना, the RBI stated that he has only made a communication, but not only record. The RBI stated that no communication has been made by the petitioner with the RBI.
আমার ব্যাংক অ্যাকাউন্ট আমি চালাবো
Hey, notice is out, nobody's come. Court will not go to the police office. Then you are appearing. I will record your name and I will record your submission. And I will regularize your appointment in the Orissa police.
ডিপলি অ্যাপ্লাই
So, affidavit of service filed by the
সেই জন্য 25,000 টাকার জন্য 11 লক্ষ টাকার অ্যাকাউন্ট
petitioner none appears on behalf of the police authority, cyber cell authority of the Orissa. Yes, next.
What of like that?
Yes. Which matter?
15, my lord.
15 is already passed. What do you want? Name who has taken the dictation? I don't know. Give the name. It will be. See who has taken the dictation. Before where? Before recess. Yes. Who is for the 16?
For 16, I'm for the petitioner, madam.
Yes.
Affidavit of service.
Yes.
Well, the petitioner is a partner of a firm who is required to carry voluminous amount of cash after business hours and after banking hours. So, my lord, due to the transit and due to keeping such huge amount of money in his house, my lord, he is seeking protection, he is seeking personal safety and protection of his business assets. He has applied for arms license, my lord.
Arms license.
Arms license, my lord.
What? Gun or revolver?
My lord, gun,
Gun.
gun, my lord. But he has
Double barrel or single barrel? Yes.
He's asking for the pistol. It's a single barrel. Single barrel.
Yes.
My lord, well, only for protection of the business assets and the personal safety, my lord.
What has happened? Rejected?
My lord, not rejected, but not issued yet, my lord.
What is the rejection order? Where is the rejection order?
There is rejection. There is no order passed only, my lord.
No. Your application is pending.
Pending, my lord. Application is
Whether
pending.
police verification is done.
Police verification.
There is so many things are there for grant of license.
Possibly my learned friend is not aware, Millard. After the police verification has happened, Millard, we have conducted a hearing whereby Millard, the petitioner himself was present. Millard, we could not find the substantiate Millard present to Millard grant him the license. So Millard, we have rejected his prayer. Now Millard, so far the relief are concerned, Lordship may kindly take trouble to see Millard, the Arms Act. I would like to handing over. There is a statutory appeal is also there.
Correct.
Lordship knows far better than I. Millard, in that event, Millard, this is appealable.
As per Arms Rules 2016.
Have you got the order?
Lord, we have not got the order yet, my lord.
You do one thing.
I will be.
You saw the copy. I am disposing of this. The petition is liberty to challenge the order.
Yes, ma'am.
If you agree by the order,
As
take
per
appropriate steps in
yes,
accordance
So
with
great.
law.
So
grateful,
so,
my lord.
so,
You saw the copy.
right now, Millard.
You are appearing for the state authority. You give the copy to one copy here also.
I will be Millard, printing out and will give it to you.
Learned Council, you are for the state.
I am for the state.
Learned Council for the state. Submit that on receipt of the application filed by the petitioner for grant of license. For grant of license.
Will kindly
arms license.
Have a look in this order.
For grant of arms license to the petitioner, comma, the authority. क्या बोला? Arms license to the petitioner, comma, a police verification was conducted. Police verification was conducted, and on receipt of the report from the concerned police authority, comma, personal hearing was also been done. Personal hearing was also been given to the petitioner, and after hearing the petitioner in person, comma, the authority, the district magistrate Nadia found that at the time of found that the additional superintendent of police
Ranaghat Police District Nadia had submitted a report not recommending the case of the petitioner. Not recommending the case of the petitioner. Accordingly, police on query, it was also the authority, the district magistrate also find that there is no threat of life to the petitioner in India, and as such, the district magistrate has rejected the request of the petitioner for grant of arm license to the petitioner. The counsel for the state respondent has supplied the copy of the order to the learned counsel for the petitioner and also hands over the same to this court. Let the same be cut. Give it to the. Let the same be cut.
I may mail to
As the authorities already passed
Oh, mail ID.
police learned counsel for the state further submit that as the authorities already passed an order by rejecting the claim of the petitioner, and he submit that the order passed by the concerned authority is appealable order, and as such the writ is not maintained. Considering the above, this court find that when the petitioner has filed the present writ application, no order was passed by the authority. After filing of the writ petition, the authorities have passed the interim order. Now this court find that nothing remains in the present writ application. Accordingly, a writ application is disposed of. However, the disposal of this writ application is dismissed. However, the dismissal of the writ application will not prevent the petitioner for taking appropriate steps if the petitioner intend to challenge the order of the concerned authority wherein the request of the petitioner was rejected before the appropriate authority or court in accordance with law.
And we have already communicated her by way of email. We have already. May I take back the point?
Yes.
17. My lord, petitioner is present, my lord. She does not want to proceed with this application, my lord.
Yes.
Because, my lord, being victimized by some broker, my lord, relevant documents has not been annexed with the writ petition.
What is the case? What is the case?
My lord, issuing of passport, my lord. My lord.
To whom?
To our children, son and daughter.
Son and daughter. Yes.
My lord, being victimized by some broker, my lord, the birth certificate was procured from another place, my lord, it was attached with the writ petition.
I submitted the report on behalf of state, my lord, that the birth
But that is
certificate
not
was not issued by the concerned municipality, and we have received that intimation along with my report. I have submitted before your lordship.
Where is the report you have submitted here?
Yes, your lordship. On the last edition.
I have the real certificate, original certificate, but corporation didn't give me the real one. That's why. সত্যি কথাটা কেন না আমি কেন ফেক সার্টিফিকেট ইচ্ছে করে বানাবো? আমাকে কর্পোরেশন দিচ্ছে না বলেই তো আমি বানাবো।
Yes.
My lord, one was born in Kolkata and the other was born in
That's why that's the difference. Where he has produced the document showing that the son was born on Avinash Datta maternity home.
Yes, I was forced by someone to make this.
You are appearing
because
or your advocate is appearing?
My lord,
I have the original certificate.
She has been victimized by some broker, my lord, on that area, my lord. And
No,
she
that's
did-
why whether you are representing, you make a submission. If she is appearing in person, she can make a representation. You first you decide who will appear. You will appear or the petition in person will appear.
কি করবেন আপনি বলবেন বলুন
Sir, I have the original certificate for here. My daughter was born in Shishu Mangal, Kolkata, West Bengal. So my certificate, original certificate, has damaged. That's why I was trying to collect the one fresh copy of this birth certificate for corporation here, SN Banerjee Road. They was harassing me still now, and they didn't give me the real certificate.
What is the prayer in the writ petition? Who has filed the writ petition? You filed the writ petition. Who filed this writ petition?
Sir,
Polumi Datta, what is your name?
Polumi
You filed
Datta,
this.
yes.
What is your prayer before this court? What do you want?
Sir, please just give me one scope for applying for new passport with the real original certificate, birth certificate.
Original birth certificate.
Yes.
What is your prayer in the writ petition?
Sir, passport.
Passport. So birth certificate. Why the birth certificate? You have prayed for the passport.
Yes.
So what is the problem?
Birth certificate, sir. Original birth certificate, sir.
Yes, sir. What is that? Have you already taken action? When she has applied for passport? When you applied for the passport?
A few months before.
What is the date of the application? Page 31. Fresh given name Ethan Datta. This is the first son. Ethan Datta is son. And 41. Where your son born?
Allahabad.
Huh?
Allahabad.
So how you obtain the birth certificate here? Who has issued the birth certificate?
Yes, I have the original.
Where is the original birth certificate?
And this original.
Who is Ritika Yadav?
My daughter.
Who has cut down? Who has corrected this birth certificate?
No, just my husband.
No passport is given.
By either parent, by either parent. No, but here the problem is that the question of the birth certificate. Where is your son, children?
At
Where is your
home.
daughter?
At home now.
Or with your husband?
My husband is a cancer patient, and he was living at Allahabad, Uttar Pradesh.
Where is the divorce? Where is the matrimonial suit?
I did divorce petition, but I withdrew that case. Divorce
When you have
case
withdrawn?
after.
When you have withdrawn?
Before a few months ago.
Where is the order of the withdrawal?
That's
There is nothing here. Where is the order of withdrawal?
petition. Yeah.
And how you can this you will be prosecuted. If I will pass an order, then you will be in difficulty. Deserted. Are you fine? That's why I'm asking. Are you gone through? You're not residing with your husband.
No.
Where are your children?
At home with my home.
With whom?
With my mother.
What the children do? They're going to school.
Yes.
Which class?
My son is in LKG and my daughter is in 5th standard.
So how you are maintaining the children?
With my mother.
What your mother do?
My mother has rental income.
Huh? What income mother is having?
Rental income.
You want to proceed with the petition? No. You want to withdraw?
No, withdraw.
You want to withdraw?
Yes.
That's why. No.
Sir,
if you're not
sir,
seen
please
your,
liberty to file a fresh passport.
you know, madam, first you correct your the birth certificate of the children. Otherwise, you will be in trouble. I am telling you.
Yes, I must do it.
Who has cut down all the names in the original birth certificate?
My husband, sir.
Then
My husband.
with the you. Whatever that is.
Sir, please give the liberty for fresh applying.
The petitioner has filed the present writ application for direction upon the respondent number 2 and 3 to issue passport to the minor son and daughter of the petitioner. When the matter is taken up for hearing, the petitioner is appearing in person. The petition is appearing in person. Full stop. The petitioner filed this. Okay. Full stop. Counsel for the petitioner prays for withdrawal of the present writ application with the liberty to file a press. Accordingly, WPA number 21498 of 2025 is dismissed as withdrawn with the liberty to file a press. Yes, next.
Lord, I'm appearing for the petitioner led by Oyan Banerjee. That on the last occasion, this is that matter with regard to IVF, my lord.
The appeal is pending.
My lord, there is no stay in that appeal. There is no stay in that appeal.
Maybe, but the appeal is pending.
Appeal is pending, my lord.
And appeal is pending, and yesterday one matter has come. The Honorable Division Bench of the Kerala High Court has.
My lord, yes, I have gone through that Kerala High Court judgment. My lord, it's an interim order.
Maybe, but this court having sitting in a single bench has to take the decorum of the court. Once this court has found that the division bench has stayed the order not by this court, that the order of this court has been considered by the single bench while passing the
that order. My lord, my lord.
that matter is fixed on 22nd. So I am fixing on 22nd. The other matter is fixed on 22nd.
Fixed one?
The similar matter yesterday it was fixed, so I fixed on 22nd of December.
My lord fixes it up on 22nd.
Let the matter appear on 22nd December under the same heading. Next.
Lovely.
I am for the petitioner.
My lord, this is my lord. The petitioner before your lords is filed an application for my lord issuance of scheduled tribe certificate before the my lord SDO in terms of the my lord Act my lord under Rule 4. My lord, application has been admitted and my lord acknowledgement slip has been given. As of date, my lord, it has not been my lord decided by the my lord subdivision officer in terms of the my lord Act. My lord, the fact of the case is this, my lord, the child mother is the my lord ST community and father my lord belongs to my lord general caste. My lord, by of a decree of divorce, when the child was 2 years, my lord, the decree of divorce was granted by between the father and mother. Thereafter, my lord, the child is residing with the community of the my lord mother, who is belongs to a my lord ST community. To get benefit of all these my lord things, my lord, the child has applied before the my lord SDO for my lord issuance of my lord ST certificate. But that application has not yet been decided by the subdivisional officer. As of date, this is the my lord present subject matter of the instant read application. My lord, now, my lord, kindly direct the my lord SDO to my lord decide the applications, my lord, in terms of the my lord Act, my lord, by issuing by my lord invoking provisions of my lord 4 and 5. And if my lord SDO if SDO needed, my lord, there is a provision of section 8 also to my lord form a inquiry team and inquiry report. That is my lord subject matter of the SDO's concern. My lord, first of all, my lord, SDO has to decide applications.
As per law.
Let the SDO be directed to my lord decide my applications. My lord, whatever will be the fate that will be subject.
I will not stand in the way. That's what I.
SDO is the authority.
Yes.
SDO is the authority. If your lordship
No,
kindly.
there is a local our act is there, na West Bengal. What?
Yes,
act?
West Bengal Identification Act 1994. My lord.
I'm lord section page 20 and 21. 21 is the lord the for my application is 21. Acknowledgement is lord page 20. But if lord, if the court directs the authority to consider, I will not stand in the way. But my lord, section 1, your lordship will say section 4, section 5, section 8. As per law. Yes.
Law.
Yes. The law.
Section 5A, my lord, kindly. At a boy.
The biological father is not belonging to the scheduled caste.
That is decided by the Supreme Court. I
No.
this judgment also.
Yes, you place the judgment for the appropriate authority.
So let them decide.
Yes.
No, there is a prescribed authority.
Yeah. Prescribed authority. A subdivisional officer, I'm not in accordance with law. If inquiry is required, inquire. That's the, if not the law provides inquiry will be made. As per law, your lordship kindly direct
the.
But
of the
and not the your lordship kindly record one line subject to correction. The allegations, if any, not deemed to be denied because I am not using the application.
The grievance of the repetition in the present application. Petitioner has applied for grant of scheduled caste certificate, scheduled tribe certificate before the concerned authority, and the same was duly registered on 24th of July 2025. But till date, the concerned authority has not considered the application filed by the petitioner for grant of scheduled tribe certificate. Accordingly, press for a direction upon the authority concerned
Respondent number 4. Consent for disposal of the request made by the petitioner for grant of scheduled type certificate. Learned counsel for the state submits that though the petitioner has made an application which was also admitted on 24th of July 2025, accordingly, if a direction is given to the concerned authority, the concerned authority will dispose of the same in accordance with law. Consider the submission made by the counsel for the respective parties. This court find that at the land counsel of the respective parties, this court find that no purpose should be served by keeping the writ petition pending, as the petition has already applied for grant of scheduled type certificate, but the same has not been disposed of by the concerned authority. Accordingly, the sub-divisional officer.
Yes, Lord. Respondent number 4. Respondent number 4.
Mednipur.
Mednipur.
Accordingly, the sub-divisional officer, Mednipur Sadar office at Mednipur is directed to dispose of the application filed by the petitioner.
Page 21.
Petitioner, which is appearing. Petitioner on what is the date of your application?
24/7. Page 20, your lordship will find.
24th of July 2025, in accordance with law. If the authority find that the petitioner is entitled to get the scheduled type certificate, the same can be issued on compliance of all formalities within a period of 6 weeks. 6 weeks from the date of receipt.
Make it 8 weeks, not instead of 6 weeks.
8 weeks. 8 weeks from the date of receipt of the copy of this order. And if the authority find that the petitioner is not entitled to get the scheduled type certificate, the authority shall pass speaking and reason order
and communicate
the same within a week thereafter.
And let your lordship kindly record that your lordship has not gone into the merits. All points, sir.
As the petitioner, as the petitioner
No, merit is
disposed of
joining.
at the motion stage and no affidavit is called for, this court has not gone into the merit of the matter. The authority is free to take all decisions without influence of the order.
I'm deeply obliged.
Next.
My lord, I appear for the state in this matter. My lord,
Yes.
Please, I was harassing by some brokers, so that's why I withdraw my
Go
case.
to the other court. This court is not having determination. Go to the other court.
my lord, kindly, my lord,
Police protection, other court. Correct.
kindly, my lord, takes up the prayer.
Please liberty for the applying for.
I already
fresh
given. Liberty given.
No, passport for passport.
Yes, liberty given to file a fresh.
Thank you. Thank you.
Kindly, my lord, the prayer once at page 15. Just for a moment.
Page 15.
Yes, my lord. My lord, prayer A at the bottom, my lord. Kindly sees, my lord, it is prayed that a writ on the nature of mandamus or writ of any other nature or direction commanding the respondents to forthwith consider and allow the petitioner's application dated 30th May 2024 for conversion of nature of land in respect of LR Dag number such and such from Danga to Danga Bastu. My lord, my first point is, my lord, this is pertaining to the, my lord, determination of group 1.
Absolutely not, because of prayer B. I am seeking for a quashing.
What quashing?
Quashing of an, my lord, this
Same
member.
law.
My lord, this is one matter.
My lord,
First of all,
remembers.
the other points are there.
No, my lord, remember that I had shown that judgment, my lord, Shobhasachi Bhattacharya's judgment, wherein, my lord, regarding the wetlands, there was one judgment from NGT which they had misinterpreted to show that there was a blanket stay for registration in 4 mojas and also for conversion of the land. Justice Bhattacharya was pleased through that judgment, saying that this blanket ban cannot be upheld, and the notification regarding registration was set aside. The same thing on the same day, 118 was regarding memo number 118
It
was
is the
regarding
merit of the matter.
registration, and regarding 119 that notification.
No, see, what you have prayed for.
Yes.
Kindly
First prayer is with regard to the conversion of.
Yes,
I am grateful.
My lord would not grant that. My lord would grant me prayer B. I am happy.
that
My lord
is-
quashes that.
My lord, that is also
Quashes,
my lord, because it pertains
quashes
to
that.
conversion.
That is a notification. That is a notification
But
by
those,
the
my lord,
BLR
the writ
saying
rules
that.
of this honorable court, my lord, it pertains to the group 1 determination.
No.
Where is the order? This.
And my lord, so far as my lord, the other issue is there, my lord, I have another point of maintainability.
Now, where is the 30th October order?
That is at page 40.
Page 40.
Yes, 39 and 40.
Compliance of the order passed by the Green Tribunal, hereby requested to initiate or not to initiate, and yes.
Yes, I've sought for both 39 and 40 both. My lord allows this to press, I am happy.
My lord, I oppose this, my lord. My lord, so far as, my lord, the group determination is concerned, kindly seize, my lord, the group 1 determination. My lord, anything and everything, my lord, concerning a land and, my lord, especially conversion.
Dispute about land ceiling regarding Bagra.
Miscellaneous is also there, lordship.
Yes, land and including the land laws.
My lord.
That is not regarding, he did not pass it under the West Bengal Land Reforms Act.
My lord, the application is made under the Land Reforms Act. Kindly seize. My lord, he is missing this.
Which law the conversion of the land?
Kindly
is to be
seize page
passed?
36.
That is under fifth. That is under West Bengal
Under
Land
which
Reforms.
land? Under
But
which of?
under Land Reforms Act.
Correct.
But I am ready to forego my prayer A. My lord passes prayer only sees my prayer B and C. That is not under any land laws. And the notifications that were passed, they were not under this act. They were passed outside the act.
My lord, kindly seize page 36 of his writ petition once. This is, my lord, his application for change.
I am again saying he does not have, my lord do not grant me mandamus. My lord would cause these two notifications and set it aside. Then my application will go through.
I put a question to myself, my lord, how? It definitely pertains to, my lord.
Starts where your case starts from where?
Well, my case starts from the
conversion only.
No, my case starts from notification, because this notification, if these notifications do not are not there, if my lord quashes this, then my conversion application will go
Where,
through.
where is the notification?
Well, 3940, page 39 and
Issued by
40.
the, my lord,
3940.
Yes.
the BL and LRO. Oh.
And then the district magistrate.
39 and 40.
Yes, page 39 and page 40.
40.
Well, 39 just says because of page 40, I cannot give you conversion. And page 40 is by district magistrate.
Correct.
Not even the BLRO.
See, 39 is again the conversion not
Grateful, my lord. I'm
But
grateful.
the reason is 40. The reason is 40.
40.
Not
Complaints of the order of the Green Tribunal, so and so. The state of Bengal requested to initiate and proceeding related to the record correction and conversion. Again,
yes.
I'm grateful.
My lord, that was not an order under Land Reforms Act.
This court find that the writ application, and this court is not having the determination to decide the present writ application. Accordingly, WPA number 23493 of 2025 is released from the list of this court with the liberty to the parties to mention before the appropriate court having the determination.
Grateful, dear.
Liberty may be given to correct the form. My lord, that has to be given. My lord, otherwise, it won't be taken in group 1. My lord,
You go.
My lord, I'll just explain. If I do not correct, if my advocate on record does not correct that form, my lord,
No.
that has to be given. They will not take.
Release, you go to the secretariat and ask the assignment.
I'm grateful to you.
My lord, may I just say one thing? My lord did not release it on personal grounds. They will come and, my lord, the only question is
Releasing on for want of determination,
want
as I
of
have.
determination. I will be asked what is the determination. I have to say group 1. If the group 1 is not mentioned, my lord gives me only liberty, my advocate on record, to correct it on the cost title. Just
Sir.
group 1. But that liberty is given.
Court is released. Court is released. You know where. You go and ask the secretariat and you mention why I should give this.
But it is
liberty.
given as a.
You decide where it is to be mentioned.
I'm grateful. Thank you. Here's the PH here.
I have a lot of leave to mention for inclusion, my lord.
With original side.
My lord, may I have your lordship's kind leave to mention, my lord, for extension of interim order. My lord,
When the interim is
my lord, on 19th, my lord, it is expiring, my lord. My lord, kindly,
18 to be mentioned, मेरे को.
my lord, kindly keeps it on the 15th, my lord, if it is. Kindly keeps it on the 15th of
Why?
next week, my lord. My lord,
Auspicious day on 15.
my lord, I'm being led by Mr. Deepan Sarkar, my lord. So,
Interim order, you want the senior. Come you. I want you to argument the matter.
This is that matter, my lord. Your lordship had passed a decree. Pursuant to the decree, my lord, in terms of your lordship's order, we've made the payment, they've received the payment. This is only recording that, my lord, that application we have taken out in terms of Order 21, Rule 2 of the Code of Civil Procedure for recording satisfaction of the decree.
Lordship, I'm appearing on behalf of the defendant number 1. Before vacation, your lordship has directed to exchange the affidavits. However, the affidavits is ready but could not be affirmed yet.
What is the application? Who has filed the application?
We have filed the application. If you
The misconceived application, first of all, lordship.
my lord, my application, I am not understanding, my lord.
I am dismissing this application, holding that you have already paid and you accepted with the full satisfaction. That's all.
Kindly appreciate the fact that I would be very honest with your lordship that I have already filed an appeal.
Filed an appeal.
Filed an
Oh,
appeal.
you raised all question
Filed
before
an
the
appeal.
appeal.
And kindly keep it because
You accepted the amount.
Yes.
My lord, he has written to us that kindly pay me, and we have paid also. My lord, kindly see paragraph 7 of my application. The remittance details is there.
Client lordship kindly, and I have just
We have no communication from our client.
just received the information from the client. There would be change of the briefs. The advocate on record, the learned advocate on record would give.
So what you want?
Kindly keep it after 1 week.
For what?
The instruction and
I will record the submission of Mr. Roy Chaudhary.
My submission and kindly keep this application so we can.
Why?
Because I do not have the instruction from the client. The advocate on learned advocate on record would give.
No problem. When the other advocate will come, they will pass an application.
Also kindly.
My lord, this is just a bogey. I'll tell your lordship what they have done.
Just kindly record that an appeal has been filed and my rights and
Okay.
contention of
Okay, I will record. The
without prejudice to my rights and contention in the pending appeal being APDT 20.
you are the plaintiff.
Yes, my lord, he is the plaintiff.
No,
He's saying
here, Fox and Mandal, you.
No,
I am the plaintiff.
My lord, we are the plaintiff.
The plaintiff has filed the present application being GA 7 of 2025, praying for a recording of satisfaction of the decree by the plaintiff by paying the decretal sum of rupees 1,07,03,773 to the defendant number 1. To the defendant. Counsel for the plaintiff submit that in terms of the judgment passed by this court dated 28th of July 2025, the plaintiff has paid the total amount of rupees 1,07, kitna tha? To the defendant number 1, and defendant number 1 has received the said amount with full satisfaction. Counsel for the defendant number 1 submits that the defendant number 1 has already prepared an appeal and prayed for adjournment. This one?
Wait for okay. You
Wait for adjournment.
Yes, keeping this application alive, Lord.
Wait for adjournment. Consider the submission made by the counsel for the respective parties. This court find that in terms of the judgment passed by this court, that plaintiff has paid the total amount and the defendant number 1 has already received the total amount with full satisfaction. Thus, nothing remains in the present application according to GA 7 of 2025 disposed of.
Look, this is allowed, my lord.
Disposed of.
Kindly record. Because unless it is allowed, my lord, they will contend, my lord, that your lordship has not granted this prayer.
Already.
My lord,
Kindly record that without prejudice to my rights and contention.
What?
I have no instruction from the client, lordship.
Next. Item number 2. Yes,
Well, that in the morning I mentioned that by mistake it has come as adjourn motion. It should become.
हाँ वो ये काम करो एडजॉर्न मोशन चले गया Appellate से। What is item number?
Item 32.
Item 32.
Give the slip. Give the slip. It will be taken tomorrow as adjourn motion.
As a urgent motion.
Urgent motion. ये इसको yes urgent motion में आएगा कल. Yes, call them.
Well, this is an application for setting aside. My lord had heard it, my lord, on one or two occasions. Well, your lordship may remember that, my lord, your lordship occasion to deal with this, my lord, at the section 36(2) stage. My lord, the question which, my lord, occupied your lordship at that juncture was only as to whether, my lord, there is, my lord, fraud or corruption, my lord, surrounding the making of the award. And, my lord, that is what your lordship had confined to. My lord, the matter had thereafter travelled up to the Supreme Court, and the Supreme Court has, my lord, said that, my lord, the 34 will be decided uninfluenced by, my lord, the observations made by your lordship. Of course, my lord, I must mention it by way of passing that, my lord, the law has since undergone a change. In fact, my lord, there's a very recent Supreme Court judgment where the Supreme Court has now said that, my lord, unconditional stay of operation of award is no longer only dependent on making out a case of fraud or corruption. Today, if you can show that, my lord, there is something that goes to the root of the matter, which would otherwise mean that something, my lord, on which the award can be set aside, and, my lord, prima facie the court is satisfied about that, that would also operate as a ground for unconditional stay of operation of the award. But unfortunately, that judgment was not available to us when your lordship heard the matter. So, my lord, we didn't have, my lord, the privilege of that.
What has happened to the execution going on?
Execution is going on, my lord. Section 47 is there. My lord, we have also, my lord, furnished security. So, my lord, to that extent, my lord, I think, my lord, the court was satisfied because we have furnished security by way of immovable property and, my lord, also details of our bank accounts. My lord, your lordship will remember that today the claim is almost 3,000 crores against, my lord, government. Now, my lord, two things your lordship will, my lord, also.
Then the interest also increase.
Yes, yes, of course. My lord, provided, my lord, I can persuade your lordship that, my lord, the award needs to be set aside. And I would imagine that, my lord, there are good grounds in this case. My lord, so far as this matter is concerned, my lord, one very important thing is, my lord, the positioning of the parties and the award. Well, your lordship will remember that, my lord, the claimant in this matter was, my lord, Chatterjee Petrochem. And, my lord, the respondents were really twofold. My lord, one was WBIDC and the other was the state of West Bengal. Now, my lord, there is no award against WBIDC. The award, my lord, is only against the state of West Bengal. Secondly, my lord, there is, my lord, no, my lord, arraying of, my lord, the Haldia Petrochemical as a party. And, my lord, I don't know, my lord, how the award will be now executed, my lord, without Haldia being a party, because, my lord, it is Haldia who is supposed to be, my lord, paid the incentive, which is a subject matter. But, my lord, without going into that, may I first, my lord, formulate my points, and then, my lord, I shall bring your lordships back to, my lord, the papers. My lord, the first point, or, my lord, may I just once show your lordship the agreement once again? It's been a long time, and then, my lord, come back and formulate my points. My lord, please have a look at, my lord, the agreement out of which, my lord, the entire dispute arises. Volume 3. That your lordship will find at, my lord, page 107. My lord, which I believe is a part of this volume 3. Volume 107, this should mean volume 3.
353.
What do I have then?
This is the award. You're showing the agreement.
Okay.
Volume 2.
I'm sorry, my lord. I'm sorry.
That is the award.
That's sorry, my lord, 353. 353. My lord, first your lordship will notice that, my lord, the agreement is entitled the share purchase agreement. And, my lord, this is, my lord, not a case where, my lord, the substance will, my lord, override the form. It is, my lord, in substance, in form, my lord, in character, a share purchase agreement. That is, my lord, the primary purpose of this agreement. My lord, the date is important, 11 September 2014. This is shown to be the effective date. Now, my lord, the first, my lord, party is West Bengal Industrial Development Corporation Limited. Why West Bengal Industrial Development Corporation? My lord, because this is the entity which held shares my lord, in Haldia Petrochemical Limited. Then, my lord, your lordship will find. Then your lordship will find the next, my lord, party is Government of West Bengal. Now, my lord, West Bengal Industrial Development Corporation is defined as the seller. WBIDC, the seller. That your lordship will find in bold. So far as the government is concerned, government is, my lord, the second party. Now, my lord, this assumes great deal of importance because, my lord, the share purchase agreement is, my lord, necessary between the buyer of the shares and the seller of the shares. So the seller is, my lord, WBIDC, the buyer is, my lord, Chatterjee Petrochem. But, my lord, government is, my lord, really in the nature of a pro forma party here because the government is not.
Remember, you are in middle.
Yes, I'm in middle. Yes, of course. But, my lord, your lordship finds that, my lord, ultimately, my lord, there are two parties, my lord, who really have, my lord, no role to play in this, my lord, buying and selling of shares. One is, my lord, Chatterjee Petrochem Mauritius. I'm sorry, one is, my lord, the government of West Bengal, and the next is Haldia Petrochemicals. Haldia Petrochemicals is the entity whose shares are held by WBITC, which is going to be sold to Chatterjee Petrochem
Through its affiliate.
my lord, through its affiliate, my lord, Essex Development Investments Mauritius. Now, my lord, your lordship will thereafter, my lord, please have a look at, my lord, one or two very important things.
No, the West Bengal Industrial Development is the seller.
Yes.
That's right. Correct. And the purchaser is the Chatterjee Petrochem.
Right. Well, lord, Chatterjee through its affiliate,
Yes.
my lord, which is called Essex Development
Essex and
Investments.
Haldia Petrochem.
Well, lord, that is, my lord, Essex Development is, my lord, described as the purchaser.
Purchaser, yes.
So, my lord, sale and purchase of shares is confined to only these two parties.
Correct.
Yes. Now, my lord, it is the shares of Haldia Petrochemical that is being sold, and, my lord, it is ultimately being facilitated through the government of West Bengal.
Yes.
Now, my lord, so far as this is concerned, your lordship will now, my lord, have a look at, my lord, what is being sold, what is the subject matter. My lord, please have a look at, my lord, clause C at page 355. As on the execution date, the authorized share capital of the company, my lord, that is Haldia Petrochemicals, is such and such, and, my lord, the paid up capital is such and such, so that will not trouble your lordship with that. Then, my lord, the next, my lord, is your lordship will find that, my lord, the purchaser is incorporated in Mauritius, the seller of the shareholder in the company and is owned and controlled by government. My lord, now the history of, my lord, the transaction which is narrated in this agreement becomes very important. My lord, kindly allow me to, my lord, show your lordship that. At the time of its incorporation in 1985, HPL was promoted by WBIDC and the RP Goenka Group, with each having equal shareholding. By 1990, the RP Goenka Group exited the project and was replaced by Tata Motors Limited and Tata Power Company Limited. HPL was granted industrial license in November 1993. On or about the second quarter of 1994, Dr. Purnendu Chatterjee evinced interest in participating in HPL. Accordingly, WBIDC, CPMC, which is Chatterjee, and Tata entered into a joint venture agreement dated 20th August to implement Haldia Petrochemical project. HPL plant was commissioned by August 2001. Soon thereafter, the company was in dire need of funds, leading to a liquidity crunch. HPL was in need of financial managerial restructuring. For achieving this objective, this is, very important. This is where, Chatterjee comes in, evincing an interest to, ultimately control the company. And, kindly see, all this starts from the year, 2002. For achieving the above objective, the government of West Bengal agreed to put CPMC in management and control of the company and agreed to transfer such number of shares to CPMC so as to ensure that CPMC has 51% shares in HPL. So, Chatterjees were to be given ballot control. On that date, transfer of 155 million shares would have made CPMC 51% shareholder in HPL. Accordingly, the government of West Bengal entered into the agreement dated 12 January 2002 with CPMC. Further, WBIDC, CPMC and CPIPL, an associate of CPMC, entered into an agreement dated 8 March 2002. So, there are agreements entered into in the 2002, which would put Chatterjees in management of the company with 51% shareholding. Thereafter, with the joint efforts of Government of West Bengal, WBIDC and Dr. Purnendu Chatterjee, CPMC, a financial restructuring was successfully negotiated with the financial institution led by IDBI as the lead financial institution. A corporate debt restructuring package approved on 22nd January 2004 and formally placed on record by CDR Cell by its letter dated 12th February 2004. India Trade Mauritius Limited subscribed to 107 million equity shares worth 107 crores in HBL. Now, Indian Trade Mauritius Limited is also a part of the Chatterjee Group of Enterprises. So, my lord, your lordship sees agreement to acquire 51%.
You would continue, no?
It will continue, my lord. It will continue for the rest of the day, but well, I was wondering if your lordship can, my lord, hear me till 4 o'clock today. Your lordship has fixed it tomorrow and day after also.
Very well, then we'll come back at 4 o'clock.
Okay. Now, my lord, what is very important is 2002 agreement to acquire 51% holding. My lord, 2004, my lord, 107 million equity shares are acquired.
This 107 is over and above.
My lord, this 107 is over and above the 51%, my lord, 155 million shares. So, my lord, that would have put them completely in the driver's seat. Now, my lord, on 30th July 2004, the company, CPMC, the seller, and Winstar India Investment Limited, sub-account Winstar, sells SEBI sub-account such and such, a nominee of CPMC entered into a share subscription agreement. Person to Winstar agreed to subscribe to equity shares of the company at par. Some of the other associates of TCG were also allotted certain shares in HBL. So, my lord, we first have ITML subscribing to 107 million shares. Then, my lord, we have Winstar, which is also part of the Chatterjee Group of companies. My lord, subscribing to, my lord, shares at par along with some other Chatterjee entities, and this happened in 2004. So, since 2004, pursuant to an agreement to acquire majority shares since 2004, the acquisition process has started. Further, CPMC, WBITC, Government of West Bengal, and the company entered into a supplemental agreement dated 30th July 2004, by which certain terms of the January 2000 agreement were amended. The Board of Directors of company in their meeting held on 2nd November 2004 decided to induct IOC as a shareholder in HBL. This is a very important event.
Oh, I see.
Yes. Well, because
directors of the company in the meeting held on so decided to induct the IOC. Okay.
Yes, as a shareholder. So, my lord, it was agreed that IOC would be brought in as a shareholder and IOC would infuse the required funds in the company. On 14 January 2005, representatives of the Government of West Bengal and CPMC signed a one-page document which recorded that the Government of West Bengal shall sell its entire shareholding in the company to CPMC. The price of the shares to be sold was to be determined by independent valuer selected by the Government of West Bengal from among a panel of firms suggested by CPMC. Now, my lord, why is this important? My lord, your lordship finds in 2004, IOCs, my lord, agreed to be brought in as a shareholder. Then in 2005, following, my lord, discussions, it is agreed that the entire lot of shares will be sold to CPMC. And, my lord, to that effect, a one-page document is signed. So, my lord, from 2002, agreement is to take over the company. 2004, shares are, my lord, subscribed. 2004, my lord, ITML subscribed shares, Winstar subscribed shares, etc. 2004, it is decided that, my lord, IOC will be inducted. Then, my lord, the agreement is abandoned, plan is abandoned, and 2005, it is agreed that the entire shareholding will be sold to CPMC. My lord, why I say this and why this is recorded in this particular agreement is to, my lord, give the background of the transaction as to what were the circumstances which ultimately prevailed, my lord, which led to the entering into of this agreement. On the same day, an extraordinary general meeting of the company was held, where the shareholders by an unanimous vote approved the resolution to issue an allot.
So if on 14 January, Government of West Bengal has given the entire share.
Agreed to.
Agreed
to give the entire share.
Provided they were to infuse certain funds.
Agreed to share. This was because they had said that you don't need Indian Oil Corporation. We'll bring in whatever funds are required. Because the idea was to save this company.
They didn't bring.
Now, then, on the same day, an extraordinary general meeting of the company was held, where the shareholders by an unanimous vote approved the resolution to issue and allot 150 million equity shares of the company to IOC at par. Now, my lord, what had happened is, my lord, after the decision, my lord, to give them the entire shareholding, my lord, they, my lord, reneged on their obligation to bring in funds. So, Well, an extraordinary general meeting of the company is held and the decision is taken to allot 150 million shares to IOC. Now, my lord, in or around July 2005, certain disputes arose between CPMC on the one hand and the seller and Government of West Bengal on the other hand in relation to the sale and transfer of the entire balance shareholding of the seller in the company, aggregating, my lord, 519,900,002 equity shares and allotment of 150 million equity shares to IOC. In the course of the proceedings, the seller, Government of West Bengal, also disputed CPIPL's claim to the ownership of 155 million shares. Now, my lord, kindly remember, my lord, first, my lord, agreement is to give them 155 million shares, which would give them 51% stake. Pending, my lord, the enforcement of that agreement, 107 million shares are, my lord, allotted to, my lord, ITML. Then, my lord, some shares are allotted to Winstar and other, my lord, group companies. Then there's an agreement to bring in Indian Oil Corporation. That agreement, my lord, there's a flip-flop. We agree then to sell the entire shares to Chatterjee. Chatterjee does not bring in the money. We again agree to sell 150 million shares to IOC. Now, my lord, what is the dispute that now arises? My lord, the dispute which is recorded, my lord, in this paragraph P is, my lord, in July 2005, because your lordship will see in January 2005, my lord, the one-page document was, my lord, signed by which the, my lord, entire shareholding was agreed to be transferred.
So dispute arises from the P.
Yes, July 2005.
Correct.
Now, my lord, January 2005, we agreed to sell the entire shares to
Correct.
Chatterjee. Then, my lord, we agreed to sell, my lord, 150 million shares to IOC.
Correct.
And, my lord, in July, there's a dispute. Now, my lord, this is very important. What is the dispute? In or around July 2005, certain disputes arose between CPMC on the one hand and the seller and Government of West Bengal on the other in relation to sale and transfer of the entire balance shareholding of the company, of the seller means WBIDC, seller in the company aggregating to 519 million shares and allotment of 150 million equity shares to IOC. In the course of the proceedings, seller and Government of West Bengal disputed right of CPL to, my lord, claim ownership of 155 million shares because, my lord, the relationship broke down. They wanted, my lord, the entire shares. My lord, they also, my lord, wanted to stop the sale of 150 million shares to IOC. And, my lord, we then said that since you have not brought in the money, you are not even entitled to the 51% shares that we had agreed we'll sell to you in 2002. But what is very important is, my lord, they challenged, my lord, the government's right or WBIDC's right to sell, my lord, 150 million shares to IOC. Now, CPMC and its associates had initiated proceedings against WBIDC and the Government of West Bengal under Section 397 of the Companies Act on 2nd August 2005. Aforesaid proceedings under Section 397 of the Companies Act culminated in a Supreme Court judgment on 30th September 2011. In 2011, the Supreme Court judgment upheld the decision of the Calcutta High Court. Well, it said, 397 proceedings are not maintainable. Well, because this is a private dispute with regard to sale of shares by one, shareholder to, another intending shareholder. It has nothing to do with oppression and mismanagement of company, so dismissed.
And this judgment also said that Chatterjee, if he had not committed breach.
Well, incidentally, this judgment of the Supreme Court also had records that, if Chatterjee had not committed breach of its financial obligations, this situation would not have arisen. Well, that is recorded in the judgment, but that is not germane to the present issue. After the 2011 Supreme Court judgments, CPMC invoked arbitration under the January 2002 agreement. The dispute relating to 155 million shares was referred to arbitration before the International Court of Arbitration at Paris. Well, this is, the 2002 agreement by which it was agreed that, 155 million shares representing 51% of the shareholding would be transferred to Chatterjee Group. They lost, in the company law board, they lost in the Supreme Court, then, they invoked arbitration.
So this arbitration was for 155 million shares. They did not do anything about this 5. Settled.
Well, arbitration was, only confined to 155 million shares, 51%. But your lordship will remember they wanted the entire stake. Proceedings were initiated by the company in Calcutta High Court to restrain the arbitration, and arbitration proceedings were restrained by the Calcutta High Court. From May 2012, the matter was carried to the Supreme Court by a judgment dated December 10, 2013. The Honorable Supreme Court directed the parties to contest their claim before the arbitral tribunal. Government of West Bengal insisted initiated. Now, my lord, since this was confined only to 155 million shares, the balance shares were still available. And my lord, the government was desperately in need of funds. The government of West Bengal initiated an open and transparent competitive bidding process in 2012 to offload its entire stake in the company to an entity capable of reviving and restructuring HBL. Pertinently, the company was in critical financial position and in dire need of financial restructuring in order to sustain the livelihoods of hundreds of thousands of people directly and indirectly dependent on the company. Now, my lord, this is very important in the agreement because, my lord, what was the object of, my lord, this open, transparent, competitive bidding process in 2012 to offload its entire stake? It was, my lord, to revive and restructure the company, which means, my lord, the agreement acknowledges that as on the date of this agreement, my lord, the company was in need of, my lord, restructuring. And, my lord, it also records that the company was in critical financial position and in dire need of financial restructuring in order to sustain the livelihood of hundreds and thousands of people. Now, my lord, just pausing here for a moment, my lord, whoever, my lord, wanted to buy the shares of the company or were invited to buy the shares of the company at that point of time knew that the company was in financial doldrums. Now, my lord, it would be for them then to say, yes, I want to buy the shares, and, my lord, take upon myself the obligation and liability of, my lord, restructuring the company's finances, or I don't want anything to do with the company. My lord, this background assumes a lot of importance in view of what has transpired in this matter. Indian Oil Corporation was declared the winning bidder, having quoted a price of rupees 25.10 per equity share for the stake held by the government of West Bengal. The bid process and the steps taken pursuant thereto were challenged by CPMC before the Calcutta High Court in various proceedings and appeals therefrom. A list of legal proceedings pending before the Calcutta High Court and the Supreme Court are fully described in Part B of Schedule 1 to this agreement. On account of the extant orders, quote, the bidding process did not fructify. My lord, kindly also pause here for a moment. Again, very, very important. 155 million shares in arbitration. The balance stake to be sold. 520. Why? My lord, that is 520 million. Why? To, my lord, restructure the company's finances because the company is in dire need. At that point in time, my lord, who opposes the sale? IOC comes forward and says, I'm prepared to give you 25.10 without any strings attached. I will buy the entire 525 million shares. I will assume control of the company. Now, my lord, the price is, my lord, discovered in an open auction process. 25 rupees 10 paise per share for 520 million shares. Who opposes this? My lord, Chatterjee.
He gets a stay from this court on the ground
My
that
lord,
one-page agreement.
he, my lord, ultimately, my lord, initiates a spate of litigations, which is recorded here in the agreement. And he, my lord, obtains a stay for which, my lord, the bidding does not ultimately fructify. My lord, this is very, very important because, my lord, this fixes the consideration for the shares through an open and transparent bidding process. It is not, my lord, a fancy price. It is a price discovered through an auction mechanism. And, my lord, they do not want IOC to acquire the shares because they say it is our right to acquire these shares. Then, my lord, next. In the meantime, the financial position of the company had taken a further downturn, and the accounts of the company were turning into non-performing assets with the lenders of the company. An urgent and limited restructuring was carried out to avert reference to BIFR under Section 15 of SICA. The company, however, continues to face imminent danger of closure in case of no further infusion of funds for recapitalizing and for working capital needs. The lenders during the meetings with the company and the promoters insisted the dispute be resolved expeditiously. Now, my lord, they prevent, my lord, the sale of shares to IOC. My lord, in the meantime, the company is going from bad to worse. My lord, so therefore, ultimately, there is a settlement that has to be reached because otherwise the lenders will take over. In such scenario, that is, my lord, paragraph W. This is where, my lord, the whole thing culminates. In such a scenario, Government of West Bengal has informed TCG that in order to protect the overriding public interest, considered TCG's proposal dated 1st March 2014 for purchase 520 million equity shares of the company out of the Government of West Bengal's stake of 675 million equity shares, and broad understanding was reached between TCG has informed that it has agreed to purchase 520 million shares for purely commercial reasons. Now, my lord, please mark this word, for purely commercial reasons. Now, my lord, what is this? Well, there's a settlement reached. What is the settlement? Well, 675 million shares, Well, 155 is in arbitration, 520 to be sold. And well, what does TCG say? Being fully aware of the fact that IOC was prepared to buy, it obstructed IOC's purchase. But it says, I want to buy this for purely commercial reasons. Now, this is a recording in the agreement, and we have to give credence to every part and parcel of the agreement. Parties have agreed that the government of West Bengal shall offload 520 million shares to TCG and its affiliates on as-is where-is basis at a price of 25.10 per equity share. Well, why 25.10? Because this is the discovered price. IOC had offered this price. IOC had offered this price without any strings attached. It did not want incentives, setbacks, rollbacks, refund, nothing. And it is to be sold on as-is where-is basis. These expressions are extremely important. They could not have been ignored for any reason whatsoever. One is discovered price, sold, to be sold on as-is where-is basis.
Correct.
Now, then your lordship will see, and this is made further clearer. Basis at a price of 25.10 per equity share discovered through the transparent and competitive bidding process. The said consideration comes to rupees 13,060 million. Well, this
1,300 crores.
1,300 crores approximately. 1,300 crores. Parties have agreed to bring to an end all legal proceedings except the arbitration proceeding before ICC Paris, pending before various courts and fora. Parties have now agreed to the terms and conditions based on which they are entering into this agreement for reviving and restructuring HPL. Now, this agreement is intended to do what? Revive and restructure HPL. Who will restructure it? Chatterjee. How will they restructure it? By acquiring majority control of 520 million shares. They are not giving up their right to even the 155 million shares which they are pursuing in arbitration. What is the price? The price is on an as-is, where-is basis, 25 rupees 10 paisa, which is a discovered price. Now, this background is very important because now your lordship will find that an attempt has been made by Chatterjee to say that no, 1,300 crores we had agreed to pay for the shares, but you had agreed to also give us incentives to the extent of about 2,600 crores, which would mean 3,200 crores, which would essentially mean that I give you my shares and I get nothing for it. On the contrary, I have to pay for it. Now, we have to judge every agreement on the basis of the commercial efficacy that it seeks to serve. And I will be addressing your lordship also on the question of interpretation, because the interpretation of a contract is within the arbitrator's domain. But there are several judgments now where your lordships have held that where the interpretation is so absurd, where it is contrary to law, where it is a reading of the document by ignoring essential terms, then that is perversity in the matter of interpretation of the contract. Now, this is the background which is very important. Now, your lordship will see some of the important clauses of the agreement.
Some of the definitions first.
Please have a look at
1.1.39. 1.1.39. Transaction.
Your lordship will first have a look at, I will not trouble your lordship with most of the clauses here. 1.1.39, this defines transaction. Now, the transaction is the transaction which is the subject matter of the agreement. Transaction means the sale and purchase of shares as specified under this agreement. That is the only subject matter of the agreement. And when we talk about an agreement and talk about a transaction which is the subject matter of the agreement, we are looking at the consideration for the contract. There cannot be any contract without consideration. And here, the consideration is specified, is exact, and it is discovered through a mechanism. 25.10 rupees per share for 520 million shares.
So then also see 1.1.33.
Your lordship will now, please also in this regard, have a look at 1.1.33 per share consideration. This is the consideration for the contract. This is just a few clauses above. Per share consideration means the amount to be paid by the purchaser for purchasing one equity share pursuant to this agreement, being an amount of 25.10 per share. Now, so therefore we have 25.10 per share, which is the consideration for the transaction. The transaction is a transaction to, my lord, sell 520 million shares.
Correct.
It is to be sold at a discovered price on as is where is basis for commercial reasons. Now, my lord, thereafter, your lordship will, my lord, please see. Well, let's skip over, my lord, some of the, well, lord, other definitions which are not really relevant at this moment.
Two definitions more. 1,300 crores was to be paid in two tranches. First tranche exactly half 600 crores.
Yes, my lord. One more, my lord, important part. My lord,
1.25.
my lord, your lordship will please have a look at 1.1.25 once. My lord, the share consideration was to be paid in two tranches. 1.1.25.
Yes.
Well, as this, my lord, 1,300 crores was to be paid in two tranches. First tranche purchase consideration means, my lord, 650 million.
650.
My lord, the first tranche sale shares has the meaning ascribed in clause 2.1. Now, my lord, 2.1, your lordship will see. Well, that is at page 365.
Half of 520 exactly.
Now, this is the first tranche sale. 2.1, based on the mutual representation made, assurances, warranties, covenants, and undertakings given by the parties, and subject to the fulfillment of conditions precedent provided in clause 3 below, the purchaser shall purchase from the seller, and the seller shall sell to the purchaser 260 million, that is the first tranche said shares, upon payment of the first tranche purchase consideration by the purchaser.
Which we saw the definition around 600.
Now, my lord, that is, my lord, half of 1,300 crores, about 650.
The second tranche.
Now, my lord, this is very important because, my lord, your lordship will find here that, my lord, the first tranche sale was to be made, my lord, upon, my lord, the lordship will kindly see, upon, my lord, the conditions precedent being fulfilled in clause 3. Now, my lord, what are the conditions precedent in clause 3? Please see page 366. So, sale of 520 million shares in two lots. First tranche is 650 million shares. And, my lord, the consideration is fixed. It is to be paid, my lord, as the first tranche sale. And, my lord, there are conditions precedent to be fulfilled before the first tranche sale happens. And that is recorded in clause 3. Now, my lord, what are the conditions precedent?
2.1.
Yes, my lord.
Based on the mutual representation made assurance, so purchasers are purchased from the seller, and the seller shall sell the purchase 2,260.
That's it.
Thousand.
That is half of 520.
Upon payment of the first tranche.
Yes. Now, my lord, this says.
So, no, the first tranche now 1.1.25.
That is the first tranche.
That is the first tranche is
Yes, ma'am.
6,530 million.
That's right.
Correct. So here is a 2,600.
260 million.
260 million.
That's right. First tranche. Now, my lord, what does this say? My lord, the first tranche, your lordship will see. My lord, this says that based on the mutual representations, assurances, warranties, and subject to fulfillment of the conditions preceded provided in clause 3.
Correct.
Now, my lord, what are the conditions preceded? Now, why do I say this? Before the sale of the first tranche shares, my lord, if the conditions precedent do not provide for payment of any incentive, any refund of tax, then, my lord, that is not, my lord, in any manner hedged to the sale of the shares. That is why I want to show you, lordship, what are the conditions precedent accompanying the sale of the first tranche shares. That's paragraph clause 3.
Yes.
The obligation of the purchaser to purchase the first tranche sale shares is subject to and conditional upon the fulfillment prior to or simultaneously at the first completion or at the time specified below of each of the following conditions. So, my lord, the obligation of the purchaser to purchase is dependent on the fulfillment of these conditions. What are these conditions? The warranties made shall have remained true and correct with the same force and effect on the first completion date as if such warranties were made anew and as on the first completion date. There shall have been no breach of any covenants contained in this agreement or by any of the warranties contained in this agreement. The company shall have obtained all requisite approvals, including from the lenders of the company in relation to the transaction, including change in management, transfer of sale shares, amendment of the charter documents, and change in the capital structure. TCG shall extend its full cooperation to enable the company to obtain such approvals. The company, seller, Government of West Bengal, and the purchaser shall have performed and complied with all agreements, obligations, and conditions required to be performed and are complied with pursuant to this agreement. The company shall have duly attended and carried out all corporate procedures that are required under the applicable law in connection with the transactions contemplated hereby, including the approval from their board for the execution and delivery of this agreement, and the performance of the transactions, the transfer of the sale shares, and other transactions contemplated hereunder. The purchaser shall have received a certificate of a director of the company, attaching copies certified by such director or officer as true copies, true and complete, of the resolutions of the board approving the agreement and authorizing and approving the execution, delivery, and performance of this agreement. The purchaser shall have received a certificate of a director of the seller attaching copies certified by such director officer, etc., etc. Then, my lord, the seller and Government of West Bengal are not a part.
Conditions.
Now, my lord, what is important is none of these, my lord, make any, my lord, whisper of, my lord, any obligation to, my lord, pay any incentive or, my lord, refund of tax. So, my lord, the first tranche will go through, will be completed, the shares will be transferred without, my lord, any corresponding obligation on the part of the government to give any tax incentive or, my lord, to make any tax refund as a condition for sale of the first tranche.
Yes.
Now, my lord, the question is, well, if this was not a condition for the first tranche, could it be a condition for the second tranche? Now, my lord, thereafter, your lordship will please see, my lord, 2.2. My lord, first tranche, my lord, is mentioned. Then, my lord, the purchaser shall, without the prior written approval of Government of West Bengal, WBREC, be not entitled to nominate in its place and person or entity to purchase the first tranche sale of shares. So, there will be no nomination, you will purchase it yourself. Then, my lord, I have shown your lordship the conditions precedent. I don't want to trouble your lordship with that anymore.
Second tranche, 6.1.
Then, my lord, your lordship will, my lord, please have a look at, my lord, actions pending first completion, clause 4. That is at page 369.
Yes.
Now, my lord, even here, my lord, I don't want to read it. My lord, your lordship will see that there is no mention of, my lord, any incentive or, my lord, any tax refund.
Yes.
Only if your lordship sees, my lord, what is the requirement? 4.2 at page 370. My lord, from the effective date through the first completion date, the company will carry on business in the ordinary course with due care and diligence and in the manner and scope carried on as the effective date. Without prejudice to the generality of 4.2.1, company shall not and the seller and TCG shall ensure the company does not, without prior written consent, transfer, encumber shares, etc., etc., etc. So, my lord, this is the first tranche, and, my lord, this is, my lord, ultimately referred to as first completion in clause 5.
And date is important. The first tranche happened on 28th of August, on 31st December 2015. That date may be.
My lord, the first completion
or the
first, my lord, of the first tranche, my lord, happened. Your lordship may make a note, 31st December 2015. That is when the first lot of shares was sold.
When?
31st December 2015. So, my lord, the first tranche of shares were sold without any problem.
On 31st December
2015. This agreement is 2014.
Yes.
Now, they had an option to exercise the second tranche within 2 years, but during this period came the GST regime. So they got the second tranche without any debt.
Now, my lord, then, my lord, your lordship will remember that the GST regime, my lord, kindly just bear this in mind, the GST regime came in on the 1st of July 2014.
2017.
Where?
Well, I'm sorry, my lord, let me, my lord, just go through this, my lord. My lord, after first completion, what will happen is mentioned, again, my lord, not really important. They will take control of the company after the first tranche. And then your lordship will, my lord, please see. My lord, this is how.
This is the second tranche.
My lord, the second tranche will happen. Additional sale of shares, that is clause 6. This is the second tranche at page 376.
Page?
My lord, 376.
Yes.
Now, my lord, your lordship will see At page 376, there's a chart.
Yes.
Well, the chart represents as to what will be the shareholding position at the completion of the first tranche. And here you lot will see, well, the purchaser, well, with the purchase of the first tranche immediately becomes owner of 15.40%.
That is the first one.
Yes.
2 crores. Sir.
Then, well, Chatterjee becomes, well, is already, well, 25.65. ITML is 6.35. Winstar is 7.55. Well, this, well, if your lordship adds up, well, it brings it to, well, more than 51% already. Now, well, with the completion of the first tranche, even while pending adjudication of the rights over the 155 million shares in arbitration, they already acquire majority control.
So this has happened during the pendency of the arbitration.
Yes, this is arbitration is a separate chapter altogether.
Correct.
And that
So
was
this
yes,
has
but-
arbitration.
Yes,
That was a different arbitration. not
that
this
was a different arbitration, but not this arbitration.
no, not this earlier.
Yes, that arbitration is going on in Paris. That ultimately resulted in an award against us. That's a setting aside application made, jurisdictional issues, whether it will have to be in Paris, whether in India, and now the matter is before the Supreme Court.
Pending.
Yes.
Supreme Court has stayed execution. They said
Supreme Court has stayed execution. It is considering now because the very peculiar case was governing law is Indian law. Seat of arbitration is Paris.
no, venue was Paris. seat is Calcutta.
Venue was Paris. Seat is Calcutta.
Calcutta.
Seat is Calcutta. Venue is Paris. Governing law, Indian law.
Arbitration agreement, Indian.
Arbitration agreement governed by Indian law.
Courts at Calcutta.
Arbitration agreement, provides courts at Calcutta will have jurisdiction. But because we wanted to challenge the award in Calcutta, Chatterjee comes and says, no, you have to do it in Paris. And that is the dispute between seat and venue. Notwithstanding fact that it is Indian law that governs, one of the parties is Indian. Calcutta is really the
Subject
center of the
matter is here.
activity. The matter is now before the Supreme Court. Now, what is very important is with the closing of the first tranche, they acquire more than 51% shares. Because your lordship will see who are the balance shareholders. WBIDC is only about 24%.
This is the second.
15 and 9.
This is the arbitration wala 155.
Now, here, when your lordship sees WBIDC, 15.40% is what will be the second tranche. And this 9.19% is what is in arbitration.
Correct.
And then Tata Motors has only 1.33, Tata Power 1.33, IOC only 8.89, lenders have 7.58, etc. So at the end of the first tranche or the first completion, they already are in the driver's seat.
Finish.
Now, the question would be, if today they are already 51% shareholders, without any corresponding obligation to do any further act as a as precursor to closing of incentives, etc., then whether the second tranche is something that will invite that, particularly in view of the fact that it is clearly only a share purchase agreement for 520 million shares at a discovered price of 25.10. Now, there, after that, please see second tranche. Additional sale shares. The purchaser shall have the option exercisable at any time within a period of 84 months. Now, 84 months is roughly how many years?
7 years.
7 years. The purchaser shall have the option exercisable at any time within a period of 84 months from the first completion date to purchase 25.99 billion, this is the additional sale shares from the seller, against payment of per share consideration for each additional sale share, aggregating to this is a balance 653 million.
Exactly the same amount, exactly the.
So exactly equal first tranche, balance is second tranche. Same money, same consideration. In the event the purchaser or its nominees exercises the purchase option for the additional sale shares or any portion thereof within 2 years from the first completion date, the additional purchase consideration pro rata the portion exercised shall be paid. However, in the event the purchase option is not exercised or exercised in part, additional sale shares or the portion remaining shall be purchased in 5 equal yearly installments beginning from the commencement of the third year after the effective date, along with the interest at 9% per annum reduced by the dividends, if any, received from HPL, etc. So what it says is you have the option to buy the balance shares within 7 years. If you exercise the option within 2 years, well and good. Otherwise, you will pay interest on the balance sale price at 9% per annum, which will be adjusted against the dividends that the government may receive. In the case this option or right is not exercised by the purchaser at the end of each year as above, WBIDC shall have liberty to sell pro rata 1/5 share. Well, what it also is, this is also very important because it says that in case you don't exercise the option to purchase the balance second tranche of shares, then pro rata government will have the option to sell it to others.
Sell the pro rata 1/5 of the additional share.
Yes, 1/5 of additional share, of the additional share on the unpurchased portion remaining thereof. 20.
Correct.
Neat and clean. There is the question of
Now,
making
there
any
is
of
no
it
hedging this with any incentive or any refund of tax.
neat, clean.
So if you don't buy it, I'll sell it to someone else. And there the question of incentive refund will not come in. Pursuant to the acquisition of the additional shares, the purchaser of the shareholding structure will be as follows. Now, once the additional shares are purchased, then please see, ultimately they become 30 plus 25 plus 9.19 plus
More than
6.35,
70.
more than 70%. And then, again,
the second tranche is exercised by them, and the date is it is 28th August.
now, the second tranche is completed on the 28th of August 2018.
2018?
Yes. Long before, much before the 7-year period kicked in. So, they were in a hurry to complete the acquisition of the shares. Price was fixed. Shares were determined. First, conditions precedent were ultimately gone through. First tranche of shares had been acquired. Although they had 84 months to complete the second tranche, they completed soon thereafter. Because the first tranche your lordship had seen was completed in 2015. By 2018, the complete purchase of the second tranche.
Now, during this period, the GST regime can be stopped. When they were
Now,
taking the second
between
tranche,
before 2018, on 14th July 2017,
That's what I'm telling, because it is 2018 completed. In the meantime, GST has.
yes, in the meantime,
1st
GST.
July 2007,
Now, they acquired the second tranche.
without any demur or protest.
Second tranche without any demur, without any objection, without any.
When it was completed?
28th August 2018.
2008.
2018. Yes.
And we had stopped refunding. We had stopped paying from 1st July 2017 on.
Now, I'll show you, lordship, what now, became the subject matter of dispute. Now, please see, up to now, your lordship has seen, the first tranche and the second tranche.
Correct.
This is, comes to an end at clause 6. Now, the ICC shares are, the shares that are in arbitration. That is clause 7.
150.
I'll not trouble your lordship with this because this is, only mentioned as a, attending fact, but nothing more. Then, clause 8 is, very important. Representations and warranties of the seller and the government. This is, what now becomes the subject matter of dispute. But, the question is, whether this representation or warranty was a consideration for the sale, was a part of the contract for sale and purchase of shares. And, this, has to be determined in the context of the fact that since 2002, Chatterjees were gunning for the shares. In 2004, they acquired particular tranche. They went to court in arbitration saying that I want the 155 million shares. They prevented IOC from purchasing the shares. They started a whole spate of litigations to stop IOC. IOC had said that I'll take over the shares without any conditions attached at 25 rupees 10 paise. They agreed to take this entire thing at 25.10. Now, the mention of this, the question is, whether this can therefore be a part of the contract for sale and purchase of shares. Because, your lordship is enforcing, now, the object was to enforce a contract. Now, I have, cited before the tribunal, and I should be showing your lordship the judgments also, judgments which says that in one document, there may be a representation of promise which is not a contract. Because here, the contract is only a contract for sale and purchase of shares, which they wanted, irrespective of anything. They were desperate to get these shares. They stopped IOC from buying the shares. So, they did not, want to give up the right to shares for any reason whatsoever. Now, this representation and warranty by the government, the question is whether this can then be a part of the consideration, because this does not mention, the agreement does not say it is consideration. Now, my lord, please see, seller and government of West Bengal hereby
It is not
represent
a part of the agreement.
part of the agreement document. Now, my lord, let us understand. My lord, the transaction has been defined.
Okay, that your
The consideration for
consideration transaction.
so, my lord, that is my lord contract.
Correct.
My lord,
That part has over.
now, my lord, the question is, what is this? What is the consideration for this, my lord, if this is to be a contract?
Regarding the presentation.
That's right.
What you presented.
No, my lord, my representation, my lord, what it is a my lord promise. It's an unenforceable promise. Well, your lordship sees, my lord, when I give an incentive or I promise an incentive, well, at best you can enforce this through, my lord, the claim of legitimate expectation or, my lord, promissory estoppel. Now, my lord, that is a promise. It does not mature into a contract. That is why, my lord, instead of enforcing it as a contract, your lordships, my lord, ultimately have devised the doctrines of promissory estoppel, doctrines of legitimate expectation. Why not? Why? Because, my lord, these are not contracts. These are only promises. Some promises can be enforced. What promises can be enforced? When a promise is, my lord, ultimately a promise on the basis of which you have altered your position to your detriment. That is the, my lord, sum and substance of the doctrine of promissory estoppel. If, my lord, I make a promise and you do nothing, and you have not altered your position on the basis of that promise, then you can't say that I am stopped from resiling from that promise. Then I may resile from the promise also. But the fetter comes in only when, on the basis of my representation, you have altered your position to your detriment, which, but for my representation, you would not have done.
Okay.
Now, my lord, that is where this becomes important. I'm not saying it is not a part of the document. Of course, it is a part of the document. It's there, my lord, in bold, my lord, printed letters. But the question is whether this constitutes a contract and what is the language. Now, my lord, let me read the language of, my lord, this representation and warranty. My lord, representation and warranty, my lord, lords, you'll find there's no mention of any consideration, unlike in the case of the sale and purchase of shares. Seller and government of West Bengal hereby represents and warrants to the purchaser that subject to and except as disclosed, the following representations warranties are true and correct as of the respective completion dates. Title to the equity sale shares WBIDC is legal and beneficial, etc. Well, not a problem. WBIDC is duly incorporated, not a problem. Agreement duly, etc. Well, these are not a problem at all. Then,
so their case in arbitration was that we have reached 8.4 and 8.5.
Then, my lord, lordship, please see, my lord, 8.4. The seller and the government of West Bengal have the requisite capacity, instructions, and authority to enter into this agreement and the obligations hereunder. Execution and delivery of this agreement and performance of the seller and the government's obligations hereunder, including transfer and sale of shares, have been authorized by necessary action on the part of seller. Agreement has been duly executed and delivered by the seller and government of West Bengal, constitutes a legal binding valid agreement. Then, my lord, here your lordship will see. 11. My lord, now, my lord, your lordship sees, my lord, this is first representation and warranty by the seller and the government. My lord, these representations and warranties are largely with regard to, my lord, their right to the shares. Then, my lord, there are representations and warranties by the company. These are representations and warranties of HPL. Well, I will not trouble your lordship, not important. Then, my lord, representations and warranties of the purchaser. That's clause 10.
Okay, now you stop here.
Very good.
The counsel for the petitioner has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear tomorrow at 3.
What is 3:30?
3:45.
Great.
Your Lordship, Mr. T.G. Chakraborty and Mr. Shayak Ranjan Ganguly are appearing for the respondents number 125. They're both in some personal difficulty today, Your Lordship. I humbly
I'll
pray
tell
for
you,
not
Lordship, on the
delay.
last occasion, your Lordship had directed service on the Archaeological Survey of India, the respond numbers 225, which I have done again. On the last occasion, Mr. Chakraborty had appeared, and had made submission that he's appearing for the union, but he has still not got instructions whether he's appearing for Archaeological Survey of India or not.
Your Lordship, he will be appearing for the respondents number 125, the archaeological survey as well.
Your Lordship's order, if your Lordship kindly takes your Lordship's last order.
Yes.
Your Lordship will find order. made clear that in spite of receipt of notice and respondent numbers to fail to appear before this court, the matter will be taken up for hearing in absence of the respondent numbers.
So you are appearing?
Your Lordship, Mr. Srijit Chakraborty and Shaikran Junagli, they're appearing. They're both in some difficulty today, Your Lordship. I'm just
Sir.
praying for not today.
Both are having difficulty.
Yes, Your Lordship, I.
But tomorrow may I come back, my lord?
As per the submission made by the counsel for the respondents, case adjourned, let the matter appear tomorrow. Next.
Grateful.
This is a matter, my lord, for the grant of license and registration to run a homestay. But I had applied under the rules, my lord, West Bengal Tourism Policy Guidelines. Then, my lord, now I receive a communication, my lord, I filed that by way of a supplementary affidavit.
I have not received any copy. Your Lordship, though the direction was there.
Corporation down? Yes, it was given, my lord. But I'll tell you, Lordship, my lord, first I was running a paying guest. My trade license was cancelled.
Your Lordship, I do not. Your Lordship, I am so sorry to intervene like this, and I'm so sorry. Your Lordship, if I may take the liberty to make one submission, Your Lordship, in this matter. Your Lordship, I am appearing on behalf of an intervener. I am not a party in this application. I am one of the director of the petitioner number 1. Before any submission is made, I'm one of the director, Your Lordship.
Yes, sir.
I'm one of the director of the petitioner number 1, and Your Lordship, I am seeking liberty to file intervention application. I am making this submission, Your Lordship, that if the copy of the writ petition can be supplied to me, can be served it to me, I can finalize my intervention application and I can file it, Your Lordship. I am one of the
I
directors,
shall give,
Your
but
Lordship.
kindly see, my lord, what is the matter about, my lord? Why, my lord, this hue and cry? My lord, this property belongs to a company which is a family company. There are family members are directors and shareholders. We are residing, the family members are residing in this property itself. There are 2 blocks, my lord. Now, my lord, I was using a portion of it as a paying guest. An objection was given by one of the quarters. Corporation cancelled the trade license, saying that paying guest can only be run from a commercial property. So that license is gone. So I applied to run a homestay under the guidelines, tourism guidelines. And from the central government, I have already got the registration. I have now to get it from the state government. I have been running from state government, one department to another. Ultimately, I come to learn that corporation will grant it. So, my lord, I have applied under this policy. Now, they just give me a communication that a company cannot apply. Where is, my lord, I asked for myself the question, my lord, when there is no bar on the company. Company is the owner. There is no, if the company is the owner and the property is being used for residential, if your lordship sees the guidelines once, but I have annexed, my lord, the guidelines here. The homestay guideline, my lord, your lordship will see, page 19. Kindly see paragraph 4, homestay. Place where owner of establishment or his or her family member is physically residing in the same establishment, letting out minimum 1 room and maximum 6 rooms with such and such exclusively for tourists. Then kindly see, eligible applicants need to meet the following criteria for the purpose of registration of homestay. Owner or promoter of the homestay should also be the owner of the homestay. That is it. So there is no prohibition that a company cannot be an owner. Company is the owner. Company has applied for homestay registration. Minimum floor area such and such. Then can you see paragraph 5? Homestay owner meeting the above eligibility and meeting the required criteria mentioned in the checklist of facilities may submit an application for registration through online. That is what I have done. But I cannot it is not, the portal is not opening, I cannot make the payment. This was where I was stuck. Then, my lord, a series of, I applied under the Right to Information Act. Kindly see, my lord, the replies which have come. Kindly take my supplementary affidavit.
I have no copy, my lord. This matter is actually taken up out of turn on the last occasion.
No,
when
the
I have
person was
said
present.
for appearing before your lordship on the last occasion. Order was passed. The
Very well,
I can understand. Only the preliminary issue for actually maintaining the supplementary repeat on the fact, my lord, this writ petition is basically moved before your lordship for the inaction of the KMC. Now KMC passed an order which is brought before your lordship by way of a supplementary
Yes,
affidavit.
yes.
So the cause of action, if your lordship kindly see, if that is there,
What
my
is the
lord, your lordship
prayer?
hear the matter.
Well, my learned friend cannot be so technical. I am applied for the registration. I am applied for the license. Nothing has been done. I am entitled to say that, my lord, this cryptic order which has been passed is not in accordance with the provisions of the guidelines. And not only that, my lord, here, my lord, this is also a policy issue. They are not saying registration and license is different. For my, I have asked a specific query, under what authority I will apply for license. Kindly see my query. Kindly see page 8. The information sought and the reply they have given. This is coming from Kolkata Municipal Corporation Tourism Cell. First query is, what are the specific license and permission required from the Kolkata Municipal Corporation License Department for operating a homestay in a residential house? Reply: homestay in a residential house is permitted under homestay tourism policy, which is available in the web portal. That is that guideline which I have shown your lordship. You are requested to refer to the homestay tourism policy for detail. I have done that accordingly. Next one is trade license, certificate of enlistment mandatory to run a homestay business from a residential property in Kolkata. You are requested to refer to homestay tourism policy. Again, then can you see, if a trade license is required for running a homestay, which trade category or classification should a homestay owner opt for? Alternatively, it is not required, then what shall be the procedure for running a homestay? Please clarify. Reply has been given by SPIO license dated 19 September. Kindly come to 19 September, that is at page 7.
Page number 10.
Page 7, 19 September. Supplementary manual, just the previous page.
Yes.
Kindly see reply to query number 3, second paragraph. As of now, there is no such trade nature exclusively entitled as homestay in the schedule of rates, fees, charges of license department. However, information paragraph second part does not come on. So, where will I go? I have applied for registration under your tourism policy. That says an owner or promoter of the homestay is entitled to apply. The company is applying. You are saying company cannot apply. That is for registration. For license,
So your request has been rejected?
Yes, my lord. Kindly see that their document at page 10. Kindly see page 10. Cancellation for registration of homestay. This is not license. Under West Bengal Homestay Tourism Policy, owner or promoter of the homestay should also be owner of the homestay which is functioning or proposed to function. Checklist of facility has been stipulated that established or family should physically reside. That is what is happening.
No, the property in which you want the homestay permission,
yes,
that is in the name of the company or individual?
Company.
In the name of the company.
And the company has applied through the directors.
Company consisting of how many directors?
Company are applying for the 4 directors. 7 directors.
7 directors. And who applied for? Only 1 director. Have you taken the resolution?
Board resolution is there.
Resolution taken by the...
Yes.
But she is appearing for honor.
Absolutely, your lordship, I do not want to intervene, your lordship, since my learned senior friend is arguing. But your lordship, this homestay is only on the premises of the petitioner company, your lordship. There has been no permission or authority given by any of the directors to run this homestay, and there has been, your lordship, letters which has been issued by the petitioner company itself saying that this homestay is unauthorized,
Well,
it
the
is
majority-
illegal. Since, your lordship, just one moment, your lordship, since in his personal name 3 trade licenses were cancelled, so now who is using the name of the company, your lordship, to apply this, your lordship? Your lordship, just allow me to file my intervention, your lordship, and I will bring on record all the documents and all the writ petitions which has been filed against them and the KMC, your lordship, which shows that all the trade licenses were cancelled, your lordship.
Yes. Kindly see whether the company acts to the board. There may be a disgruntled member of the board who may not be in tune with the majority decision.
No, but the problem is that, see, homestay is a one scheme.
Yes.
Homestay is a one scheme, and the scheme says that the owner has to apply for.
Yes.
Correct. You are one, and the owner means it is the company's name.
Yes.
If it is in the company name, company consisting of 7 directors.
Yes.
Company consisting of the company has to act in terms of the board resolution.
Yes, but I will produce the board resolution before them. But the ground on which they have said,
that is correct. No,
that is what I'm saying.
I am not.
I am not for a moment saying that they will not inquire into my application whether it fulfills it has taken the resolution. It is the company's decision. It is not individual decision. That inquiry, I am not saying that they cannot do. Let them do that inquiry. That they can take. But this reason is not correct. I cannot be like the ping pong ball going from the government tourism department to corporation, again from corporation to tourism. This is what is happening.
Okay. Yes.
And now they are not
The
even
only
saying
thing
that I require a license.
Yes.
My lord, reference has been made from actually my learned friend referring certain thing which
Give
is
the
supplementary.
See, I will also, madam, I will consider or I will allow you to be join as a party without application, no problem. But I subject to confirmation, I will set aside this order. I will remand the matter back to the authority, and the authority will consider the petition in accordance with the guidelines and giving an opportunity of hearing to all stakeholders.
Exactly.
And pass
Very
it to
well,
the
lordship. Just one issue, your lordship, which I can
you resolve
just carry.
whatever your
No,
objection, whatever the authority, let it because
No,
here
no,
is
your
a
lordship,
company.
I'll tell you. Your lordship, I'll
Or
tell you the main issue.
you produce the document that
We asked actually that my learned friend who is actually online. My lord, that particular question raised before them. That what is your authority regarding
That's why that is not
what
mentioned.
my lord, the company, there is a policy for what? That is a residential purpose. They reside there, but it's a name of a company, not in a person.
Correct. That's why I'm telling. The company. There are now stated that there are 7 directors. Company consisting of 7 directors. One of the directors applied for. Whether there is an objection or not, hearing or not, that's why I'm telling the competent authority, who is the chief manager and the nodal officer of the top, whatever it is, let he hear the person, all the persons, call for the objection, and if any objection, you decide it on merit.
That can be done.
That yes, madam.
Your lordship, just one submission, your lordship. All I'm saying is that this Abhishek Housing, who is the petitioner over here, who is the company on whose premises this homestay is being run illegally. So, your lordship, there's a very big difference, your lordship. There's a very one big. This homestay is not being run, or its revenue is not coming to the company. It is not being run by the company. It is being run by a private person, your lordship.
That disputed question cannot be decided by this court. That's why I'm telling that I cannot decide whether who is objecting, who is getting the income, and who is not getting the income. Let the authority, you file all the objection, all the contention before the authority. Authority will decide. Then if any rejection or whatever order, the parties will take appropriate decision.
An authority cannot go into inter-se shareholder dispute.
Let they decide.
That the authority must also be.
There are objection that the
they will have to file before appropriate forum.
Correct.
They have a dispute against the management of the company. That's a different thing. For that, corporation should not take their side.
What I'm saying is, your lordship,
fixing day after tomorrow. I am fixing day after tomorrow. Come with the instruction. If it's an otherwise, I will hear the matter on and pass.
Day after tomorrow, your lordship.
Cancel. Yes. So you take instruction day after tomorrow. You come.
Oblige, your lordship. Your lordship, if a one-pager application application can be, because there are some documents which I want to show your lordship.
I am telling on verbal, I will allow you to be as a respondent in the matter, no problem. Whatever the document, that's why sitting in the writ court, what's the disputed question? This court cannot. If you want to, then otherwise you want to. This court has to decide. Then you file an application. Then it will be decided. No
point, Malad. That is the issue.
So this court cannot
Day
decide.
after tomorrow, your lordship kindly take up the matter again.
Got enough. Counsel for the petition has argued the matter at length. So appearing and submit that she may be allowed to intervene in the matter. Full stop. And this court is of the view that you are appearing for whom?
Your lordship, I am appearing for Pratik Patodia, one of the director. Your lordship, I'll give the name. My colleague is standing there.
One of
She
the
will give the
director
name.
of the company intend to add a respondent. Let the matter appear on 11th December under the same heading.
Lordship, later direction be given to give a copy of the
Serve the copy. I'll serve copy. Without prejudice, I will serve the copy. The copy here.
Obliged, your lordship.
Yes.
Yes.
Lordship, before my
Yeah,
learned friend starts his case, may I make one submission? There is a report which has been filed by the employees under the Sexual Harassment Act, and that report is before your lordship. There are certain mistakes in lordship, typographical mistakes. Certain pages of the report are missing. If it would be your lordship's pleasure, I could hand over the report to my learned friend.
Where is the report?
Lordship, the report.
Page 52.
Lordship,
filed it?
I'm handing over the corrected report to my learned friend.
Milord, the report corrected, Milord, with deepest respect and humility to my learned senior friend, Milord. This is an allegation, Milord, of a manager, Milord, the lady, against, Milord, the sexual harassment of the HR head. Now, Milord, be that as it may, the inquiry, a pseudo inquiry was conducted by the ICC. It's a big private company, Milord, industry. Now, Milord, what happened, Milord? The propriety of the proceeding, Milord, was questioned before your lordship's court. Now, Milord, your lordship's court was kind enough to entertain the writ petition. Page 24 of your lordship's brief. If my lord takes pain, Milord, to take this, Milord, which categorically states your lordship need not take the trouble. Milord, page 24. Sorry, Milord, it starts from 25. Learned senior advocate representing the ICC submits upon instruction that one of the witnesses of the petitioner do not stay in Calcutta. The ICC shall permit virtual attendance for the purpose of obtaining the evidence from the witnesses proposed by the petitioner. In the event the witnesses do not appear, then necessary order will be passed by the ICC. The ICC shall endeavor to conclude the proceeding after recording evidence of the witnesses and hearing the parties in accordance with the law at the earliest. Earlier report of the ICC, which was filed in court, is set aside. The writ petition stands disposed of. Now, Milord, what happened? My learned esteemed senior friend, Milord, has drawn my lord's kind attention that the report which I am going to, Milord, place before your lordship at page 60, the conclusive part. Milord, this is the recommendation, Milord, based only, Milord, the perversity, Milord, the page 60. 60.
Yes.
Milord, the committee has read, perused, and discussed the statement made by the complainant, respondent number 1, respondent number 2, and their witnesses, and also the statement of witnesses of the internal complaint committee witnesses. On prima facie reading of the complaint, some element of sexual harassment cannot be eliminated. I am putting emphasis on this sentence, Milord. The allegations of staring, attempting to lean over the complainant by the respondent number such and such, spying, stalking, and such, and spreading false rumors by the respondent number 2 definitely appeared to be an act of harassment as defined under Act 19. So, Milord, this finding is clear. Then, the committee also find it is quite difficult to ignore the employment status between the complainant and the respondent number 1. The root cause of the differences and disagreements between the complainant and the respondent number 1 can be traced to the career competitiveness between the parties, the act of change in the reporting structure, appears to be the beginning of the surfacing the disputes and differences between the parties. The complainant had achieved success in her career. However, to remain on the top is undoubtedly an acute and vicious circle and sometimes over-domineering. The complainant pitched against the respondent number 1 and finding herself disadvantaged has succumbed to the Achilles heel of womanhood. The committee notices that though the complainant has used all the appropriate words defined in the Act to attract the offense of the sexual harassment and has attributed to herself all the consequences of a victim of such acts, she has failed to substantiate her complaint against the respondent number 1. In fact, not a single female colleague has come forward to support her allegation against the respondent number 1. Also, in the teeth of his having been asked to go on leave and having subsequently resigned from the company, on the contrary, all female employees who did appear before the committee spoke about the respondent number 1 in a positive genre. The acts pointed out by the complainant in support of her allegation, inviting sexual harassment are acts which can at best be defined as being examples of acute competitive nature at workplace. Certain undisputed facts that clear at committee are as follows. The respondent number 1 HOD was responsible for the analysis of quality recruitment and evaluating the performance and impact of new hires. The confusion surrounding the reporting structure of the complainant in absence of such and such having been directed to respondent number 1 was not out of the routine. However, after the complainant expressed her displeasure, it had been specifically acknowledged and addressed by the managing director. The convening of the review committee, meetings of all the departmental HOD was and remains an established system of administration. There was no intention or bad motivation to bring the complainant in the same room and or be a party to a meeting attended by the respondent number 1. The allegation of demanding personal favors in the manner of requesting the complaint to recruit the respondents candidates are found to be quite baseless in the given hierarchy of the company. The allegation of the respondent number 1 asking the complainant to indulge in creating fake bills to steal from the company is not substantiated by any proof, any act of the respondent number 1 indulging in such act itself. The complainant has also failed to substantiate her claim that her L&D expert on such and such was subject to being threatened by the respondent number 1. The committee finds that the respondent number 2 to be guilty of using his office and his main agents indulge in some vague pleasure of spreading wild and grapevine rumors about the complainant. This is perceived by the committee to be an offshoot to the grapevine rumors relating to the case of such and such. In fact, the statement of Mr. Such and such complainant's witness reflects the respondent number 1's sense of dignity when rebuking said such and such for using complainant's room for drying his shirt. The statement of such and such points a finger at the respondent number 2. He admits that the respondent number 2 had asked him to spy and take pictures of the complainant. None of the complainant witnesses nor the witnesses of the respondent number 2 have claimed any nexus between respondent number 1 and the respondent number 2. The cases of the complainant that she has been traumatized and feels threatened and insecure in the unhealthy work environment around her can be traced in the presence of respondent number 2 within the workplace. However, such allegations against the respondent number 2 have been found to be quite unfair and completely devoid of any substance. The allegation against the respondent number 2 appears to be quite convincing. The statement of his own employees, such and such, proved that he was misusing office directly against the complainant by asking them to pry into her office for reasons best known to him. This committee thus holds that respondent number 2 and his men under the instruction of the respondent number 2 were acting in a manner that attracted unhealthy environment in the organization. The respondent number 2 was somehow engaged in targeting the office of the complainant because of the previous complaint. He was unable to disassociate himself from the thrill of such allegation. Hence, he started targeting the complainant and a witness, Mr. Such and such. The statement of the respondent number 2 does not indicate any nexus with the respondent number 1. In the light of observation, the committee concludes as follows. Such the complaint of sexual harassment against the respondent number 2 has been found to be not proved. 1. The respondent number 1 in his keen competitive quest at a workplace has subjected the complainant to acts of harassment which do not constitute within itself elements of sexual harassment. However, they are not matters conclusive to an unhealthy work of environment. Respondent number 2, as a service provider on a contract, has however stopped his limitation and has indulged in actions which are definitely unhealthy in any organization. His act of setting his contract employee to spy into the personal space of the complainant and Mr. Such and Such under the garb of having received instruction from the management is most unacceptable and points a finger to his own unhealthy attitude towards women colleagues. On perusal of the complaint, it appears that the competitive relatable person of the respondent number 1 has made her very shaky and uncomfortable. Being a woman, she has over-imagined this overtly act of keen competitiveness and relegates the effect of the same into the domain of sexual harassment. Recommendation: the management is recommended to take appropriate steps against respondent number 1 to ensure some proper counseling to address the spirit of keen competitiveness. Kindly note this, Millard. The management has already taken steps to terminate the contract such and such. Therefore, recommendation required at this stage against the respondent number 2. However, the management, if so inclined, refer the matter to the local police station if so advised. The management is recommended to counseling the complainant and make her aware of consequences of not being able to distinguish between aggressive competitiveness and the responsibility of and the role of women at workplace, especially when holding posts with high responsibility. The conduct of such and such at the ICC meeting and also with the ICC members during office hours remains most undesirable and aggressive. He lacks the sense of cooperation with the basic principles and object of the act of such and such. The company may take appropriate action against him as per service rule. The professional image of the respondent number 1 has been seriously compromised due to the nature of the complaint filed against him. The committee recommends the company to take appropriate steps for damage control. Management is recommended to ensure regular awareness program with the employees to educate them in the matter relating to sexual harassment. Now, Millard, my learned senior friend with her usual fairness has submitted, Millard, the recommendation that has been given to us, Millard, and relied on by my client in this proceeding, Millard. It contains certain defects and suffers from certain lagunas. Millard, if my learned senior friend's client's instruction, Millard, goes to the extent that the contents
No, the contents are not being changed, Your Lordship. Only I tell Your Lordship, certain pages, Your Lordship will come to page 65.
Yes.
Lordship will kindly see during the process, Your Lordship, the presiding officer had changed. So the name of the presiding officer is here on page 65, but she was her signature has not gone down because she was appearing online for all the other meetings. For the final meeting, she had come. So though she had put in her signature, this page has not come in. This is one mistake. Your Lordship will come to page 127. I will not be changing anything else, Your Lordship. Lordship will come to page 127. There is an email attached to page 127, Your Lordship, which is incomplete. Page 127, it is an incomplete document, Your Lordship. Then Your Lordship will come to page 136. Similarly, Your Lordship, page 136 is also incomplete. The email which is attached last but 3 lines, sent on 16 November 2024, this email is missing.
Which page 136?
Page 136. This email is missing, Your Lordship. And Your Lordship would kindly, I'm sorry, Your Lordship will kindly come back to page 58. Page 58, Your Lordship. This is page 29, internal page 29. And then Your Lordship will see internal page 30. This is internal page 24. And then Your Lordship, it is internal page 30. So these 4 pages are missing.
No, it is 29.
Lordship, this is 24, Your Lordship.
No, 24.
Oh, 29.
29.
Lordship, sorry.
29.
Lordship will give me a second. Page 20, Your Lordship. 21, then 22, 24.
25 is missing.
Lordship, 24, 25 is missing. I'm sorry, Your Lordship.
20.
Lordship will come to page 54, which is internal page 23.
Yes, 23.
And then page 55, which is internal page 26. So these 2 pages are missing. This is the only rectification. Lordship, nothing else will be rectified. So that is why I would
But if
just
the email is incomplete, then I need to look into it.
Lordship, it is his email.
is my email.
It is his
Even if
email.
the record must be, my lord, in order, my lord.
You
This
don't
High Court is a court of.
You come with a supplementary affidavit, supply the copy, let it.
Lordship, I can supply the copy here and now if it falls from
By
your
way of
lordship.
supplementary, you come, you have to give some reason why it has happened.
Lordship, these are.
There is a very big lacuna.
I totally bow down to that.
My
Your
lord,
lordship.
kindly see, my lord.
I cannot
no.
rectify the.
No, my lord, because the observation, my lord, it runs
But-
contrary to the logic, my lord, for the simple reason. If a woman, my lord, in the competitive market, if a man is myopic, blinded by myopic profit hunger, or if a man, my lord, he wants to rise, question is, my lord, what kind of relation, my lord, a man of ordinary prudence will come such, my lord, this kind of decision that it is relatable to the sexual harassment. Number one. Number two, my lord, under the scheme of the Act 2013, it is the duty of the employer, my lord, to ensure a healthy environment, my lord, in the office. My lord, the observation is page 58, the 60, my lord, which I have read, the first two paragraphs, my lord, and my lord, the findings, it is a specific findings. Now, my lord, the other paragraphs, well, coming to a conclusion, my lord, this is absolutely, my lord, inconsequent of reasoning, and the behavior of the, my lord, the committee is also inscrutable. Because for the simple reason, my lord, I tell your lordship, my lord, if your lordship kindly sees that after this observation, it is a clear finding. It is not an, my lord, esoteric philosophical debate, my lord, which a common man, my lord, cannot fathom. My lord, kindly sees, my lord, the committee after has read, perused, such and such, and their witnesses of the internal committee, prima facie reading of the complaint of some element of harassment cannot be eliminated. The allegations of starting such and such, the complaint by such and such, by the respondent number, spying, seeking such and such, respondent to directly appear to be an act. So this sentence, my lord, it conveys, my lord, a clear message. Then, my lord, the finding, my lord, it is disconnected when, my lord, the person concerned, the committee has come to a decision. My lord, today it would be a very painful event for me to my lord, request your lordship, my lord, to hear further for 30 minutes. If your lordship, my lord, allows me, since my learned senior friend is going to hand over, my lord, I would love to address your lordship on this point. It is a question of a dignity of a woman, my lord, and that has, my lord, been violated with impunity. If I can demonstrate your lordship, my lord, from this journey, my lord.
What is the prayer? What is the
Lordship, there are two respondents. My learned friend.
prayer? What is the prayer in the writ petition?
My lord, the prayer, my lord, may I take, my lord? That is at page, my lord. Sorry, my lord, for being late.
Page 20.
Page 22. It starts from 20, my lord.
Where? Page 20.
It starts from page 20. A writ of around the nature of mandamus to issue, commanding the respondent, particularly such and such, to forthwith withdraw, cancel, or rescind the impugned report of the ICC. My lord, the interim injunction, my lord, restraining the respondents from taking any action against the petitioner by giving effect or further effect to the impugned proceeding of the internal complaint committee constituted by the respondent number 1 to 5. Then, my lord, certain benefits, my lord.
You are appearing for whom? You are appearing for the complainant.
I am for the complainant. I am the petitioner hearing. Now, my lord, I am aggrieved by the findings and the reason. The findings and reasoning, my lord, there must be a logical, my lord, coherence. It must complete its logical journey, my lord, at the end of the day. Let my learned senior friend, my lord, supply me and permit me to address your lordship on Thursday, my lord, if subject to condition.
I will. Lordship, there is no interim order prayed for. Lordship will kindly see.
It's a prayer.
Yes. Restraining the respondent from taking any action against the petitioner. There is no action against the petitioner which is proposed. Only counseling. If they don't want that counseling, that's all right. That's the only action proposed against the petitioner.
So, my lord, I will address.
Lordship, there are two respondents, respondent 1 and respondent 2. Against the respondent number 2, specific finding.
She is the complainant.
She is the complainant.
See, you during the inquiry, evidence recorded, witness examined, correct?
Lordship.
And subsequently, the committee has passed the order. Once the committee is intending to pass the order, holding that the complainant is having some lacuna, whatever it may be, I can't say. Have she been given an opportunity?
Lordship, there are two respondents. There are two respondents. There are respondent 1, respondent 2.
Correct.
Against the respondent one,
Against these two persons, she has made a complaint. Committee
Lordship, the committee
constituted.
has come to a conclusion where respondent one is concerned that they are both
I am
holding.
not on that with regard to 1 and
Yes.
2. I am only regard to, because this is the
Lordship,
complainant.
they have to be. I am not going to stand in
Now
their way.
you in the committee stated that counseling is also to be required to the complainant. Correct. So this is the adversary effect upon the complainant. If you are going to pass an order against the complainant, then opportunity is to be given for hearing. See, on conclusion of the inquiry, this has been happened. What is your say?
Lordship.
What is that? You consider that and come on that.
Yes. Thursday, my lord.
Lordship, I'll come back on Thursday.
Deeply
You say
obliged.
what are the
And in the
documents?
meantime,
You give that.
Yes,
You will consider.
I'm handing over the
I'm
frame.
extremely grateful.
Lordship, let it be recorded.
The counsel for the petitioner has argued the matter at length. Full stop. You are appearing for all respondents.
Lordship.
Counsel for the respondent submit that there are certain documents.
May it retain its the position, my lord, item number 5 today.
There are some documents which is to be incorporated in
Thursday,
the impugn
Saturday.
order. In the impugn order. And as such, she prays for leave to allow the respondents to incorporate the said document. Full stop. This court is of the view before passing any order for incorporation of the any document, the copy of the document is to be supplied to the petitioner. Then at counsel for the respondent to supply the document to the petitioner. You have supplied?
Yes, yes, that's
supplied to the petitioner.
I'm deeply obliged.
Let the
Lordship,
matter-
may I hand over the honorable
let the
court
matter
order?
appear. No, you keep it with you on, come on.
I'll come back.
Let the matter appear on 11th of December under the same heading.
I'm extremely grateful.
I'm grateful.
Okay, Raj.